Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm your host, Napasa, and I'm really happy that you have joined us. Before we start off with today's webinar, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks, thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and also on X. So, please feel free to join the discussion by commenting. And absolutely, today we are going to discuss on what can H1B applicants expect in 2025. A lot of things are on our mind, and it's a very, very interesting topic and essential as well because I am sure employers and professionals are very much concerned about what to expect this year. So, if you are preparing for the H1B process or are curious about the trends, shaping the US immigration policies, I don't think you would want to miss this session. So, please stay with us. And yes, you can also join us by dialing this number on the screen, and the number is 425-436-6335, and the access code is 988-888. It's a very good opportunity for you because we are going to be joined by our very, very important guest today, and she's none other than Attorney Prashanthi Reddy. So it's really great to have you, Prashanthi. Thank you so much for joining us today. How are you doing?
Hi, Nipasa. Good to be back after the break. And we have a lot more exciting news for this year. So, yeah, it's great to be back.
For sure, for sure. I hope you had a great vacation time, holiday time, and here's wishing that this year, 2025, is going to be a great one for you and your team.
Thank you. Thank you very much. And a happy new year to you and to everyone that is online as well.
Yes, I think this is our first webinar this year, so let's go with it. What can people out there who have joined us expect from today's session?
I guess we're discussing about what to expect. What is the future of really of H1Bs under the Trump administration? The reason we chose this topic is because there's a lot of news
Yeah,
on the GOP, and it seems to be an important. It has become suddenly an important point of discussion internally among the GOP, with two warring sides. Elon Musk on one side talking about H1Bs, Trump saying something, and then on the other side the more conservative think tank of Trump talking about restricting H1Bs. So it's been in the news a lot. So it would, we thought it'd be a great point for discussion.
absolutely, Prashanti. Especially with so many updates, policy changes, and administration change, everything is going to affect this. And we already had a session earlier before we ended the year about the new updates that are coming up this year. So I think this is going to be a great one. So thank you so much for joining. And I already see Rag has joined us. Rag, a very happy new year to you too. I hope this year will be great for you. And yes, please feel free to comment more if you have any questions on the topic. So let's go right in. I have this first question, Prashanthi, and it is what does the shift to a merit-based H1B process really mean for applicants? And is it going to get harder from people, especially from the non-tech fields, to get selected under H1B?
Yeah, I think so, because basically the H1B merit based is based on, it's based on merit. So they're not going to be talking about the traditional H1B process whereby everyone is invited as long as they, fulfill the requirements of the H1, which is basically you have to have a job in a specialty occupation. So if they are going to be removing that criteria and removing the H1 completely and putting a merit-based criteria, or changing the definition of who qualifies for a H1 and making it more merit-based by modifying it somewhat. Um, I think either way, it'll be a challenge to change it drastically, but let's presume they do. What does that mean? So the key aspects of a merit-based system would be that there'd be a point-based criteria. So merit-based system may prioritize applicants based on factors like education, skill, work experience, salary, maybe advanced degrees or specialized skills. So I think salary would definitely be a higher factor. So if you're getting a higher salary, you're more likely to get an approval under that system. Or it could be that only people who have a level 3 or level 4 wage salary would get an approval under H1 based system, and not the level 1 and level 2 would be removed completely. And we've seen that in the past where the Trump administration has tried to change the prevailing wage to make it higher to match level 3 and level 4. So employers offering higher wages may receive priority for their applications, and this could be a definite disadvantage for entry level positions or lower paying industries. Uh, so it would be more demand driven in the sense that preference might be given to applicants in high demand fields like tech, healthcare, STEM related role, based on what the labor market needs are at that time. This could obviously impact non-technical fields, reducing opportunities for fields in education, in the arts and social sciences, humanities, and these fields also have a lower salary and fewer specialized skills. So they wouldn't be prioritized as much as maybe the tech industry and the health industry. But within the tech industry also, you will see that there will be a focus on higher paying jobs. So unless there's specific provisions that balance out across all the industries, I think non-tech may find it harder to compete. But let's wait and see. We're just talking about purely speculative. If
Yeah,
it would be based completely on merit based, then what would happen? As I said,
exactly.
emphasis, on STEM fields. Historically, also tech roles dominate the H1B program. Most of the H1B numbers are taken up by, in the tech people are working in the tech field. Um, so a merit-based approach could amplify this, further, marginalizing the non-STEM applicants. Also, as I said, recent graduates, applicants with less experience might face more competition, especially in fields without a clear pathway to high salaries or advanced qualifications. So it depends on what the final outcome is and what it looks like if they're going towards a merit-based system. How will they do this? How will they equalize non-tech and tech fields? Will they even bother to do that? Will they only
Yes.
go based on high salaries in and not based on industry? We don't know. So all these uh, are open for speculation. Uh, but I think in general, non-tech applicants will find it maybe higher because their salaries are lower than tech industries salaries. So let's see. Any the tips for people who might get marginalized under this merit-based system? I would say they should focus on advanced degrees, um, showcase their niche skills if they have any, um, partner with employers, I guess, seek out employers who will be under that high demand industry. Uh, so these are a few things that can be done. Pursuing an advanced degree, so let's hope that it doesn't come to that. And even if they have some kind of a merit-based system, that it's a common sense based system and it does not marginalize anyone. So let's hope for the best.
Yes.
Only time will tell.
So true, Prashanthi. And I mean, it's almost 30 years that you have been practicing immigration law, and imagine like no more lottery system for H1B. It's going to be so different, and I can only imagine. So we'll just have to wait and watch. But folks
Right.
out there, be prepared, and why not? I mean, you should always showcase. your best side. And now the competition is not just the world but also you to be the best at what you are doing so that you could be selected. So I think that's a good thing also. Right, Prashanthi?
Yeah, we should also keep in mind that all this is speculation and it's harder done than said, right?
Yes.
So, in order for him to make these drastic changes, I don't think he'll be able to do it just through regulation because that regulation will be then challenged in court because that's not what the Immigration and Nationality Act says, and he has to follow the law. So he might have to go through some kind of get congressional approval to make drastic changes, but he can definitely make changes through regulation, and that itself can have a big impact on the H1B process without him having to, do more drastic changes such as, changing it completely to a merit-based system. But he can implement some elements of the merit-based system and put it into the H1B program by just increasing the prevailing wage. Basically, what he's saying is only high salaried people are welcomed on the H1B program and not entry level. And that itself is kind of tuning towards a merit based system. And he can do that very easily. But of course, that also can be challenged in court. But let's wait and watch.
Yes, let's do that. Well, K. Vishwanathan is saying hello to both of us and hope we can post questions later. Yes, you can. Please do post. And you can also join us to ask your question, by dialing the number on the screen. And the access code is also given. So just join in, even through a call. Rag, it's been a real long time, that you've been commenting. And why not join us on call today? So yes, we would love to know you. Let's go on to our next. Prashanthi, that I mean, there's a talk about stricter checks on employers who sponsor H-1B visas. So, what should both employers and employees do to stay safe? Play a safe game out there.
Right. Even as per the present, the H1B regulations that are going to take effect very soon, even as per those new H1B regulations, they've made, compliance into a big issue. And they're saying now FDNS visits. FDNS visits are basically audits done by FDNS officers after the approval of the H1 to make sure that the person is, the employer and the employee are following the H1B rules or the LCA, what was said on the LCA. And they've made that compulsory. Before it was FDNS visits, you could allow the officer into your office or you could refuse to allow them. Of course, that could lead to a denial, but now they've made it mandatory. So if you do not allow the FDNS officer to do his job via an audit, then they can deny your case simply based on the fact of non-compliance. So they've done that. They've also, um, you know, uh, kind of streamlined the H1B process, defined specialty occupation in a better way so that there's no room for ambiguity. They could still be, but they've tried to kind of define things more and make them streamlined. So in order to make ensure that you can pass any audit or you can pass the stricter checks on employers sponsoring the H1B, if you're an employer, then you should make sure you maintain your accurate records, keep detailed documentation of the job, the salary, the qualifications. Make sure you maintain your public access file with all that information in there. Comply with the wage laws, ensure that your wage meets or exceeds the prevailing wage. In case there's an audit, that will be questioned as well. Of course, at any point of time, no matter which administration is in power, you have to avoid misrepresentation, be transparent about the nature of the job, and avoid inflating the job title or massaging the job responsibilities to make them, more attuned to H1B. Uh, Sometimes you may not be in a specialty occupation and you put in responsibilities that don't actually belong to the beneficiary in order to make it look more like a specialty occupation. Avoid doing that. But you can certainly explain your job more, to explain how complex it is or why you think a H1 bachelor's degree in a specific field is required, uh, as long as you don't make up stuff. So that's avoiding misrepresentation. Regularly conduct internal audits. Proactively review your compliance and visa requirements. Get in touch with your immigration attorney. They can help you with doing auditing your company as well for DOL compliance as well as USCIS compliance, making sure your public access files are in place, making sure everyone is being paid the prevailing wage, is working at the LCA location as per the LCA location. Your HR can easily do this as well. Make sure you're aware of what a public access file is, because a lot of you'll be surprised, but a lot of H1B employers don't know what that is. And that's the first thing that an officer would look at in an audit. Also ensure that you're paying your employees on time and you're not delaying payments more than is allowed by your state, by the DOL. Um, so these are some of the things that you can do to make sure that you're always in compliance.
Well, thank you so much. Thank you so much, Prashanthi, for taking that up and for the detailed explanation. And yes, we do have so many folks out there who have joined us. Please stay with us. We are going to take up your questions. K. Vishwanathan, Rajesh, Vikas, thank you so much for commenting. Rag as well. We are going to take your questions very, very soon. Rag says, wee hours here. Well, chat works better than calls. All right. Thank you so much. No worries, Rag. We are just looking forward. All right. So, moving on, Prashanthi, we hear new definition about specialty occupation. So, especially starting this year, do you think that some of these jobs will not qualify as specialty jobs, or maybe they will not even fall under H1B anymore?
It's possible, though. I mean, I understand that they have redefined, what in a certain to a certain extent, redefined what is a specialty occupation. Um, but the definition, I don't think. I mean, it depends on how you interpret it. But I don't think the definition is um, in any way more restrictive. At least that's not what it's meant to be. They have in fact said, with reference to redefining specialty occupation, they've said, um, basically that what they've said is that a bachelor's degree in many fields can be required as proof that it's a specialty occupation. It does not have to be one field, but they've said also that the fields have to be well defined, and they have to be related to the job. So if you're asking for a bachelor's degree in computer science, electronic engineering, math, physics, and that's the industry standard for your particular job. In the past, maybe USCIS would say that since it's various fields and they just would presume that it's disparate and different various fields and they're not related, and they would deny it. So now USCIS is saying, as per the new regulations, that it's fine if various fields are required, are common for your job, but you have to show how those different fields are related to your job. For example, if you're saying for a systems analyst that a bachelor's degree in math is required, you have to show how that math degree is related to the position of a systems analyst, and you have to go into the transcripts and see what is related in the math program that you did in the transcripts to your actual job. So that's what they're saying. They're asking you to be more specific, but they're allowing, um, they seem to be allowing different fields as long as the fields are related. So, but of course, under the Trump administration, we have to wait and see how that affects. Under the Trump administration, it's very possible that even though the intent was something under the present administration, the Trump administration can interpret that specialty occupation field much more narrowly and restrict H1Bs further, and just based on decisions say that, oh, okay, received, we've got this explanation from you, but we don't agree with it, so we're denying the case. We don't think physics is anyway or math is anyway related to, position of a systems analyst. So, it's all dependent on intent. What does the present administration intend to do? And they can make use of the regulations, and there's enough scope there to interpret them in many ways to further their intent. So if they want to narrow the H1Bs in general, they can narrow it by giving decisions that have a more narrow definition of what is a specialty occupation.
Prashant. Right, and they have. I think there are so many updates and new jobs coming up, especially with AI ruling over the world. I think there will be so much more additions as well. Apart from subtractions. So I think yes, Prashanthi, you can.
Yeah, I mean, also Nipasa, based on his previous stance on H1Bs, previously the Trump administration has often emphasized reducing what it views as misuse of the H1B program. Of course, this is
Right.
in their world, they think that the H1B program is being misused, and so they're trying to clamp down on it. So they've introduced policies that uh, make the eligibility criteria stricter, and so they, narrow the definition of specialty occupation, as I said. And based on, his previous executive order, Buy America, Hire America, aimed at prioritizing U.S. workers as opposed to, non-immigrants. He has increased restrictions, um, made stricter whatever jobs that they perceive as non-critical. They've made it difficult to get H1s through those, jobs. Enhanced audits. We talked already about the higher wage requirements. He's done that. Again, redefining specialty occupation. So he's done a lot of things in the past, which shows that he is strict on H1B. But we have to see whether he will balance out that and look at what is the demand for skilled workers in the tech and the AI industries and in robotics, and try to loosen up the requirements in those areas. If he's influenced more by Elon Musk, he might do that. Um, so let's see. We have to just wait and watch what happens.
Yes, there's still say about a dozen more days, and Trump is going to hit the office. I'm sure folks are all looking out for the 20th of January. So yes, and also we hear that the per country cap for green cards has been a hot topic, and they're going to remove the per country cap. So if this happens, how do you think it's going to impact the backlog, especially for Indian applicants out there?
Well, it hasn't been in the news as much as the H1B program has been in the news. Per country caps, yes, Elon Musk has talked about it. Uh, and some other people in his administration have talked about it as well. Um, and he has said, in some meetings that, he wants to make sure that students, don't have to leave, etc., etc.
Yeah.
Um, so we don't know what will happen. We have to wait and see again. Per country caps for green cards. It'll be great if it's removed. What is the impact? I mean, a lot more people will get green cards, right? People who've been here for 20 years and been struggling to maintain their status on a H1B visa will get the benefit of it um, by getting a green card, and they will have more flexibility in their job. They will not be stuck with one employer. They will be able to open up their own businesses because a lot of these people are highly skilled, and they have, gained those skills by working in the US for so many years. So
Mhm.
to let go of that kind of talent would be just foolishness, I think, because these are potential entrepreneurs, potential leaders, people who will create jobs for sure. Because companies, even if they're working as employees, companies who hire such people will again hire more people because they're business will expand. And also, these people could be entrepreneurs themselves and open up businesses just like Elon Musk did. He was on a H1B program. And if he had these restrictions, then we wouldn't have had Tesla and SpaceX, right?
Yes.
So that is the potential that we're talking about with reference to the green card numbers, opening up the green card numbers.
Right, right. Yes, Prashanthi, thank you so much. And you already spoke about, Trump's past stance, on H1B. And of course, we all hear that he's going to make immigration policies even stricter and tougher. So, yes, I think there is a need for skilled workers also. So, maybe if you could tell us what do you think on this also, even though industries like tech and AI are in need of skilled workers.
Are you saying what is the impact for skilled workers?
Yes, I mean, looking at Trump's previous stance, when he was on rule, and now Trump 2.0 coming in, do you think that his policies are going to get stricter and tougher?
Yeah, on the whole, I think passed on based on his previous government, what they did. Uh, just going through that, there was a focus on Buy America, Hire America, and based on that focus, the number of denials went up by 30%. Now it's point something percent. The number of RFEs went up by 60%. Now it's some 3% or 4%. Um, and there were increased restrictions, audits, visas were getting denied. He, in fact, completely stopped any visas based, he said based on COVID, but he stopped people from coming into the country completely using some old archaic rules, laws that were in place. So Title 42. So we don't know if he intends to do that again. There was a Muslim ban. People from 7 Muslim countries were completely stopped from entering into the US. All these affected the H1B program. He wanted to introduce higher wage thresholds, and the DOL, in fact, published a regulation for those higher wages, but luckily it didn't go through. But as per that higher wage law, which was struck down by the court for some technical reasons, if they do it right this time, the minimum wages, say for a software professional, would be 200K plus, and that would pretty much wipe out 70% of the people that are eligible to file, or more, 80% maybe, to file for a H1, because there are not many people receive a wage of 200K plus uh, in the in the IT space.
Right,
So
right.
that can, severely curtail the H1B program. I don't know whether he intends to do that again or not. Um we have to wait and see, because they are, as I said, different thoughts right now. There is one group that is for a limited H1B program and one group that is completely against the H1B program.
Right.
But even Elon Musk is for uh, encouraging higher wage people and not so much entry level. So I think on the whole, IT consulting companies are going to be
Safe.
facing trouble. IT consulting companies are going to be in trouble because no one seems to be advocating for them. Um, so let's wait and see what happens.
All right. All right.
Again, a lot of it, um, even though they want to do it, they may not be able to. They can do it to a certain extent, but they may not be able to do a whole lot. It can be what happened in the previous administration, so we can expect that. That may be what they can do, because more than that, then they will have the courts will get involved. Then they might have to pass new laws, in which case they might need uh, majority in both the House and the Senate, which they have right now, but they might be not all Republicans may approve of those changes. So we have to wait and see. Everything is kind of up in the air.
So true, so true. So much is being said than really happening right now. I think we just have to wait and watch. But Prashanthi, I think now we should address some of our questions from the viewers. Let's not make them wait too long. So let's take up this first one from K. Vishwanathan. It's not about H1B. Let's see if you would like to take it. It's about L1 visa blanket. So he says, mine is still at a petition stage and working to close before the 17th of January as he chats now. His attorney has asked for additional cost if it gets filed after the 17th. Yes. What are the challenges and changes? He's asking.
In general, L1 blanket, if you're L1 blanket, I'm not sure why you're working with USCIS with an attorney, or maybe the L1 blanket is being filed at the consulate by the attorney. But either way, L1 blankets are usually easier to get approved than individual L1 applications. If you've submitted your documentation and you're likely to file, submit your case by January or earlier the better. You might not be affected too much by the changes because it takes time for these changes to happen. I don't think it'll happen on day one. But having said that, we are already seeing certain inquiries at the consulate level, certain denials that were not there before. We're seeing certain RFEs being sent by USCIS, which were not sent before. So even before Trump comes in, we are seeing USCIS is gearing to a more Trump-like USCIS already, because the change of administration is a few days away. So that we see that they're already becoming more restrictive, but definitely makes sense to file sooner rather than later.
Thank you so much for taking this up. K. Vishwanathan, I hope you're here. We're sorry for keeping you waiting too long, but I hope that you got your answer. And let's move on to our next one. This is from Indu. Hello, ma'am. My petition is still showing actively reviewing. When can I expect the result?
I'm actually not seeing any of the comments on the side panel for some reason, but if we can
Oh,
have that, that'll be great so I can read it. But so what is the question, Tipasa? And I'm not seeing any questions scrolling on the screen either.
you don't see it? Saying, hello, ma'am. My petition is still showing actively reviewing. When can I expect the result?
And now the video has frozen. Can you see me or?
Yes, we can see you.
Okay, well,
Oh,
let's just go with it then because my video is frozen from my side for some reason.
okay. But then we are perfectly very clear. I mean, there is no lag,
Okay,
nothing.
okay,
So,
okay. So let's just go with it then. So what is your question? Because I don't see the scrolling.
he says his petition is still showing actively reviewing. So he's asking when can he expect the result? This should be about his H1B status, I guess. Petition.
Actively reviewing,
Hi.
again, it depends on whether it's premium processing or whether it's regular processing. Premium processing, usually you'll get it very soon in a week or so. If it's regular processing, it can take 3 to 4 months. So I suggest that you convert to premium processing if you haven't done so. I know it's expensive, 2,000 plus dollars. But it's regular processing is taking about 3 to 4 months.
Okay. So, Indu, I hope you got your answer. And let's go on to our next question. This is from Rag. Rag has a question again about L2 and H4. Bundling with L1 and H1 is going away on the 18th of January. What does this mean for the first time L2 H4 applicants?
We don't know that the bundling of H4 is going away completely. Yes, it is set to, uh, as per the court decision, it is set to lapse, but it is possible that the present administration or the future administration could renew it. So again, that is up in the air. But if they don't, then we will look at again delayed processing times for H4 and H4 EAD. It could take, if they are processing it alone, even now we are seeing that it's taking 8 to 10 months to process. When during the Trump administration, we saw that the H4 and H4 EAD, though they could not or did not make any changes with reference to removing them, they delayed the processing time to such an extent that it became the benefit was completely nullified because it was taking 18 months or so for people to just get the H4 or H4 EAD, and nobody, especially if they're working, if it takes so long to get an EAD, then it nullifies the purpose, and then they cannot remain in their jobs. But now with EAD automatic extensions, that should help, even if there's a delay in processing, unless the Trump administration removes that EAD automatic extensions, then of course, then it would affect you negatively, and then you may not be able to remain on a H4 EAD because your job will not, nobody will keep the job open until you get the extension.
So true, so true. Thank you so much for taking this up, Prashanthi, for Rag. And folks out there, you can join us on call. I mean, this goes to everyone, Indu, RK, Rag, the Silence Files. You can join us on this number, 425-436-6335, and the access code is 988-888. And once you're in, just speak. We will be able to hear you. This goes out to also K. Vishwanathan and everyone else who have joined us today. So my next one, let's take this one. Train me, saying, "Hi, this is Kiran. I am an H1B holder. My I-94 is expiring on 12th of January due to my passport expiration. I have applied for my passport renewal, but I do not have a new passport yet. What should I do?"
So they're saying that the I-94 is expiring because why did they, if the I-94 is expiring, they can apply for an extension, right? But she's saying that the passport is expiring.
Yes, the I-94 is expiring on 12th Jan because of the passport expiration.
Ah, so what is the question?
So the question is, I have applied for my passport renewal, but I do not have a new passport yet. What should Kiran do?
So if you can file an extension of, I don't know on what status she is or he is, but they can file for renewal of their I-94. They have to before it expires. If they don't, then they have to leave the country, and they should be able to file without a passport, uh, and then there will be an RFE, and then it's possible maybe to submit the passport upon receiving the RFE, and then hopefully USCIS will adjudicate your case. Though USCIS might say that you don't meet the requirements as of the date of filing, if they follow that strict interpretation, then you're in trouble. But if they don't and accept your passport, uh, then it should be okay. So I would file for an extension either way, or leave the country and not allow your I-94 to lapse, whether you get your passport or not.
Okay. Thank you so much for taking this up, and I hope, Kiran, you got your answer. Now, well, the silence files, I think we should take the question up. He was saying, "Can you please pick my question?" Yes, we can. So, this is on your channel, Prashanthi. So, asking, I got 221G. Should I wait or look for transfer of H1B approved petition to new employer? And how to find new employer?
I can't help you with how to find new employer, but with reference to should I wait or not, that's up to you. But it really depends on what is the strength of the present H1B petition that you have. And it also depends on what they're asking for in the 221G, and whether the employer is willing to is able and willing to submit those documentation. Uh, if it is a legitimate case, and if they're able to submit the documentation, whatever is asked for, then I think there's no harm in waiting. Um, but if you have, that they are asking for something which your employer is not able to provide, or will not be able to provide in a satisfactory manner, then you should definitely look for a new case. So it's important to evaluate your case and then decide. But even if it's a good case, you should know that it will take some time maybe to process it. Once it goes into 221G, it could take 6 months, 1 year. So you have to be patient and willing to wait, and it's worth it. The wait is worth it if you think you have a good case. Otherwise, you might just be better off filing another H1B cap exempt petition, since you certainly qualify for that, at least based on the present rules.
Okay. Thank you so much for your question, the silence files, and I hope you're happy to get your answer. Thank you, Prashanthi. Well, K. Vishwanathan is back, just asking one question: is L2 work permit also being withheld?
No, an L2 is something that is automatic with an L1. You don't even have to file a work permit as per the new regulations. So unless they change the regulations and make you file a L2 application, that's what it is. And there is no talk about taking away the L2. There never has been. It's always been about H4 EAD, because L2 has always has been there for many years. Uh, and no one has talked about removing it.
Okay. Thank you, Prashanthi, for taking this up, and I hope you've got
And
your
I
answer.
think
Yeah.
L2 is also part of the regulation, part of the L1 regulation. So it'll be more difficult to take that away. But whereas the H4 EAD was done as an executive order, so therefore people talk about removing that because it's easier to do it.
Okay. Well, thank you. Thank you. He says he's listening and learning. Thank you so much for joining us, K. Vishwanathan. And stay with us. Maybe you could just stay up, learn more till the end. And also, now let's take up RK's question. How would the new requirements of the bona fide job offer work when filing a new H1B base of the new regulations? Also, what would be the impact on third party placement?
Right. So this is the bona fide job offer is part of the regulations. We were expecting this. This has always been something USCIS has asked for in the recent past, at least in the past 10 years. And only recently in 2020, because of the IT Serve versus Cessna decision, USCIS reserved the right to ask for bona fide employment, but did not really ask for in-client letters and purchase orders, etc. But now they have put it as part of they were waiting to put it as part of the regulation. Now that they have included it in the regulation, which can certainly be challenged in court, even though it's a regulation, but more difficult to challenge it. The bona fide job offer means that, especially in the scenario, like you said, third party placements, that is an IT consulting company scenario, it plays a big role, because in order to show that you have a job, you have to provide then the contracts and work orders that you have with your end client, because that's how third party placement works. That's how consulting companies work. They don't hire people directly, but they place them at third party sites. So they're asking for contracts, work orders, vendor letters, end client letters. They can ask for contracts between all the layers if there are 2 or 3 layers. So they can start asking for all that. And they can certainly restrict the duration of the H1 if they see that the contracts are not there for 3 years, or you're not able to show a bona fide job offer for 3 years. But they have said kind of in the regulation that they don't intend to do that, to restrict the H1B term to coincide with what's in the purchase order. But with the new administration coming in, they might do that as well. So you're looking at, you cannot file H1 speculatively anymore if you're an employer. You have to actually have a job available in order to file, which is challenging, especially for cap cases, for new cases, because you file the H1B cap cases 6 months in advance generally. And when you file that, you might have a job offer in place, but no client generally will wait for 6 months for you to get the person into the US because jobs usually fill up faster, and usually the requirement is immediate. So if they might close out the requirement if they don't get anyone, and maybe have someone offshore work for them, have their offshore company hire someone, and that's what we're talking about, right? By restricting the H1Bs, you are taking all the revenues offshore. So Costa Rica, Mexico, India, these countries definitely benefit, but the United States doesn't.
Yes, so true. Thank you so much, Prashanthi. And RK, thank you for your question. I hope you've got your answer. And now let's go on to Esther's question. Esther saying, I got selected in the H1B lottery 2024, filed my petition around May, got a response in August, but it was an RFE on my qualification. Basically, what they were saying in the RFE was that the job that she was applying for doesn't relate with her qualifications. And my attorney advised I add an expert opinion letter to the new petition and some other documents. What do you think are my chances? She even said that she filed the RFE in October 2024, but she did not get a response yet. So what should she do and what should she expect?
What are your chances? That really depends on what your qualifications were and whether they were related or not, whether you were able to make up a case, make a case that your qualifications are related. Maybe you put an experience. Maybe you get an expert opinion letter for a work experience evaluation, or maybe you showed that the degree was related by itself by comparing your subjects that you took with the job, like a table comparing the two, the job duties versus the subjects that you took. That's generally what is done in order to show that there's a relationship between the job and the degree. um, so it really depends on how strong your case was. It is, if it was a strong case, then you can expect an approval. But of course, there are anomalies always. Sometimes even when you do the right thing, and you show that you're qualified, um, USCIS can deny those cases. In which case, it might be a good case for appeal. Um, but I would say just you have to wait and see, because I don't know what are the details of your case, and even if I did know, I don't know if the USCIS officer will follow the general norm of who qualifies and who doesn't, because nowadays strange things are happening. So
Yes.
I guess you have to wait and watch. If you are if you want to get a response faster, I would suggest you convert to premium processing so that you'll get a response within a week. Remember, even if it gets denied, you have 30 days to file an appeal. And once you file the appeal, it is possible to then file for a change of status to a different status, or file a transfer or whatever, um, to a different status if your I-94 is expired. If your I-94 is not expired, then you're fine. You can just, if it gets denied, then status quo is maintained, your present status is maintained, and then you can figure out what you want to do, maybe file another H1B petition under the cap, but you are certainly will be subject to the cap again because your H1 was not approved.
Right, right. She says thanks, and she was also saying, do the USCIS also request for tax return from the employer?
They could, but depends on the circumstances. Usually they don't.
Okay. Okay. Thank you, Esther, for joining us with your questions, and I hope you've got your answer. We also have yeah, the silence files coming back with another
I
question.
like the name.
So, yeah, what's the name? I wonder. Yes, please tell us your real name. I mean, this
Or
promises to
what
use the
it
name,
means, what silence files means, what
the
it
silence file.
signifies.
Sounds so
Yeah,
mysterious, right?
very
But
mysterious.
yeah. So saying, my employer has not received any email till now from the consulate, and that is a small employer with an in house project only. The interview
Hmm.
was on the 3rd of January this year, I think. Yeah.
So that is not, I mean, hold your horses, be patient. January 3rd is not that long ago, right?
It's just
You're
5 days
expect
back.
you're expecting like, something, a response for 221G in 5 days. You have to be patient. But having said that, since it's a small employer, like you said, in-house, it doesn't seem to be a very strong case. But I wouldn't say that you have waited enough time to know that or not.
All right. Patience is virtue, and all the best. Just wait a little longer. I'm sure they will get back to you. And Muhammad Ali says, "Nice to see you here again. Nice to see you too. Thank you so much for joining us." We have some more questions from our end. I think we should take them up. Control, if you could display them, please. They'll be great. But before that, maybe we can also take Rajesh's question. Meanwhile, saying, "I've heard a lot about potential changes to the H1B lottery system. If the rules change again in 2025, like focusing on higher wages or prioritizing certain industries, how will they impact someone like me who is applying from a mid-level tech job?"
So if you get into level three, maybe you should be okay. But if not, there might be an issue. You have to wait and see. If you are level three, maybe you're okay. We don't know. Again, because there's nothing has been defined as yet, nothing, there's no clear understanding. We just have examples of what was given last time. The way the wages were structured, they said that even anyone below 200,000, again, it depends on which state you're in, but which county you're in. But they said that 200,000 was the average salary based on the new DOL prevailing wage calculations. So then you would know whether you're in or not based on the previous wage rule. We don't know whether it'll be the same wage rule that comes in. If it even if it comes in, whether it'll be upheld by the courts or not. Previously some decisions by Trump were upheld, others were not. The Supreme Court upheld the Muslim ban, right? Though the lower courts uh, said it was unconstitutional, but many other Trump rules were not upheld by the court, such as the wage law, the H4 EAD law. So we have to wait and see what happens, really. Hard to say,
Okay,
but looks like you might be affected if it comes to the wage rule based on, what the previous rule was.
okay, okay. Thank you so much, Prashanthi, for taking this up for Rajesh. Um, say,
Um,
K
can
is back.
you just give
Yeah.
me? I just need to plug in my computer. Can you give me a minute?
All right, sure.
Sure.
Sure thing. And meanwhile, folks out there, you can join us, on call as well. You can dial this number 425-436-6335, and the access code is 988-888. And once you're in, you will be able to speak with us. I mean, it's so great that you have joined us by commenting, but it'll be great to even hear you. So you might as well join us. And meanwhile,
I'm back.
folks, you can also contact our attorney, and you can have a call with her. You can even email her. Her number is 212-354-1010, and her email address is prashanthi at reddyesq.com. And also go visit www.reddyesq.com to get to know more about Prashanthi. And good to have you back, Prashanthi. Well, let's take up some questions from our Facebook and YouTube, if since we still have about a couple of minutes. So, control, if you could display, please.
By the way,
So, this
just to let you know, I
yeah.
can't see anything, so you'll have to read it out.
Okay, sure, Prashanthi. Saying, "Hi everyone. I've been job hunting for a few months, and with my visa nearing its end, I'm considering returning to India temporarily. I'd like to get your thoughts on the current hiring trends. I am on H1B visa with 3 years remaining. So I wouldn't need to go through the lottery process again. However, I'm curious, do employers tend to prefer local candidates over someone outside the US, even if the sponsorship process is relatively straightforward? And how easy or difficult is it to come back to the US if I leave without a job? He would like some, he or she would like some perspectives.
Right. I mean, it's a good question, and everybody's asking that question, especially with the number of layoffs in the tech industry recently. I get people at least one call a day uh, in the same subject. Um, so it's hard to say when you'll get your next job, right? But it is true that a lot of companies don't want to sponsor for a H1 because they're just not comfortable with the process. It is a process that may be straightforward, but involves paperwork and is a learning curve. So if you've never filed a H1 before for that employer, it seems like a lot of work. Uh, and there is also compliance issues. You have to pay the prevailing wage, you might get audited. So employers don't want to deal with all that. So employers who are used to it and who have done it might be willing to, but people who have not done it before might hesitate to. But the thing that you have in your favor maybe is that they may not find a US citizen or a person with a VEAD or a permanent resident uh, to fill that job. If they're not able to, then they are forced to then file a H1, which is the case in most instances where people, are first-time H1B filers, employers are first-time H1B filers. It's because they can't find anyone who's a US citizen, or it could be that they don't find a candidate that's good enough as you, that's as good as you, right? So they are willing to go through the process no matter what because you're the best candidate that they have. So that's a possibility. And what was the second part of the question?
The second part of the question was how easy or difficult is it to come back to the US if he
Yeah,
leaves without a job?
right. Then you have to find a job while you're outside the country, which is maybe difficult because most employers require you to go through an interview if
Right.
and maybe they're not comfortable with video interviews. If they are, then that's certainly a possibility, but they might want to do an in-person interview, in which case you're at a disadvantage. You could get a job with a consulting company because they don't care, but in order to get an end client or to be picked by an end client, again, they're looking for maybe in-person interviews. So if they're willing to do video interviews, again, they want you to be in the US. They don't want you to be taking the video call from India. That's also a restriction with some employers. So it depends really. Definitely your chances are less if you're outside the country versus if you're in the country. So you might want to consider filing a change of status to student status or visitor's visa status that will give you some time to recoup, maybe find another job, improve your skills, etc., etc.
Thank you, Prashanthi, for taking that up. Let's go on to our next quickly. I mean, if you still got a little time, some more time, Prashanthi.
Sure, maybe one or two more questions.
This one is saying, "Hi all, I'm switching from my current employer to new employer. Please let me know odd mandate if it's odd mandatory to take the I-140 approval document from the current employer. It's a consultancy, so I'm not sure if they will give."
Yes, you would need a copy of your I-140 approval. You don't need the original. You need the copy so that you can file for your H1 beyond 6 years because you have to, if you pass the 6 years period, because you need to submit a copy of your H1B, your I-140 approval when you're filing your H1 beyond 6 years. So definitely need a copy. You don't need the original.
Okay.
And you also need a copy of the I-140 to port your priority date in case you are leaving and another employer is filing your green card. Then you should port the priority date from your previous I-140, and for that also you need a copy.
All right.
It is
Thank you. Thank you.
having said that, it is sorry, it is possible to get, if your employer is not giving you a copy, it's possible to get um, uh, part of the I-140, not the exact approval, but enough for you to file. When you do a FOIA case, Freedom of Information Act, under the Freedom of Information Act, they do send you a stamped I-140 petition, which can act as an approval.
Well, that's very interesting. Thank you so much, Prashanthi. And maybe let's take up one last before we leave. And if you could tell us, please tell the possible outcome for a scenario like a mechanical engineering graduate with 10 plus years of experience in software development.
I think you qualify because you just need to get a work experience evaluation done since you have 10 plus years experience in the IT field. You have good experience letters. Get the evaluation done before you file the H1, but you should be good.
All right. Thank you so much, Prashanthi. I know there's so much more to talk about, but Shushant has joined us on YouTube asking, what about for EB3, all other countries? Well, I think we will touch up on EB3 in another episode, Shushant. But thank you so much for joining us. We have been discussing today about H1B and how does 2025 look ahead, for H1B applicants. So I'm sure there's so much more to speak about, right, Prashanthi? And we would like to come back maybe with this topic or more new topics on what to expect this year since it's the beginning of the year. So, Prashanthi, maybe before we leave, if you have any notes or tips for the audience out there who are really anxious to know, what's going to happen with their H1B this year.
Yeah, definitely it is. I understand why you're anxious, and we are all anxious as well for you. Uh, and the good thing is that you have the support that you need. Make sure you keep in touch with your attorney to so that you can get updates on what is happening, or if there is any situation that goes south, you can take their advice on how to proceed. So always keep abreast of the news, stay in touch with your attorney, make sure you get the proper advice. It may not affect a lot of people, but it'll affect some people. Um, and we have to just wait and watch. We can't react before we know what the process is or what is going to happen. There's no point in being anxious about what we don't know. The only thing we can do is be prepared rather than being anxious. So be prepared for uh, whatever there is to come. Have alternatives in place. Always have alternatives. So if one thing is not working out, you should be able to have an alternative that you can switch to, maybe an F1, maybe a H4 EAD. Um, you know, Maybe you go to Canada because it's not worth staying in the US anymore. uh, there are alternatives always. So keep alternatives in mind. Don't be anxious, just be prepared.
Thank you so much. I think that's a great tip to be more prepared than just being anxious. And here's wishing that 2025 is going to be great for all of us, employers, employees, professionals, and even attorneys. So thank you so much, folks, for joining us. And K. Vishwanathan says, thank you for answering with ease, Prashanthi. And my wife seems more comfortable to quit here if we succeed in this visa dream. Well, that's that's a good one, I think. So thank you so much for joining all of us, and just wishing all of you a wonderful day ahead. Thank you so much, Prashanthi, once again. And folks out there, you can also consult with attorney Prashanthi. Her number is 212-354-1010, and her email address is prashanthi@reddyesq.com, because that's where she will be able to get in touch with you better, know your case better. So yes, do get in touch with her. Thank you for joining once again, and have a great day ahead, everyone.
Thank you.
All right. So
Hello, everyone, and welcome to today's episode of Immigration and Jobs Talk Show. I'm your host, Sam, and I'm back again with a very exciting episode that is lined up for you today. So, before diving into topic and announcing the name of our guest, here's a very important disclaimer. That is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. All right, friends, once again, welcome back to Immigration and Jobs Talk Show. I'm your host, Sam. And today we are diving into a very important and timely discussion. And the topic is how can E2, L1, and EB5 visas open your path to US immigration through investment? So if you have ever considered starting a business or expanding your enterprise or making significant investments in the US, I think this is going to be a perfect opportunity to explore how the E2, L1 and EB5 visas can open doors to your American dream. And to help you in this, we are honored, to have one of the best attorneys. That is attorney Alessandro Giordano. Alessandro Giordano is a highly experienced immigration attorney licensed to practice in Florida, New Jersey, and New York. He has also dedicated his career solely to the practice of immigration law, helping individuals and businesses navigate the complexities of US immigration. So, Alessandro, first of all, a very warm welcome to Immigration and Jobs Talk Show for the very first time. And it's an honor to have a show with you, and we are really grateful that you are here with us. Thank you so much for joining us.
Of course, Sam. Thank you. Hello, everybody. The pleasure is all mine. I look forward to sharing this important information with you all.
Wow, that's lovely. So, Alessandro, why don't you go ahead and share something about you? Like, how did you started your immigration journey with our viewers who don't know much about you?
Sure. So, my name is Alessandro Giordano, and I am an immigration attorney. For the past 10 years, I have exclusively practiced immigration law. I am an immigrant myself, and having gone through the immigration system, so to say, I really found my vocation in helping others navigate as you said, the complexities of the immigration laws and the immigration journey. And this is why I almost exclusively practice immigration law.
Yeah, I think you were immigrant yourself, and that's why you decided to help, as you mentioned. So I think that was
That's
lovely, and that's why our viewers can connect with you more because you yourself is an immigrant. So I think that was a wonderful introduction, and now our viewers also got to know about you. So Alessandro, my question, before diving into today's session, I would like to know from your end that how are you seeing the US in the upcoming year under Trump's administration? Do you think there will be a new era for the US people or it's going to be a nightmare?
There will definitely be significant changes. I
Hmm.
practiced during the first administration of President Trump between 2016 and 2020. And I can tell you that things were different compared to the previous administration, the Obama administration, and the current administration, the Biden administration. So I definitely foresee changes. What I can tell you is it's something that all practitioners say, and I would say it's common knowledge that things will be hard for people who are in removal proceedings, people who are undocumented. But what I can tell you is that when it comes to employment-based and investment-based immigration, um, I have not seen or as many changes, I would say, during the past, the previous Trump administration. So while there will definitely be things will definitely be different for people in removal proceedings, family petitions, and many other things. Um, Hopefully we will not see as many changes for people who intend to invest in the United States or intend to immigrate through a lawful path, such as investment-based visa or employment-based visas.
All right. Okay. Thank you so much, Alessandro, for letting us know about it, how the future we might think and we might predict regarding these visas. So with that, here's my first question to you is regarding today's topic that how can E2, L1 and EB5 visas open your path to US immigration through investment? I mean, what do you think? What our viewers can expect from today's episode?
So these are three different options: E2, L1, and EB5 visas. Um, E2 and L1, the first distinction that I would make is that E2 and L1 visas are non immigrant visas, which means that they allow you to live and work in the United States temporarily, right? The EB5 is, on the other hand, an immigrant visa, so it will lead to once the requirements are met, to a grant of permanent residency. So these are three very good options for those who are seeking to live and work in the United States, either temporarily or for those who are seeking a settlement in the U.S. for a longer term, permanently.
All right. So, Alessandro, here's my another question with you. Like, this is a question that majorly most of the people, the investors,
Mhm.
they ask for. Like, which visa from E2, L1, or EB5 would you consider most suitable for an entrepreneur, and what are the key reasons for your recommendation?
That's a great question to begin with. So, as I mentioned, the first distinction to make is that the E2 and the L1 are non immigrant visas. So, they will allow you to live and work in the US temporarily, but do not directly lead to permanent residence. So, both E2 and L1 visas can be renewed. The E2 can actually be renewed indefinitely, so long as the business still qualifies for E2, for the E2, and the investor qualifies for E2 status. The L1 can be renewed for a maximum of 5 or 7 years, depending on the type of visa. On the other hand, the EB5 is an immigrant visa, so which leads to a grant of permanent residence, leads to a green card if the requirements are met. Now, that said, the most suitable option, the most suitable visa, depends on one's specific goals. So the E2 is a great option for entrepreneurs from 3D countries, and we will discuss also what that means, what 3D countries mean within the context of an E2 visa. No, it is a great option for those who want to establish or manage a business, grow a business um, by investing a substantial amount of money. And we will also discuss what a substantial amount of money is considered for E2 purposes. The L1 is the ideal option for those companies seeking to expand into the United States. And the EB5 is the option for those with the resources to make a significantly higher investment and who wish to obtain permanent residence, to live and work permanently in the United States.
All right. So thank you so much for letting us know about it and giving us a detailed explanation on this. Also, Alessandro, I want to let my viewers know about it that friends, we are live on YouTube, LinkedIn, Facebook, and Twitter as well. And it would be great if you could join us. It would be great if you could post your questions from any of these platforms that you are watching this session in. And we are here for an hour, so it would be great to take your questions up and we will definitely answer them. So, yeah, I think with that, as we already understood about the basic understanding of the E2, L1, and EB5 also. Here's another question that how does the E2 visa allow investors to manage their businesses in the US and eventually bring family members?
So that's what the E2 visa is designed for. So the E2 visa is designed to allow investors to come to the United States and direct and develop, so actively manage and grow their business in the US. Besides that, the E2 investor, can bring his or her spouse, and the spouse can apply for work authorization and pursue employment anywhere in the US. Doesn't have to work necessarily in the E2 company like the investor has to do. And then the investor can also bring children. Children are those, under 21. Children are under 21 that can attend school or college in the US. So I never stress this enough. The E2 visa is temporarily and must be renewed. But if the the business keeps meeting the eligibility requirements, it can be renewed indefinitely. So if the business remains operational and meets the requirements, it can be renewed, for indefinite period of time.
All right. So, also, Alessandro, here's a question that's coming in my mind, and that's a very basic one. Like, till now, we have been discussing regarding visas. But if
Mhm.
we specifically discuss about the business, then is there any business or is there any other options related to business that you would like to suggest to our viewers? Like, this business will be a good one, good idea in US to put an investment to it. Is there any business types or is there any recommendations to it that you would like to tell to our viewers about it?
I would say that, again, we have to look at this question within the context of each specific visa, right? Referring to E2s, there is a requirement that the business in which the E2 investor will invest has to be an active business. It cannot be you cannot obtain an E2 visa by making a passive investment. For example, I cannot invest money in the stock market and apply for an E visa based on that investment, or purchase real estate and rent it out as is. That's a passive investment. That's not going to work for an E2 visa. So definitely for an E2 visa, what we're looking for is an active investment. There has to be some sort of a entrepreneurial activity or commercial activity that supports the business.
All right. And would you like to say about the L1 and the EB5 as well?
The EB5, there are two ways to invest, quote unquote. There is one can apply for an EB5 by making a direct investment, so applies it, investing in a new enterprise, or investing through a government approved regional center. So somebody who wants to take a more, I would say, quote unquote, passive role within the investment and just invest the money without having to manage the business can apply through a regional center. These are the two ways that we're, the one can invest for within the EB5 context. As far as L1, really there is no type of business that's more suitable. The L1 boils down to I have a company. There is a company abroad that's seeking to expand in the United States. They're looking to transfer either somebody who has held for 1 year within the past 3 years, managerial, executive, or specialized knowledge, capacity, or role. They're seeking to transfer this employee to work for a sister company, an affiliate company, a parent company, or subsidiary company in the United States in one of these three roles.
All right. So I think that was a very insightful answer that we got from you, and thank you so much, for putting that up. And let's move ahead with another question that is of L1 visa. So, Alessandro, we all are aware that L1 visa is known for intra-company transfers. So, can you please explain like how a foreign company can use the L1 visa to expand into the US?
Sure. That's exactly the purpose of this type of visa, of this visa classification. The L1 visa enables a foreign company to transfer employees to the US to establish or grow a US branch, an affiliate, or as a subsidiary. So the very first requirement, when we're looking at L1 visas, is the qualifying corporate relationship. For example, shared ownership. As I mentioned before, the foreign company and the US company, they have to be their affiliates. They have to be, one has to be parent and the other has to be a subsidiary. That means that one has to own and control the other, or they have to be owned and controlled by the same person, the same company, or the same group of owners. So that's the first requirement. Second requirement is that the transferred employee has served for 1 year within the past 3 years as an executive, as a manager, or as a specialized knowledge employee or worker. And this person needs to be transferred to the US to hold one of these three roles. And the role doesn't have to be the same. So if I was a manager for a year within the past 3 years in the company abroad, I worked in managerial capacity. The company in the US does not have to transfer me necessarily to work as a manager. I could be an executive or I could be a specialized knowledge employee. These are the pretty much the nuts and bolts of L1 visas and how they can help companies, foreign companies, expand into the US market.
But Alessandro, I am thinking about it. Like as you mentioned that the company can. It's not important to have the managerial post only. If a person is manager in this company, then through L1, it's not compulsory to have that managerial post. Then don't you think it's going to reduce the skills? Because if the designation is not exactly the same, how they are getting in that different nation, with the same company, then don't you think it would be a little affecting the employer in a negative way because the designation won't be the same? So, what's your point on this?
Not necessarily, not necessarily. That's the so there is no legal requirement that the person holds the same role abroad and in the United States. And if given the fact that there is this flexibility, if the petitioning company in the US decides that that employee is better suited or is needed in the US in that new vest, quote unquote, or in that new role, maybe there is a reason. So I would say that pertains more to business decision rather than a legal decision. From a legal standpoint, we can have somebody who was a specialized knowledge employee in their home country for the company abroad, the foreign company. Maybe they're needed managing personnel or managing, department or a unit or of the company in the US, and that's perfectly fine. How that affects the operations of the US company, that's more of a matter for the US company from a business standpoint, I think.
All right. I think that's very well explained, and I got my answer. I hope our viewers too got the answers. And meanwhile, Alessandro, the great thing is that there are some viewers who has joined us, and I can see Sanjay, I can see Sudhir, I can see Ravi. So, friends, it's lovely to have you all. And do let us know from which platform you friends are watching us right now. And keep on posting a question. It's not mandatory, to just post one question. You can ask follow up. You can ask any question related to today's topic, and we will definitely take them up. But till then, wait for some times. After asking some random questions from my end, I'll be coming back to your questions. Okay, so now, yeah, Alessandro, now I have another question regarding the EB5. So we know that EB5 is more for the green card and it provides the permanent residency. But we want to know more about it. Like, what does the EB5 visa offer other than just a green card?
So I would say that there are three main benefits. Number one, the EB5 investor can live and work in the United States permanently because they're going to get their green card if they meet all the eligibility requirements, and they can work anywhere in the country, and they can um, you know do any kind of work, lawful work. Obviously, they don't have to work in the business where they invested funds in, like the E2 investor has to do. The E2 investor has to work in the E2 business, in the E2 company. The L1 transferee has to work for the L1 petitioning company. The EB5 investor, once they get their green card, they could live and work anywhere in the United States. So there is that kind of flexibility. Then family, they can bring along the family, so spouse and children under 21. And once they get their green card, they can also work and live anywhere in the United States, right, indefinitely. And they have access to, especially for the children of EB5 investors, they can gain access to US schools and colleges at the same tuition rates as American citizens. Usually, that obviously, you know, depends from school to school, college to college, but that's what I have seen and what the trend I think is. And then number three, after 5 years of being a permanent resident in the U.S., If you meet all the other eligibility requirements, you can apply for U.S. citizenship. These are the three, I think, most important things that EB5 option offers more than E2L1, just beyond getting, I get my green card. This is what happens when you get your green card. You can live and work anywhere. Your kids can go to school at the same rates as, American citizens. And then you can apply for citizenship after 5 years.
Wonderful. I think that's wonderfully explained, with the pointers. So thank you so much, for letting us know about it. And I think it was a great answer. And most of the viewers, mostly think about there's a confusion regarding EB5 most of the time because EB5 mostly they consider for the permanent residency. But now I think after watching this session, they might be knowing more about it. But I have another question that it's just a random thing that what can you say about the visa process out of like E2, L1, and EB5? Which visa process takes more time or maybe less time? Can you just talk
Definitely
about? Yeah.
the EB5, this is notorious. EB5 processing times are way longer. E2, E2, you can apply for an E2 visa in two ways. If you're in the United States in lawful non-immigrant status, you could apply for a change of status. That doesn't give you a visa. That puts you in E2 status, right? If you are abroad, you apply for an E2 visa at a consulate. So the processing times depend on the times of the consulate. There are consulates who have higher backlog or lower, more of a backlog or less of a backlog. So it depends. The L1 visa has two steps instead. Well, you could also apply for a change of status, but let's say you're abroad and you're applying, you want to the actual visa in your passport to be able to travel and enter as an L1 transferee. So you first petition, the U.S. company first petitions for files a petition with USCIS, so in the United States. And then once approved, the petition gets transferred to the consulate abroad. So we also got to wait for, consular, for the consular interview or consular appointment. And that depends on how long the consulate will take. EB5, different ball game, very long times, could take up to 2-3 years. But, if you're looking to get your green card and establish yourself permanently in the United States, it's definitely worth waiting.
Absolutely. I think waiting for 2 to 3 years instead of and getting in return for a lifetime
For a life.
permanent residence, and I think it would be much worth it, But I think that's great, and we are getting to know about the visa process also with these three visa categories. So thank you so much again, and.
Yes.
We have, I think let's take a few questions from our viewers because we are getting so many questions, so I don't want to upset them.
Mhm.
And let's take Ravi's question. So, Ravi is asking that my passport is currently under renewal and I have a valid H1B visa stamped until September 2025. However, my I-94 is set to expire on January 12th, 25 due to the passport's expiration date. Once I receive my renewed passport, what steps should I take to extend or update my I-94 to reflect the visa's validity? Can I do this within the US or do I need to leave the country and re enter?
Can you go back to the slide before?
I think, okay, let me read out this another question. And what can I do if my passport is received after my I-94 expiry?
I'm assuming this person is in the US, right? Ravi, I'm assuming you're in the US.
I think Ravi, it would be great if you could let us know where you are actually asking this question in US or some on the other
I
country.
think I
And it would
think
be
you are in the US. So the I-94, so this is a general, generally speaking, the I-94 is what dictates your period of authorized stay in the US. You have to be very careful what's the expiration date of the I-94. And also if there are very fact specific questions, I would rather address them individually. So I encourage you to give me a call or to contact, an immigration attorney. There's my contact information right there. because there might be other questions that I want to ask you, and that might play a role into the answer.
And here Ravi answered yes, he is in Denver right now. So I think you predicted right.
Right. Yeah, I would assume so. So seems that there is a 994 that is expiring soon. That seems something time sensitive, very delicate. I encourage you to schedule a consultation. Um,
All right. So I think
Generally speaking, you can extend your status. You can extend your status being in the U.S., but you have to file, paperwork. You have to wait. So it really depends on what the facts are, what the circumstances are, um, to determine what's best. Because you could, leave and re-enter if your visa is valid.
absolutely. So thank you so much, Ravi, for asking this question. And in case if you still have any follow-up question or would like to know more about any other question, any other topic that you would like to know, then please post them on the comment section and we will take them up. And meanwhile, you can also consult with our today's attorney, Alessandro Giordano. And the contact details are visible on the screen. You can see the telephone number is 973-494-5649. And you can also email him I would like to spell it out. That is AGIORDANO at THECOMPASSFIRM.com. And you can also visit his website, that is www.thecompassfirm.com. So I think it would be one of the great thing, if you could directly ask this question or any other question if you are
Right.
facing related to immigration process. So I think this
Yes.
would be a great one. And with that, I think let's take the another question that we received from a YouTube viewer, and that is from K. Vishwanathan. So his question is that L1 visa petition to be filed this month, but mostly after 17th Jan or 20th Jan. What will be the challenges and new rules with Trump administration? What would you like to say?
So it's hard to predict exactly if there will be any new rules. I think that after January 17 or January 20, after when? You know, how long after those dates? I think that's still early in the administration, and maybe it might still be early in the administration to have any meaningful changes. So I would just, unfortunately, that's the only thing that you can do for now. Wait and see. But I don't know if there will be, again, catastrophic changes for these kind of business visas. I've seen, yes, during the past administration, the previous Trump administration, um, adjudicators were a little tougher. I could, I noticed that trend, you know, um, tougher decision making on immigration officers' part. But really, the big changes that I expect are for people in removal proceedings, individuals in removal proceedings, or individuals who overstayed their visas, individuals who are here undocumented. Um, I'm not saying not to worry, but yeah, wait to worry.
Absolutely. And, with Trump's administration, we have also come across that in his first term, he was trying to limit the H1B visas, but now most of his statements, he is actually favoring H1B visa. So,
Right.
H1B visas, people are more into it. But what's your opinion on this?
Yeah, as I said, employment based and investment based visas, um, I have not seen the administration being so tough as in other aspects of immigration. I practice a great deal of not only E2s and L1s, but also EB1s and EB2s. And to be honest with you, I haven't experienced that much difference. One thing that was different was when the travel ban was implemented. So that could affect the ability to travel, but that's not specific to L1 petitions or E2 petitions. That is across the board. Um, The only thing that I can say is that we're all, anxiously waiting for these changes. We just need to wait for now.
Absolutely. We can just hope that everything goes smoothly. But
Right.
as most of the people are very much concerned about like what's going to be under Trump's administration, but mostly, we have seen that he has been very stiff towards the immigration. But
Right.
if we look now for the H1B visa, I think that's the mostly highly skilled workers that people need, right? And he's actually in favor of that. So I don't think any other visas like E2, L1, or the EB5 will also going to face some kind of hurdles or problems, regarding this
Yeah,
administration.
that's consistent with what I've seen before. Yeah, they were a little tougher. Administration was a little tougher, but nowhere near other areas of immigration law.
Mm.
So yeah, I don't expect a catastrophe like for other immigrants.
Well, we hope so. And what do you think about the Biden's administration? Was Biden administration more in favor of immigration as compared to Trump's administration? What's your call on that?
I have seen. So I have two takes on this. Definitely more in favor under certain, um, you know, from a certain standpoint, not as tough, not as hard. When it came to individuals in removal proceedings, um, seeking benefits before the immigration court, and even adjudication of benefits like L1, C2s. Yes, not as tough, but also I have not seen this current administration favor immigrants and the immigration system as much as I thought it would. But now it's passed. We have 2 weeks, and we have to move forward and look what's ahead.
Absolutely. And I think it would be a great year, and that's what we can hope. So, good luck to Americans, and obviously not just to Americans, it depends upon the whole globe. So,
Right.
yeah, and, I think with this, Ravi has commented, I will definitely contact you, Mr. Thank you so much, Ravi. And it would be so good, that if you could directly consult with our attorney. And Vishwanathan is also here and saying thank you. Thank you so much,
Of
Vishwanathan,
course, you
for.
guys are very welcome. My pleasure.
Absolutely. And with this, Alessandro, I'll be coming back to our viewers' question after some time. But I would like to continue with another question that's mine. For someone who is considering the E2 visa, what are the common mistakes that applicants make when proving their investment?
That's a very nuanced question. I like it. I will give you first the three most, I would say, common misconceptions of the E2 visa.
Yeah.
First, you know, so that we clarify what the E2 visa is for and for whom it is. The E2 visa, people think that E2 visa is for everyone. Unfortunately, it is not. It is for only nationals of certain countries. Is a treaty investor visa. That means that the U.S. has to have a treaty with your country of nationality or your country of citizenship. Okay, so only citizens of E2 treaty countries can apply for the E2 visa, and this is it's simple to find out what are the E2 treaty countries. You just Google E2 treaty countries, and one of the first results is the for the website of the Department of State, and they will tell you what the treaty countries are for the E2 visa. So another misconception is that any kind of investment will work for the E2 visa. That's not correct. Um, what I said, as what I said before, the investment for a E2 visa for an E2 visa is to be active, cannot be a passive investment. So many people ask me if they can buy real estate and rent it out as is for profit, and then if this kind of investment is suitable for an E2, and it is not. So an E2 investment must involve some sort of commercial or entrepreneurial activity. So passive investments such as in the stock market or buying real estate and renting it out typically do not qualify. Another misconception is that you know the E2 visa might lead to a green card. No, there is no direct path from an E2 visa to a green card. So if you, after you're here in E2 status, you want to apply for a green card, you have to, seek an independent basis. And you cannot pass from an E2 to an EB5 automatically or directly. That there is no such thing. However, the E2 can be renewed indefinitely if the business keeps operating and qualifying. So you could be here for as long as you want, so long as you keep meeting the eligibility requirements. Now, as far as mistakes when it comes to E2, one of the main mistakes is failing to demonstrate that an investment is substantial. We have to demonstrate that we have invested a substantial amount of money into the E2 business. And then another mistake that I see frequently is insufficient documentation of the source of funds. Remember, when you invest in the United States, this is valid for both the E2 and the EB5, but you have to demonstrate that um, your funds, the funds that you're investing, originated lawfully. It's called the source of funds. So we have to thoroughly document the lawful source of your investment. I would say that these are the main misconceptions and most common mistakes when it comes to E2 visas.
Absolutely. And I think that was a great one because it's not just important to understand the mistakes, but also, what people predict and what people think
Right.
with that, what mistakes they do. So thank you so much, Alessandro, and also for letting us know that these mistakes are not common only for the E2, but also for the EB5 visa. So
Right.
I think, it would be great if you could also, the EB5 investors can also look for these mistakes. And with that, here's another follow up question that we received from Ravi, and it is: will having a child born in France provide any advantage in expediting the green card process for an H1B visa holder? What would you like to say on this?
Not directly, not that I can think of.
Okay.
Not that I can
That,
think of.
okay, that's not an issue. I think,
I don't, not that I can think of in the sense, I don't think so. I don't think it will provide any advantage in expediting the green card. No.
okay. I hope, Ravi, you got your answer. And let's move ahead with another question also that I have in my mind. That is, Alessandro, we can say that entrepreneur, I want to talk about the entrepreneurs and the business people. So, is it like, can an entrepreneur start a new business in the US under the E2 visa, or do they need to buy an existing business?
Great question. I get asked this question 100% of the time that I have an E2 consultation. People ask me
Right.
all the time, do I have to buy? Do I have to start from scratch, or can I buy an existing business and maybe keep it as is or make some changes? The answer is both. Either option is viable. Entrepreneurs or investors who are looking to come to the United States on an E2 visa with an E2 visa, they can either start a new business from scratch or purchase an existing business. So starting a new business allows obviously more control over the business, but it requires, there are some hurdles to starting from scratch, right?
Absolutely.
Purchasing an existing business offers the advantage of maybe an established business, some maybe operational history, customer base. So, from a legal standpoint, both options are viable. You can come to the United States with an E2 visa by both starting a new business or purchasing an existing business. Which one is better for you depends on what you want to do.
Absolutely. And I think that was a wonderful answer. So I hope our viewers got to know that it's not exactly necessary, that to have to start a new business or to buy a new one. It completely depends upon your situation. And if and still you want to need a further clarification, or still you want to personally connect with our attorney, then you can directly contact him on the contact details that's visible on the screen. And that is 973-494-5649. And with the email ID that is definitely, I would like to read it out, and that is Giordano at thecompassfirm.com. And with the website, you can also visit there. That is www.thecompassfirm.com. So with that, we have another viewers also, and Sanjay is here. So I would like to take up his question. And Sanjay is asking that I am running a successful IT business in my home country, and I'm thinking about expanding it to the US. Would the L1 visa be a better choice than an E2 visa for me? What factors should I consider when choosing between the two?
The very first factors that you want to consider, Sanjay, are number one, are you a national of one of these treaty countries? Meaning, you have a passport from a country that qualifies for an E2,
Mhm.
right?
Right.
Not all countries qualify for an E2 visa, right? So if you're not a national or a citizen from an E2 treaty country, your only option would be the L1. So that's the first thing that you want to look at. Number two, the investment. This is something that we haven't discussed, but I would like to touch on it, Sam, if that's okay with you. The
I
difference
think that's
between
great. Yeah.
right, the difference between the investment part, um, between E2s, L1s, and EB5s. They're
Mhm.
three completely different, type of investments required. For E2, the investment has to be substantial. The law doesn't tell us what is substantial, right? What substantial means doesn't say under 50 is not, over 50 it is, under 100 is not, over 100 it is. No. Usually what I like to see is at least $100,000. So Sanjay, you want to look at, the funds that you can invest. Number one, if you're a citizen of a treaty country. Number two, if you can invest $100,000 at least. Um, those are the two requirements that I look at. Now, circling back to the differences, between the investment requirements, E2 has to be a substantial amount of money. L1 doesn't mandate specific investment. We just need to show that the company's operations in the US are adequately supported in terms of resources, personnel, but there is no set amount. And for the EB5 calls for a more significant investment, $1,000,000 or $800,000, depends on where the funds will be invested.
All right. Okay, so here's another question, Alessandro. And with that, thank you so much, Sanjay, for participating. And in case, if you have any follow up question, then please post them on the comment section. And with that, here's another question that what are some of the challenges and advantages of using the L1 visa to move employees or executives to the US?
Interesting question. So the first challenge that I see when it comes to an L1 transferee, this is more for larger companies with a lot of owners, right? We have
Yeah.
to we have to prove that there is a qualifying corporate relationship between the company, the foreign company, the company abroad, and the company in the United States. When you have a large multinational company abroad with a lot of owners, it's complicated to prove that there is that relationship. Maybe the owners are not the same in the US. Maybe
Right.
ownership is not the same in the US, right? And that's the first thing that usually, uh, you know, could be challenging when we deal with large multinational companies. And then number two, it's something that USCIS tends to question a lot, and it's the capacity in which the individual worked in the foreign company, right? So this is always challenging, demonstrating the employee's executive, managerial, or specialized role. So we have to be very, very detailed in the description of the duties. We have to be very, very specific. because that's usually a challenging part.
Absolutely. And also, what would you like to say about the advantages?
So the advantages for the L1, I would say off the top of my head, um, number one, there is no minimum investment required. It's
Oh,
not like the
that.
EB5 or the E2.
Mhm.
E2 again, as I said, I would like to see at least $100,000. For L1, there is no such thing. There is no minimum investment amount required. Number two, if you qualify for an L1A, chances are you also qualify for an EB1C, which is a type of green card, an immigrant visa petition that leads to a green card that has the uh, same or very similar requirements to an L1A. So if you have L1A status, you qualify for L1A status, you're here in L1, as an L1A transferee, chances are you can pursue, after some time, you can pursue EB1C classification and apply for your green card. So that's the second advantage that I would say. Then number three, you're allowed to bring your spouse and your children under 21. So you can come with the entire family. That's the third
Wow.
advantage that I would say.
I think there are lots of benefits to it, and I think it would be one of the
Yeah.
great, a very safe kind of visa category to invest on. So thank you so much, Alessandro, for letting us know about it, and for explaining, not, I won't say in a very detailed format, but in a very crisp and clear way. And I think with this, you were correct. The short answers are more correct and more accurate to understand. So with that, I would like to continue with my next question. That is, how do E2 visa holders navigate the challenges of renewing their visas, especially if their business is still growing? And what steps can they take to ensure smooth renewals and improve their chances for the approval?
So when you renew your E2 visa, I feel like renewing is a kind of an improper term because you're reapplying for the visa, right? And you have to
Correct.
show exactly the same requirements that you made the same requirements of eligibility that you showed the first time. Just you don't have to invest again because you can use the initial investment, right?
Yeah.
But the renewal success for an E2 depends on a few things. First of all, the business has to show continued operations, right? The business has to still be operating and running. So we want to provide financial records to show that the business is operating and financially healthy, quote unquote. Then we want to show. I like to show that we are employing people in the United States, so job creation. These are usually the main point. There are obviously other requirements, but these are I think that the things where an E2 visa holder that wants to renew his or her E2 visa should be more proactive about.
All right. Okay, and with that, here's another question: that how does the E2 visa allow investors to manage their businesses in the US and eventually bring family members?
So this is what the E2 visa is for. If you are an E2 investor, you're investing in a business in the US, has to be an active and operating business. And as an E2 investor, you're coming to the US to direct and develop the business. That's what you have to do, and that's all you can do. Um, Differently, the spouse can come to the United States as an E2 dependent, apply for a work permit, and work anywhere else. They don't need to work in the E2 business. And then children under 21 as well, they can hold E2 status up until they're 21. They can go to school. They're allowed to study here. So this is
No.
something that's definitely worth considering. I would say it's a great advantage for an E2 family that wants to move to the United States.
Absolutely. And I think it's one of the most good benefit. It's going to be a very beneficial for them as well. So we can see, lots of benefits regarding L1, E2, and the EB5 as well. Though the visa process are different, but it depends which category they are choosing for. But these three categories have their own benefits. And if we also look for the 2025, then we can just hope that it's going to be beneficial year for these categories too. And I think with that, Alessandro, we have covered almost all the questions. And
Mhm.
with that, we have been left for 10 more minutes. So I think with that, want to take my. Okay, let's take the viewer's question. And here's another question that I have got from Sudhir. That is, if I apply for an EB5 visa and invest in a regional center, how do I ensure my investment qualifies under USCIS rules? Also, what happens if the project fails? Will I lose my visa?
That's a loaded question. So if you're going through a regional center, these centers are pre-approved, so they should already qualify, under USCIS rules. But still, EB5s are very complex and nuanced. So get a lawyer to assist you, even if you're filing to a regional center. Okay. And then what happens if the project fails? There could be an issue. There is a conditional period of 2 years, and after 2 years, you have, after the investment, you have to show that the project is still standing. So EB5s are complex. If you have the intention to invest a large amount of money, 800,000 and up, I would say it's worth contacting an attorney and being counseled and assisted by somebody who has experience with EB5s, because again, it's very nuanced, very complex, and there could be some pitfalls, and you need to be explained all these things so that you can make an informed decision.
Absolutely. I think taking expert advice would be a great suggestion here. So, with that, we have touched Sanjay's question, Sudhir's, and Ravi's question. And Alessandro, we have more questions from our Facebook group, because there also we have our viewers who regularly post questions regarding the immigration topics, that we mostly have our webinars with. So, here's another question that I would like to ask from you. That is, does buying an existing home care facility qualify for EB5?
Overbroad question, I think. There are many requirements to an EB5, many requirements to an EB5. So, you have to invest in a new for-profit enterprise. So a new, commercial for-profit enterprise is one established after a certain date, or if it was the certain date is November 29, 1990. If it was established before, you have to restructure or reorganize it, or make some changes. So it really depends. Is a very fact-specific question. And you need to invest the required amount. And that depends on where you're investing. You need to show that you are creating a certain amount of jobs. So I think that it's hard for me to answer this question based on the very, very, very little information provided.
Absolutely. I think it would be great, the one that who has posted this question. And if you're watching this session, it would be great to have more details. And, it would be better for us, and it would be better for our attorney also to answer your question. So, no worries. Let's move ahead with our next question. And the question is that I'm a Canadian citizen of Indian origin. What is the processing time for obtaining a green card via the EB5 route? Are there any quota restrictions applicable to individuals born in India?
So for the EB5, again, the timings are very, very long. What does it mean, a Canadian citizen? So you have a Canadian passport, but Indian origin. Where were you born? Because the restrictions are for certain nationals.
I think he has been born from, I mean, in India only, and after that, sometimes he took Canadian citizenship.
Right, right. There is some backlog, and nationals of India are a little, we know that there are some restrictions. Um, but again, I would need to have a little more information to answer this question. To answer this question, there are some restrictions. Most EB5 categories now are current, or they have been current as of recently. But again, I would need a little more information to answer your question. So if there are questions that are very fact specific, I encourage you to, you don't have to. I like that you're posting anonymously. So I'm a big fan of confidentiality. um, but
Right.
if there are, if they're very uh, circumstances or fact specific, I encourage you to shoot me an email and we can take it from there.
Absolutely. I think that would be the great one. And thank you so much, Alessandro, for taking this up and at least letting our viewers know about it, like what they can expect from you. And with this, we have another question that how long does it currently take to receive an EAD and an advance parole card? Are applicants still getting a combo card? Also, are these cards being issued for 2 years or 5 years?
Again, I don't have enough information to answer this question. I can tell you that yes, combo cards are still being issued. It depends. For example, recently I had a husband and wife. One of them got the combo card, the other one got the work permit only, and that got the advanced parole in the good old paper fashion. But yes, combo cards are still being approved, are still being issued. And then it asked if they're being issued for 2 or 5 years. So at times the duration of the work authorization document, employment authorization document, depends on the category under which you're applying. So I would need to know maybe more about the about the
Yeah.
situation.
Absolutely. We completely understand this thing. And with this, I hope this question looks a bit detailed. So let's expect something from this. Control, if you could zoom in a bit so that it will be clear for
Thank
us.
you.
Thank you. Yeah. So it's the question is that good day to all. I have a few questions regarding E2 visa and would appreciate if some experts can provide advice. Firstly, if my spouse gets E2 visa and dependents, myself and kids, gets E2S, can the spouse who got E2 visa switch to E2s subsequently and dependent become E2 status?
I think
Let's,
this question is asking if this person has E2 and the spouse has E2 as a spouse, and then they
yeah,
switch. So the
true.
main E2 becomes the E2 spouse, and the spouse makes the investment. I mean, if you qualify, that's what I'm understanding, but it's a bit confusing to me. um, the way it's posed. If I understood correctly, it would be possible so long as you meet the requirements. And then I see that there is another question. After changing the status from B1, B2 to E2 while staying in the US, how E2 applicants may leave the US and re-entering. So I'm assuming the person enters the US with a B visa, a tourist visa, or B1, B2 business or tourist visa, with a visitor visa, and then change status. So if you want to re-enter in E2 status, you need to go to a consulate abroad and get the E2 visa stamped in your passport. And then you can re-enter with a E2 visa and have E2 status. So you would need to get the actual visa stamp in your passport for E2.
All right. So I think with this, Alessandro, we have completed our Facebook questions too, and I think most of our viewers also got your answer. And it's almost 1 hour, but there's one more question that I would like to know it from you because this is a mandatory one and it's very important to know. So, is there a famous company or entrepreneur who used the L1 visa to enter the US? And how did they ensure that their visa approval and what can others learn from their journey?
I love this question. So I love this question because many large multinational companies used L1 visa option. Like many large multinational companies,
Yeah.
go have their employees go this route to transfer them to the US. However, this is something interesting that I actually want to emphasize. The L1 visa is not just for large corporations. Small and even new companies can also take advantage of this option, the
Yeah.
L1 option, provided that they meet the requirements. Like there is something that is called L1 visa for a new office. So if you are a new company in the US, you can apply for an L1 if you're starting brand new in the US. You're in business for less than 1 year in the US. You can use the L1 to transfer employees from the foreign company into the new company in the US, even if you have nobody working in the US yet. So it is not just for, again, many large corporations use the L1 visa, but it is not only for large corporations. Small companies can use this too to establish or expand operations into the United States.
All right. So I think with this, we have almost reached to an end. And this was the last question that I wanted to know. And thank you so much, Alessandro, for taking this up and letting us know about it. And I'm sure, our viewers loved this session. They got to know so much about it. And the most importantly, I think they got more clarity regarding these three visa categories. And I think most of the people, they were concerned about the complexities and the problems, that is going to happen, that they predict that's going to happen in the upcoming year. But thank you so much to you for clearing that up and, taking all the questions very patiently and answering them. So from my side, I think this session was amazing one. And after all, this was your first time on our show. So I want to know, how did you feel? How was your experience?
I am very happy that you guys invited me. I appreciate the opportunity to be here and to share, all this information with your public. I hope they enjoyed it as much as I did.
Absolutely.
Thank you again. It was a pleasure for me.
Same here. And I think it was truly an honor to have you with us today and, to have this session and to introduce you to our viewers. It was one of the great thing. And thank you so much to our lovely viewers also who participated in today's webinar and asked their questions. And even after this 1 hour that got ended, after this also you can keep on commenting, you can keep on posting your questions. And in the next show that we are going to have with Alessandro, we will definitely take that up. So don't be upset with the fact that we are not going to continue our live session, because soon or the later we are definitely going to come back with another very exciting episode. And that's all. I think it's almost a wrap, and we have reached 1 hour. So thank you so much, Alessandro, for being with us, for sharing such an insightful answers with us. I'm sure our audience loved it, and it was truly an honor to have a show with
Thank
you.
you.
So thank you so much.
Pleasure was all mine. Thank you.
All right. So thank you so much, everyone, for this amazing session. Don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. And we will be coming back with more exciting episodes with different attorneys. And stay tuned. Keep updated yourself by also clicking on the bell icon that is going to visible on the screen. So thank you so much, everyone. And yeah, I think good luck and take care. Bye bye for now.
Hi everyone, welcome to Immigration and Jobs Talk Show. I'm Rajni Bharara, your host, and before I move ahead, let me read out this very important disclaimer by watching our videos. You agree and understand that the information provided by our attorneys and guests, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this important disclaimer, welcome back everyone to Immigration and Jobs Talk Show. I'm your host Rajni Bharara, and today we are here to unpack the ever-changing world of immigration with expert insights and a lively discussion. Whether you're navigating the complex maze of visas or just curious about immigration trends, you have come to the right place. Today's topic: EB2 NIW visas. Are USCIS making it harder to get it approved in 2024? Buckle up because we are diving deep into this hot button issue. And trust me, we have got the dream team to break it down. Yes, but first, let's give a warm welcome to our wonderful audience, whether you're watching us live or catching the replay. Thank you for tuning in. Be sure to stick around because this episode is packed with valuable insights and maybe a sprinkle of humor too. And don't forget to drop your questions in the comments. And yes, after we get answers from our dream team, we will be asking your questions to them. So now, without any further ado, let's meet the dream team, our incredible guest for today's show. First up, we have Rob Melvin, a 26-year veteran in the legal arena and a licensed attorney by the Texas Supreme Court. Rob's journey has taken him from litigating in Texas courts to serving as a Foreign Service Officer for the U.S. Department of State, where he held consular commissions under 3 U.S. presidents and adjudicated over 9,000 visas. From diplomatic scrutiny trainings to managing high-profile visits from the likes of Hillary Clinton and Mike Pompeo, Rob has done it all. Today, he's a powerhouse in employment, business, and investment-based immigration. So, Rob, welcome to the show.
Happy to be here. Thank you for the invite, and we're humbled to be on your show and thankful for the opportunity.
Of course, it's a pleasure having you on the show. And after Rob, everyone, let's meet our second guest, Philip Rodriguez, who might just be the Clark Kent to Rob's Bruce Wayne. Philip is a partner at Doss Rodriguez, PLLC, and brings 13 years of stellar experience to the table. He has represented clients globally, tackling everything from family-based petitions to removal proceedings with finesse. With a Juris Doctor from St. Mary's University and a knack for delivering personalized legal solutions, Philip is a force to be reckoned with. Philip, we are so glad to have you here. Thank you so much for joining us today.
Yes, thank you very much, Rajni. It's a pleasure to be here.
Well, thank you so much to Rob and Philip. And guys, let's get into today's topic. The topic, like I said, is the EB2 NIW visas. Yes, EB2 National Interest Waiver visas. With the USCIS rolling out the new guidelines, are these coveted visas becoming harder to secure? Are we entering a new era of red tape? Or is this just a bump in the road? Let's find it out from Rob and Philip. So now, without any further ado, Rob, I would like to come to you first. You know, while I was introducing you, you have this 26 years of experience. I might have accidentally called you a 26-year-old, which you also look like, the both of you.
My wife's in the witches.
but Rob, also I would like to know from you, recently the US presidential elections results were out and the Trump is back with his very aggressive team and his administration, because every day he's giving us a shocker with picking those controversial candidates and making it harder for immigrants to actually think that is it going to be possible for them to get into the US now, or is it going to be more difficult? How is the situation going to be? So it's so chaotic and it's all over the place right now. So were you happy with the results? Let's first come to you and then we can see how Philip felt about it.
Okay, well, I mean, to my knowledge, I don't consider this bad news at all, especially for Indian nationals. It may be bad news for people from the Western Hemisphere that have come over irregularly, because I could see removal practices being very more difficult. But there's some things that I think that maybe your audience should keep an eye. I mean, there's 3 people close to Trump now that have his ear and will have it regularly. You have the second lady, Usha Vance. You got Vivek Ramaswamy, and then you have Kash Patel. All 3 of those people are going to be talking to him every day. And believe me, they've been in the U.S. for a long time. They know the plight of the Indian retrogressed visas and the problems that people have been having coming from India to here. As for like the comment on the adjudications becoming more difficult, we've actually seen in our practice, 2023 was the dream years. Those were the golden years for the EB2 NIW. We were shooting 3-point shots, getting approval without a lot of pushback. 2024 actually turned into a bit of a quagmire. That I don't know what happened. I don't know if USCIS was pushing back against the administration because of all of the irregular immigration coming in, maybe as kind of I don't know, retribution, if you will. But we have seen in 2024 more pushback, more stringent, more new requirements, almost pre-Danisar analysis to the EB2 NIW than we did in 2023. So I have high hopes for 2025 for the Indian national population. They're some of the smartest applicants that we have, the most highly educated, the most qualified. And I mean, in my opinion, everybody's got an opinion. I think Trump and his team are going to be looking for people of that caliber that are going to come in and kind of lift the boat of the U.S. economy with especially STEM, financial investment, those types of visas coming in. So I'm actually super hopeful that 2024 will go away for the EB2 NIWs because it's been a rough year. And and that 2025, once things start rolling, we're going to see a better improvement. Again, that's if USCIS, each agency kind of has its own culture, does its own thing. I worked for state under Trump. They pretty much ignored Trump and just kept doing their own thing. I mean, of course, they had to do some policy and economic and political moves that he made them do. But I was in the consular section and they just kind of, they're like, yeah, whatever. So I don't know. I don't know if that is too much information or answers the question, but I think that we're going to see, I hope that we're going to see an improvement, especially in the fields of STEM and cases where we can make a really good argument that in addressing a very specific national interest for the United States.
Philip, what about you? Because, I mean, Rob said that it's going to be, with Trump coming back with his team, it's going to be good for the market and good for the economy. And, we have seen that Trump is already talking about putting those percentage of tariffs on those countries, especially Canada. And, recently Canada's Prime Minister Justin Trudeau, he met President Trump, and he actually joked with him for becoming, Canada becoming the 51st state of and merging into the US. And he said, you are more than welcome to become, you will not be the Prime Minister, but then you can become the governor of the 51st state. How about that? So, he has really scared Canada. And, there are talks about putting 100% tariffs on the BRICS countries if they think about, getting another, if they are getting those, instead of, if they will give priority to some other, anything else apart from dollar. So what do you think? Because, there are so many talks about that. So how do you see? Do you think it's going to be good?
Well, yeah, I agree with Rob in terms of the EB2 NIW visa, right? Because that visa is for people who can show that their work is in the national interest of the United States. And touching on what Rob mentioned, how we have seen, so under a Trump administration, we may see a stricter interpretation of USCIS policies, but I don't necessarily think that that's because it's the Trump administration. If we go back, let's think about DANISAR, which is the guiding framework for an EB2 petition. DANISAR became law in 2016 under Barack Obama. And since then, and think about that, 2016, that's only 8 years ago. So that framework hasn't been in effect for very long. Prior to DANISAR, we had a much stricter framework for EB2 under the New York State Department of Transportation, and that went into effect, I believe it was 1998. But the point is, we may see stricter interpretations of USCIS policies under Trump. I don't necessarily think it's a function of Trump. I think we'll get into this a little bit later, but I think it's more a function of the fact that a lot of people are learning about EB2 now, and a lot of people are filing those types of applications. It's become highly competitive, and that is why USCIS has to do a better job of sifting through all of these applications and finding out which ones are truly in the national interest of the United States. And I think what we're probably going to see is the industries that will be favored under a Trump administration are going to be manufacturing, I think national security, and I think technology, which may not be good news for those who would like to apply under the humanities or the arts. They may have higher hurdles to jump.
Okay. Well, thank you so much to the both of you for that amazing answer, and also for sharing your point of view. But with this, Philip, I would also like to know from you that what do you think? Do you think that USCIS gets influenced by who takes the office? Let's suppose, because earlier it was the Biden administration and now it's going to be Trump administration. So do you think they make plans and they make the policy changes or whatever updates that they give in? It somewhere gets influenced by who takes the office?
I think the leadership does have an effect on policy directives and adjudication standards. However, I don't think it's necessarily going to be a complete shift, right? I mean, USCIS is a relatively large organization. It has its own culture, right? So because a new leader comes into office who may have a differing opinion on policy, sure. I think it is fair to say that might influence some adjudication standards. However, I don't think that it's necessarily going to just make it impossible for people applying for EB2 and IW. As I mentioned, what we may see is a shift in the industries that are favored by this administration, because it's no surprise. Trump and his team have come out and said that they want manufacturing in the U.S., technology, and national security. And so I think we may just see a shift in the types of industries that are favored. Would you agree?
Rob, what about you? What do you think?
Definitely. I mean, it does depend who's put in charge of DHS, and then it flows down from there. And then they'll have the director of USCIS and the deputy director, and they will push downwards. But I've been inside the belly of the beast. I work for state, and I know they do have their own corporate cultures. I think, in my opinion, they're going to be more in line with, if these predictions are right, with the emphasis of Trump and his team continuing to be on manufacturing, tech, STEM, anything like that. I think it will influence the adjudicators in favor of pleasing their bosses. These people are all bureaucrats. I was a bureaucrat, right? So what's the one big fear to a bureaucrat? It's your career. And what is that? That's your review at the end of the year, okay? these are all civil servants. In fact, they're all graded on a G scale, which means you don't just get promoted. You actually have to, if you want a higher, better job, you want more pay, you have to apply for a higher scale, a GS 14 instead of a 13, right? Mm-hmm. So the only way that they're going to do that is they're going to have to show that they have a track record of pleasing their bosses. If their bosses are telling them, look, Trump says X, we need to go in this direction, and that's the order they're getting from the top, they're going to need to move that way if they want to eventually secure a higher level government service job and keep continuing on. There's some that'll be perfectly happily being a GS-12 and couldn't care less and just want to draw their check, do their 40 hours and build their pension, right? Mm-hmm. But there's some go-getters, and the hustlers are going to want to see, they're going to want to comply. So I think it's going to be a great year for EB2 and IW. 2024 has been a challenge for us in our practice, and I know it's not specific to us because we're members of ALA, and we have our distros with thousands of immigration attorneys all over the United States, and we constantly keep an eye on it because it's one of our areas of emphasis is employment, business, and investment, immigration. So we really keep a close eye. And I think it's going to influence them. Yes, I think there's a misperception that it has as much influence as it actually does, but that's just my experience in working for state. And I have a lot of friends at USCIS and DHS, so I kind of keep my thumb on that pulse as well.
Okay. So, but then, Rob, when you say influence, do you think that influence is going to be good or is it going to be bad?
I think for the Indian national community, it's going to be fantastic. Mm-hmm. It's one of the smarter applicant pools, one of the more ambitious applicant pools or countries, and just more qualified, and they're more hustlers. I mean, they just are go-getters. And I think that's going to be what the policy that they're going to want to be pushing downstream at DHS, down to USCIS and everybody else, to the adjudicators, is look, we're kind of changing the way we look at immigration. We want to do, as you've mentioned before, kind of a merit-based system. The family system will always be there, but they want to improve our economy. And the only way to really do that is to do a brain drain away from other countries. And India's got plenty of brain drain power to provide to the U.S. I think it's going to be good for India.
Okay. But then what do you think about the visa? I've still not delved into our questions that actually we have prepared for you, but I'm still coming up with the follow-ups. But then I would like to know from you, Rob and Philip, that then what about the wait times that India actually sees, from whenever the visa bulletin comes, the processing times, the wait times for India specifically are very long. So why do you think that happens? Philip, I would like to start from you.
Well, the reason you see these retrogressed visas and the wait times is because of the per country caps on green cards. It's a 7% cap on green cards from any country, and you have a lot of applicants from India. 7%, I believe that works out to around 9,000 visas, 9,500, something like that per year. Mm-hmm. But because we have so many applicants, that's what leads to the retrogression. And something that I think maybe we could see, there's legislation pending right now to remove the caps on green cards. And so that's something that we could see help with these retrogressed visas. But that's a great point that you bring up. And that is the biggest India-specific challenge, is that we're seeing retrogression decades.
11 years to visa availability and 12 to adjust.
Yes.
Wow.
Yeah, so that's a very good point. And what you do in that instance, and what we advise our clients is, well, let's look for, if that's what you're going for, let's look for other ways to keep you in the U.S. lawfully keep you working. Let's look for other options, because the EB2NIW visa is just one tool in our toolbox, just one. We have so many available options out there. So that is key when it comes to an analysis for an Indian national who is seeking the EB2NIW.
Okay. And Ram, okay. So now I would like to actually ask from you that, but do you think in 2024, I mean, it's just about to end and 2025 is about to start, right? So do you think in 2025, EB2NIW is still going to be that golden ticket, you know, for the immigrants?
Yeah, I mean, so here's what's happened, and Phil can put in his 2 cents. I think the H1B program, the CAP H1B program, has become such a disaster over the last 2 cycles that everybody kind of flooded from H1B over to EB2NIW. And I think that's what's caused the problems in 2024. So what I would like to see happen, what I hope to see happen, is they actually fix the H1B, because people have been gaming the H1B so badly that the percentage of the lottery winners, I think, was 10% last year and 17% the year before. So people are opting for other ways. So they're going to the EB2NIW. EB2NIW is definitely the golden ticket. I mean, same with EB1, but you got to have a good package, you got to have a good plan, and you have to be qualified. You know, it's not the golden ticket for everybody. You know, we usually can knock out the first part relatively easy to the EB2 analysis. It's when you get into the national interest NIW analysis, substantial merit, they usually just give it away, because the ones we're throwing up there, we're not throwing up to open up a McDonald's restaurant, right? We're opening, you know, we're doing naval inspections and maintenance on cargo ships, oil platforms, logistics and supply chain cases, warehousing and distribution. I mean, those types of cases, you're not going to just get an EB2NIW for any reason. But we usually, substantial merit, usually they just kind of give that one away, because it's easy to articulate how something might be in the substantial merit. So then there's 3 prongs, but there's actually 4, because the first one has 2. Then you get to the national importance. This is the one where they're currently really sticking it to applicants. Okay, so what? Your program, your subject matter expert has substantial merit. So what? How is what you're going to do going to be in the national interest? We have to now lay out the breadcrumbs piece by piece from their business plan, from their proposal, to the substantial merit piece, and connect the dots very explicitly for the applicants. And then you drop down to is well-positioned. You know, before, well-positioned was kind of like, well, they've got a master's or they've got a good professional history. Now they want more. They're even asking for kind of like, okay, you're going to do this. Do you have the financial wherewithal? Where are you going to get those funds? Do you have any kind of track record in doing this particular endeavor? So they're making that one a little bit harder, but that one is usually we're able to overcome relatively easily. But then they jump to the last one, which is the most nebulous of them all, whether on balance it would be in the interest of the U.S. government to waive the labor certification. Well, what the heck does that mean? I mean, I thought we answered that in the first three questions, but basically we're making the argument that this is so necessary that we need to just move away the year and a half labor cert process, which is currently just getting longer and longer and longer, and just get this person in. Let's get him in. Let's get him going. Let's get him improving the country. You know, whenever there's a national crisis that or an international crisis that we can link to and cling on to, that's related to our client's deal, we do that to, and try to file as quick as we can to, to hit that particular piece. Like, we need this person in now. So anyway, I don't know if that answered your question, whether it's the golden ticket. It's not for everybody.
Yeah.
Not for everybody. It's not the Willy Wonka chocolate bar. You have to actually, come in with merit in this deal. When we make you look as good as you can possibly look, but you have to have some juice behind you as well.
Right. I mean, if this is not the golden ticket, maybe US can also come up with, golden visas like Dubai or maybe, other countries. They offer golden visas, right? So maybe US can come up with something like that. Right, Portugal. So, okay, coming back to my questions, Rob, I would also like to know from you that with President Trump now returning to the office, what do you think? What are the risks of reversing the more lenient policies recently adopted by USCIS regarding EB2 and NIW applications? And how do you think that this might impact applications who already have begun their petitions?
Well, first of all, the more lenient policies, maybe that applied in 2023. We are not seeing that in 2024. So I think the question may kind of presume an erroneous answer. We think they're stricter now than they have been for the last couple of years. Although on paper they might be lenient, in as applied, they're much stricter. So everybody who's already in play, they're going to get adjudicated under the standards when it's on that person's desk. So whatever the policies are at that time, there's not going to be any kind of grandfathered in, because DONASAR is the standard, right? And has been since, what'd you say?
2016.
So that standard hasn't changed. The way they implement the standard, that's changed. Couple things that have been problematic or troubling to us that we've seen is, we've read a lot of articles and tracked a lot of things that it looks like they're adjudicating a lot using AI tools, which everybody uses AI tools now, right? Problem is, I used to work for the government and I know what kind of software they usually get. And let's just say it's not ChatGPT 4.6 or whatever, we're seeing RFEs that are misspelled, incomplete sentences, jumbled garble, repeat boilerplate clauses, just that maybe don't even apply to the same case or the same subject matter. That's a problem. We also saw the recent article did. They've subcontracted a lot of their work to Chase. So here you have civilians adjudicating these cases. I can't say for sure that they're adjudicating EB2 NIWs, but by the RFEs we've received, it wouldn't shock me, because it seems like the person making the decision doesn't even know what the heck they're talking about for the case.
Yeah, it's Rob brings up. So a request for evidence, just for viewers that don't know what that is, that's what USCIS sends to us after they've reviewed our initial submission, our initial visa submission. If they would like to see more evidence about our application, they'll send us a request for evidence. And it is no exaggeration to say that we have seen, I would say, of the RFEs that we see, about 50 to 75%, they literally make no sense. And just like Rob pointed out, grammatical errors throughout, requesting evidence that was included with your initial submission. So on the topic of the AI and RFEs, I totally agree with Rob. And then as far as going back to the leniencies, I also agree with Rob. In our practice, we don't see any leniency. These applications, this visa is a very tough visa to get approved. Thankfully, we've had great success with that. One item maybe that could be considered a leniency is premium processing, and that may have been a leniency early on, but now you ask almost any immigration attorney who's in this area who handles these types of cases, and they will tell you maybe it's not such a good idea to file premium processing, because that's almost like you're putting a target on that application, and it may draw greater scrutiny from USCIS. I would say in our practice we see that more likely than not. Certain applications that are just stellar applications, maybe they could benefit from premium processing. But again, what we see frequently is that premium processing, which could be considered a leniency, wasn't so lenient.
Not only, I mean, why would you pay $2,800 and probably some extra attorney's fees to do premium processing when your visa category is retrogressed by 11 years? So you're going to get a yes much quicker. People were doing that because of the elections. But now, I mean, we recommend our clients don't even utilize it at all because of the negativity. We think it's like a boogeyman out there that if you use premium processing, you're more likely to get a strong RFE, and they're really going to come at you because it's a war of attrition, right? A lot of people don't respond to the RFE on time, or it's much more work or much more cost. They just go away. So that's just that many less petitions that they have to adjudicate. But if there's no, it would be very difficult for me to imagine the benefit of a premium processing especially to an Indian national, a Chinese national, a Mexican national, any of the ones, Philippines, that are very retrogressed. Why do you care when you get your approval? Because you still got a long wait before you can do anything else.
Wow. Okay. As they say, nothing comes easy, and especially, if it is something really good. So I think those EB2 applicants, will really have to buckle up, and maybe they can start binge watching some stress management videos. How about that, Robin Phillip? So, but Philip, I would like to come to you and ask you, but do you think that with this, do you think there will be rush among applicants to file their petitions before, any anticipated policy changes? Because people, especially now that Trump has won, because they are every day thinking that some or the other policy change might happen. So do you think that there will be rush among applicants? And if people are considering that, what advice would you like to give them?
Well, I can tell you that the short answer is yes. And I say that because we've seen that. We have seen a rush in applicants trying to get their applications in before the change in the administration. We have had any number of applications, but also the EB2 and IW. We have people calling us every week, 10 to 15 possibly calling us a week, trying to get this EB2 and IW petition, trying to get it filed. So we do see a rush, and we're seeing a rush from all countries in all areas. People want to come to the U.S. And so what I would advise anyone who is in that position that would want to get their application in before this current administration, I'd say, talk to a lawyer as quickly as possible. Give us or someone else a call. However, be realistic about your timeline, because in all likelihood, the EB2 and IW, because as we've outlined, it is a difficult visa to apply for and come up with all the evidence. So it's not necessarily going to be filed before the new administration begins. So just be realistic about your timeline. And also, again, I know there may be some anxiety out there about the change, but come on, we change every 4 years almost. Whether it's the same political party or not, there's change in the administration every 4 years or so. And we've seen that in our practice, in Rob's employment with the government, in my practice in immigration law, in both of our practices. Change is going to come no matter what. You just have to select a team that is prepared to handle that change.
Right. So I think we are going to see a lot of people more than the attorney's office. They are possibly going to go to the astrologer's offices now, especially for these 4 years. Rob, I would like to come to you and ask you that what do you think? What do you think about the Muslim majority countries? How are people dealing from those countries? And are you also getting calls from those countries? Because Trump with Project 2025, I mean, Trump and his administration are thinking of putting a ban in the Muslim majority countries, travel ban. So if you can please tell us about that too.
Yeah, I mean, we haven't seen a lot of that in our practice. I've seen zero. We both take calls and we usually interview the clients together. So we really haven't seen that as an impact at all. We have many clients from Muslim countries and it's like the boogeyman effect. It's like that's something that may never happen. Maybe it will happen. If you're that afraid of it happening, then get in. Let's get your case filed and go. But I can't predict with any certainty that that's going to happen again.
Yeah, we don't. On the topic of the boogeyman approach, we cannot advise our clients based that are rooted in fear. Right? We try not to use fear. We do not use fear to influence the way we handle our practice. Again, change comes every 4 years, and sometimes faster, depending on what the judicial system is doing and what new case law is coming out. I mean, really, as Rob mentioned, we're members of the American Immigration Lawyers Association. Mm-hmm. It's over 1,000 immigration lawyers across the United States. And we are on listservs and distribution channels and emails. And so we follow this all day, every day. And I mean, new cases come out every day, every week. You get 3 or 4 or 5 new cases that change the law. I think the judicial system, it's on its track. It's going the way it's going to go. And I don't think that there's necessarily major influences on who's in charge.
Okay. Thank you so much again for answering the question, Rob and Philip. Now, I would like to come to you again, Rob, and I would like to ask from you, given the historical context of, the heightened security scrutiny during Trump's first term. So do you anticipate that the USCIS will revert to a more stringent interpretation of national interest? And if so, what evidences might applicants need to provide to counteract this?
Well, I sure hope they don't get any more strict than they already are, because they're at a pretty high level, and Trump's not even in office, and they've been at that level all year this year. So, like I said, the strategy is you have to have a strong business plan. So you need a professional business planner, right? And they're going to take all of your strengths and all of your history, and then articulate the national interest. But now we can't just say, okay, great, this person is in cybersecurity and has a good professional background. This is a national interest. We're getting hacked by Iran and China and North Korea. So that's a good match. Now we have to show this person is cybersecurity. The first 3 months, they're going to do this to implement it. The second second quarter of the year, they're going to tie into these certain key areas of the economy or of the national landscape, and then these are going to be the results, right? So you really have to, more than ever before, for national interest, just lay down a crumb trail, paint a picture exactly how what you're going to do is going to help each aspect. It's very easy to articulate a national interest, but the way that they're saying national interest now is show me how your person is going to hit that national interest. It doesn't matter that, we've had the Panama Canal problems and problems in the Suez Canal. I want to know how your naval engineer is going to actually fix those problems. So then you've gone from just saying, hey, I've got a great naval engineer and I've got there's huge problems that are causing supply chain worldwide, massive damage. Now you got to say, this is what my naval engineer is going to do. He's going to go over to XYZ spot, address, ABC issue. It's going to result in DEF result. I mean, it's a lot more work and a lot more intensity. And quite actually, as a law firm, we have to raise our rates a little bit to correspond with the amount of time that we're having to put in these. I mean, because these are getting to be, much more intense cases than they were before already. Again, I hope in 25 is that what we're presuming is going to happen is going to actually be the opposite. I want to see, like with Elon Musk involved and the emphasis on STEM, that they're going to be seeing, hey, this candidate's great. We know what the national interest is. Approve this, this petition. I can't say that's going to happen. Those are my hopes, but it sure as heck can't get much harder than it is right now. And we're under Biden. We're under the Democratic Party. This year has been awful for national interest. So, I don't see how it gets much harder than it's been. Philip might have a different opinion, but
no, I agree. I think what we're seeing with national interest and heightened scrutiny has been coming down the pipe for a while now. And what we see is a focus more on immediate economic and job impact rather than long-term contributions. So part of the question was, what key evidence can we provide? Well, some key evidence is we need to have a quantifiable economic impact. What I mean there is we need to show the job creation, the impact, the benefit to the GDP. We also need to show that our applicants that they have industry recognition and they have endorsements within their industry. And we need to show specific examples of how their work aligns with the U.S. priorities, which we see as going more toward infrastructure and other critical industries like healthcare, like technology. That is some of the key evidence that we will have to show to show that these applicants will contribute to the U.S. national interest.
One more thing I want to interject, Raji, is that we've kind of taken a tact on our EB2 and IW cases, treating them almost as if they're EB5s. So we like to see at least 10 direct job creations under the business plan. And then we also want to show at least some significant impact on what's called the TEA type zones, the high unemployment, rural, those areas, because those are what, in the government's mind, those are, kind of policies that they want to address. We're trying to use that mindset from over here in the EB5 world, implement that into our EB2 and IW cases to kind of make that extra link on the national interest. Say, hey, not only is our person going to do XYZ resulting in DEF, but look, they're also going to create 15 jobs, 20 jobs, direct jobs, which will result in a downstream of 75 jobs, and they're going to help rural or economically disadvantaged or high unemployment areas in this way too. So we're just kind of having to try to get sophisticated, a little more sophisticated, and change the way we think about and approach these cases to kind of try to outthink the adjudicator, if you will. I don't know. It's, if you try the same thing and get the same result, then that makes no sense, right? We want to get ahead of the game.
Okay. Well, thank you for the answer, Rob and Philip. And Rob, you mentioned Elon. So I really hope that, he actually takes the national interest to the next level, but doesn't dodge it.
There's things that need to be dodged, Raji. Believe me, I was inside the belly. That could be helpful to us in the long in our interest and your clients' interests. So anyway.
Yeah, that could also happen. So, but Philip, I would like to come to you, and I would like to ask you. But what about the applicants? In the fields outside STEMs, like maybe arts or social sciences. How can they stand in their case to potentially the stricter definition?
Sure. Well, so applicants that are in the STEM fields, if we're thinking more, which I think USCIS and immigration law on a whole is going toward more of a merit-based system. We know we're pretty certain that under the Trump administration, it's going to be more merit-based. And so taking that into account, and taking into account the effect that might have on applicants that are in the arts or the education or social sciences, I think what we need to do is we need to have a clear, measurable benefit to the U.S. interests. We need to show evidence of these applicants' exceptional ability, and we need to show their national awards, their publications, their broad societal impact, how they're going to help the U.S. national interest. And so really the analysis is the same as any, STEM versus non-STEM, but we may just have to go deeper. As Rob mentioned, a key part is preparing this case as if we're applying for the big EB5 visa. And for anyone who doesn't know what that is, that's the big investor visa where an applicant needs to invest a minimum of $800,000 and needs to provide or create at least 10 U.S. jobs. That's a high threshold. And so I think part of the success that we've had with the EB2NIW petitions is that we take that framework and we try to apply it to these applications that have a lower threshold. But if we can hit that higher threshold, then that's great. And I think that's part of why we've had, and not just us, other immigration attorneys have been doing the same thing. But that's how we would show that a non-STEM applicant can contribute to the U.S. national interest and be successful with an EB2NIW petition.
But so, like, if you had somebody in the arts and social sciences, you just got to think, okay, what's a major problem? All these wars we've had in Afghanistan, all these soldiers that we've had come back with PTSD, and part of their plan is going to be, we are going to go out into the veterans community and help kind of, rehabilitate and I don't know what the word is I'm grasping for, but kind of ease the pain of these soldiers through the use of our art program or our social
basically like coping mechanisms.
Social sciences, sciences. So you gotta think about how you're gonna tie what would otherwise be, hey, this is just a great artist, this will improve our culture. If it was me, I would say, yeah, we're gonna do that. But they're also, like, I'm just making this up, we're also gonna help all the veterans with PTSD because we're gonna go out to them, do outreach to them as a way to help them ease and recover, from the pain, mental pain that they have still from being in war.
Yeah. Mm-hmm.
Gotta get creative.
Mm-hmm. Yes, Rob, you were saying.
You have to be creative. You're just going to have to get very creative in those specific areas. It's not going to be good enough, I don't think, just to say, oh, I'm great at social sciences or great at art. You got to think about doing some other things and tying in some other aspects that you normally wouldn't do, but that are important to the Trump administration.
Right. Okay, thank you so much for that insightful answer. Well, we really hope that national interest, doesn't become, whatever that makes USCIS less bored today. It doesn't change to that because, that also happens, right? So thank you so much for that insightful and detailed answer, Rob and Philip. Now, a lot of people are actually posting their questions. So before I take my questions, how about if we move to the viewers' question?
Sure, whatever. It's your show. You tell us what you want to do.
Thank you so much. Okay, Andre is here and he says, I am Brazilian, and he says hello from Brazil, and he says this rule is not God or good. I'm not sure what he means by that, but Okay, let's take Asim's question maybe. So Asim says, one of my friends applied for an EB2 NIW visa last year and got denied. He's now thinking of applying again, but the process seems more complicated with the new guidelines. Do you think the new rules are making it harder to qualify? And if so, what different should be done to qualify? Rob, let's start with you.
Well, like we've said before, Andre, the rules haven't changed. The way you approach the rules, you may need to change your approach because you don't see it. Your Brazilian friend doesn't see it because they just were a one-shot player, right? They just came up to the plate, they swung 3 times, and they struck out. You can retool those same cases, but use a firm like Rajni's or us or whoever you want to hire and rethink as to how they're being adjudicated now. What can we change differently? What can we change in your business plan? What can we emphasize more? And what different national interests can we try to hit and link to in a different way and maybe amplify the impact of your proposed endeavor so that you will be successful this time? Resubmitting it the same way you did it last time, you're going to get the same result, right? But the rules have not changed. The way they're implementing the rules have changed. So you got to stay current with that. You got to stay in the mind of USCIS. You have to stay, have your pulse, your thumb on the pulse of how they're adjudicating, not just your cases, not just Rob and Philip's cases, but the whole nation's cases. Mm-hmm. And it's not something that a layperson would know because they're just, just throwing it in there.
Yeah. We've got to. I agree with Rob. The guidelines haven't necessarily changed. The bar has moved a little bit higher, but again, EB2 NIW is not an easy visa to qualify for. Yeah. We often tell our clients that it is a superhero visa. We need to show how they are going to be a superhero to the U.S. interests. Mm-hmm. And so if it didn't work the first time, that's okay. We wouldn't discourage you from trying again if you can do it in a creative way where you can really bring to the forefront and highlight your experience, your knowledge, your record of exceptional ability.
Okay. Thank you so much for that great answer, Rob and Philip. Asim, I hope you have got your answer. In case you're looking for a follow-up, continue posting it in the comments below. Meanwhile, let me quickly take Sanjay's question too. Sanjay says, I have been told that supporting documentation plays a crucial role in the EB2 NIW process. Has the evidence required changed with the recent updates from USCIS? And if so, what kind of documentation is now essential? Philip, would you like to answer it?
Sure. I think documentation and providing the key evidentiary documents is key. It is key to an EB2 NIW application. And the biggest one is a professional business plan, a business plan that outlines every single aspect of the applicant's proposed endeavor. We need to show that they will contribute to the national interest of the U.S., that they will have a substantial impact, that they are that they're well placed to follow through and execute their endeavor. Okay, so a business plan is key, and maybe not stop there. In several of our cases, what we've done is, sure, it's a requirement. Any client that we work with, it is a requirement that they submit a professional business plan that is prepared by an independent company who looks at our applicant's record, CV, and is able to interpret that is able to create a professional business plan based on that record. However, again, we don't necessarily need to stop there. We can provide expert opinions. So in several cases, we have gone out and looked for U.S. experts on the particular industry or topic that the applicant would like to apply based on, and have those experts explain how the proposed endeavor would impact the U.S. national interest, how it would improve, how it would bring significant benefit to the U.S. interest.
Yeah, the average, to answer your question on paper, our average filings in these cases are minimum 500 pages up to 700, 900 pages. Okay, so yeah, documentation is important. There's critical pieces that Philip's already mentioned. Number one is the business plan. Number two is if you're advanced degree, obviously you have to show that. If you're not advanced degree and you're going for exceptional ability, you're going to have a ton of documentation to prove up because you're going to have to hit 3 of the 7 requirements, and you're going to have to do those through letters of reference, colleagues or people highly positioned within the government, business or academic sectors, as high up as they can, but they got to know you. They got to know your past accomplishments and what were the outcomes of your efforts, and then also give a really strong prognosis of your future, your potential, your potential energy, so to speak, because these aren't letters of you should give XYZ a job because they're a great person. No, these are letters of hyperbole, like to the maximum. This is the best person I've ever known. They resolved all these problems for this industry. It had an impact on the actual industry overall. And wow, what a great day when they become a U.S. resident, because they have the potential to take their proposed endeavor, shoot it to the moon. So yes, minimum business plan, letters of recommendation, and then all your paperwork you need to back up either your extraordinary ability or just your master's or PhD or your bachelor's plus 5 years advancing professionally in your area. And the thing I like about the expert opinion letters, those are kind of silver bullets. I mean, that doesn't mean you're going to win because of it, but they are very impactful because they're from industry experts in your area of expertise, totally independent. They don't even know this person. They're just reviewing the record and writing a professional opinion. Many times the CVs that they attach to theirs are like 20 or 30 pages long themselves for that particular expert. So, I mean, these are heavy hitters. The other thing I want to tell you is expect an RFE. You're going to get an RFE on everything. Oh my goodness, I got an RFE. I have a horrible case. I thought you guys said I had a strong case. That's not what they're doing. They're beating you down by attrition. So don't give them all up front, right? One of the strategies is to just hold back a little in anticipation of the RFE, because then when they bring the RFE, you still have some bullets in your gun that you can fire at the RFE, plus maybe go to some of these extraneous sources like an expert opinion letter.
Okay. Thank you so much for that answer, Rob and Philip. So no nepotism. It will all depend on the skills and right. So Sanjay, I hope you have got your answer. So make sure that you have all those documents ready that were mentioned by Rob and Philip, and you have to keep in mind that the nepotism will not work, especially not anymore. And yes, Rob is nodding. He's completely against it, right, Rob? Especially with the EB1A visas.
If you're talking nepotism as far as like reference letter, hey, if you can get a reference letter from Trump, you get that reference letter. We've had cases where we've gotten reference letters from presidents of other countries for the national of that country. So don't shy away from that. But it can't be just, hey, this is my niece or nephew, let them in. They got to know your professional abilities, your professional history, and your potential. So they got to speak professionally to that. It can't just be, well, Raji's a great person, so she should really be a resident. It's got to have some depth and substance to it.
Absolutely. And I think that's the reason why President Trump also endorsed, he said now if you are skillful and if you are adding to the US's economy, you will be eligible to get the green cards. And no longer because you are applying and because you are in the wait lines, you'll be able to get the green cards. Only you are skillful, and if you are, getting graduated from the good universities of the United States of America, you'll be eligible to get the green cards. Is that why he also endorsed that, Rob?
Yeah, I believe so. I think, I mean, I just read an article, it was a Politico, right?
Mhm.
Which is no friend of Trump or anybody on the right.
Right.
Yeah, so far left article basically saying, look, they are going to be looking for people with skill sets, especially in STEM. And sorry, I got a little off track. What was the question? Raji, what was it?
No, even I forgot. I was too invested in your answer. Even I forgot what I was asking. But actually, is that the reason why actually Trump endorsed, the skills?
Yeah, more of a merit-based system. And in reality, I'll let you go ahead and finish your talk on the article.
Yeah. So the article was saying, look, Trump is an Indian national's best friend because they have the skills, they have the intelligence. They're going to bring, they're going to bring the heat on the areas that he wants. They anticipated the biggest pushback is maybe a problem with Congress getting heat from their constituents because we've had so many problems in the U.S. with irregular immigration that I think people kind of got fed up with immigration and lumped it all together, whether it's legal or, irregular. And so Congress might be more of a problem than Trump and his cabinet. But yeah.
Yeah, and the thing with the merits-based system is, I think the benefit that I see to the way it's being laid out, or we anticipated it will be laid out, and how it was laid out during Trump's first administration is, I believe we're dealing with the merit-based immigration system as is. At least under the administration, is they're giving you the guidebook, they're giving you the blueprint. Here are the 10 items that we're focusing on, and here's how you can qualify under each of those 10 items. Whereas to me, it may be a little bit more laid out, a little bit more transparent versus what USCIS may have been doing in the past, where it seems more discretionary, right? So if it's more discretionary and USCIS decides, well, we'll put more weight on this one item versus this other item, a merit-based system that is clear, that is transparent, could do a lot of good for visa applicants who do qualify, as Rob mentioned.
It might be bad for us as attorneys because it won't be as complicated, but I think it's much better for the clients.
Yes,
because they maybe just have a scorecard, right? And I don't know. I think it's going to be good for a lot of people groups around the world. Others not so much, but for certain people groups, definitely.
And of course, and that's how it should be, right? If you have those skills, and if you are a merit-based person, and you should be eligible to get the green cards, and if you're adding to the US's economy, you should be eligible, to get the green cards. Whereas, but then, talking about Trump, that's a whole another conversation, because then what he sometimes says, then his actions are, completely against what he's saying, because, he wants to have the merit-based system for the immigrants. But then coming to his own team, he's picking Linda McMahon as the Secretary of Education Department. So, I mean, that's a little controversial, right? Robin, Philip, I mean, I know that's a conversation for...
Yeah, Rajni. He's a non-traditional politician, but still a politician at the end of the day.
True.
I won't defend him on that, but I do like Kash Patel and Vivek. I'm not gonna apologize for that.
Well, even I not just Kash Patel and Vivek Ramaswamy, but even Tulsi Gabbard and then Stephen Miller and then Tom Hooman as the border czar. I think those are some great picks, right? Whether you agree with his policies or if you disagree with what he says, but then some of his candidates are really amazing. And thank you so much, Rob and Philip. But I would again like to maybe take a few more questions. Hari is here and he has posted a question from LinkedIn. He says, I'm eligible to apply for this is actually for an H4 EAD. So would you like to take this?
No, we really shy away from giving case-specific advice to a non-client for ethical reasons. We don't know the facts behind their. If you want to speak generalities, it's fine, but maybe this one's not the greatest one. Yeah.
So maybe, Hari, what you can do is the details of Rob and Philip are scrolling below. You can directly, if you want to get in touch with them, you can get in touch with them, discuss your case with them. And yes, I'm more than happy to help you out, and you can, directly write to them. And let's quickly take Madhavi's question. Madhavi says, can you analyze the recent USCIS policy changes and court decisions impacting EB2 and IW visas and provide specific examples of how these changes have affected the approval rates and processing times for NIW petitions?
Well, I'll start. So sure, as far as the new cases, and so the biggest case that we've seen come out with EB2 NIW is the matter of Danisar case. That's what provided the three prongs that we've been discussing all along that gave it a more streamlined approach to the pre-Danisar era, which was guided by another case, U.S. New York State Department of Transportation, which that required, it was a little bit tougher under that standard because what it required was proof of national scope and specific labor market unavailability. That was challenging for many applicants. And so what Danisar did in 2016 is it now focuses more on substantial merit and national importance. So we were talking about work by an applicant that it has inherent value and can be important to the U.S. interests. So what we've seen is a shift from the focus of market unavailability to the applicant's unique contributions to the U.S. And how I think that has affected the EB2 and IW petitions is it has like we were talking about with a merit-based system, it is laid out. Now you have a playbook with specific guidance as to how you can meet those requirements and have a successful visa application. And what we've seen is there has been an increase in the rates of approval. It's still a tough visa, but we think now we have a clear standard under which to apply.
As far as the court decisions that was mentioned in the last question, one thing that I see all the time on our distros, one thing to keep in mind, the NIW piece is completely discretionary. Completely discretionary. You cannot challenge that in federal district court, the U.S. Supreme Court, whatever. You will get knocked out at the knees immediately on a motion to dismiss your case. So if you lose your EB2 NIW case and you want to fight them in court, for wrongfully denying your case, and if they made that decision based under the NIW piece, it's a loser case, we call it. So if there was other key legal factors in the EB2 qualification part, you may have a case to go forward. But the NIW piece itself, it's in the adjudicator's hands. I don't remember the name of the case, but there was a recent case that came out speaking to vice consul, the inviolability. I always have trouble saying that word. It's inviolable. You can't violate the vice consular's decision, right? They're the judge, jury, and executioner in let's just call it the B1, B2 context, but really in the adjudicating consular process cases. This recent case that came out totally strengthened that position. Before, there was a lot more challenges you can make to the consular decision, the vice consular decision-making process. But now they've been narrowed down tremendously, which was weird because just before that, there was a case coming out limiting administrative, the Chevron case, limiting the administrative ability of agencies to basically legislate upon, us.
Mhm.
So, but since we're specifically talking about this concept, the cases are against any type of appeal to a district court in a federal lawsuit context.
Yeah.
It'd just be a refile would be your
Yeah, and just to add to part of the question was how has it affected processing times? We've seen shorter processing times in general for EB2 and IW. As a matter of fact, right now, as of this morning, we're looking at 10 to 13 months processing time for the Form I-140 for an EB2 and IW case. And then, of course, you think if you do premium processing, which we've discussed some pros and cons about that, then you're looking to a shorter time period of 15 days. So what DataSart has done is it's created a clearer path to the EB2 and IW visa.
Mhm.
If there's one thing I can add to, when we file our cases, we always put for consular processing, even though we hope we don't have to, because you can always adjust status even if you put consular processing on the petition. All you have to have is your receipt number for the approved petition. And if you have a legal way to stay in the U.S. And your case and your category is current, then you can adjust status from within the U.S. If you have to run the gauntlet of consular processing, you're basically going to get re-adjudicated again by the vice consul. You already got adjudicated by the USCIS officer. But that's not the biggest issue. The biggest issue is it's got to run through NVC first in Washington. There's going to be administratively a couple months to get you documentally qualified. And then they just wait. And they wait for post to have an interview available for you. We have cases that have been ready for interviews since September 2023 and still have not had an interview date yet in that country. And I don't know what the case is in India at the embassies or consulates there, but in general, I think they're taking low priority on scheduling interviews versus the relative family member immigrant visa, which is means the most to Congress because that's the people that vote for them,
Right. Okay. Thank you so much again, Rob and Philip, for answering the question. Let me quickly take Trisha's question because she has also posted one question over here. She says, I'm considering submitting a waiver of job offer for the EB2 NIW visa, but I'm uncertain about how USCIS is viewing these types of cases under the new guidelines. Can you explain how they assess the waiver and what strategies might help to improve the approval odds in this area? Philip, let's start with you.
Sure. Well, with the NIW, of course, as we know, the benefit of applying for EB2 NIW is to waive the job offer, going through the perm process, which is, time consuming, a little bit, more expensive. So what we have to do is we have to show why it's in the best interest, why it's in the national interest to waive the job offer. And explanations of how the way we do that is we need to show that waiting for the job offer is not feasible or practical for this particular endeavor, for the proposed endeavor. We need to show that the applicant's skills and expertise, that they're highly specialized and they're not readily available in the U.S. workforce. That's another way to do it. And finally, a third example is we have to explain how waiving the job offer would accelerate the project's progress. If you make this applicant wait the 2 to 3 years, you're delaying this really important work that they can do in the U.S. So if you waive that job offer, what you're doing is you're accelerating that progress. You're accelerating the benefits that this applicant is going to bring to the U.S.
One other thing along that line on the whether or not it'd be in the best interest of the U.S. to waive the labor cert is to hit if you have a case where it's impracticable, like say this person, if they take a job offer at a certain place in this industry, will have a non-compete clause automatically because that's the industry standard. So they won't be able to benefit the industry as a whole. They will be pigeonholed into one specific employer, which will not help the national interest. So therefore, it's in the U.S. best interest to waive the labor cert. Or this person holds a patent on a widget that, it's impracticable because they own the patent, on the widget, and, no one else is going to get it. So let's bring them in and let's get them started and let's get them helping the U.S., thrive.
Okay. So, Trisha, thank you so much for your question. I hope you have got your answer. Now, Rob and Philip, there are a few questions posted in a Facebook group by our viewers. So, if you don't mind, can I share my screen and maybe take some of the questions from there?
Sure.
Great. Thank you so much. Okay, I'm quickly sharing my screen. Okay, can you see the screen? Okay, so this person, I think Javier, has posted that he says, I'm a Spanish teacher. I have applied for EB3 and IW I-140. Does anybody know if there is any possibility to be approved? What would you like to say?
I would say no, because there's no such thing as an EB3 NIW.
EB3. No, EB3. Yeah, we assume she meant. I'm going to assume she means EB2 NIW, and we like to say that no case is impossible, right? We would need more details, but speaking hypothetically, a Spanish teacher isn't automatically ruled out from an EB2 NIW. However, as we discussed earlier, you've got to be creative. We've got to show what experience does she have? How would she benefit the U.S.? In the U.S. here, we're dealing with an ever-increasing Hispanic population, right? And unfortunately, sometimes a lot of the Hispanic population is in underserved communities where someone like the caller, the questioner there, could potentially benefit the community. We'd have to show how does her experience as a Spanish teacher improve the U.S. economy, U.S. national interest. So again, we don't like to say any case is impossible. That could potentially be a tough case, but it's not impossible.
Yeah, I think if she's got especially if she can hit the advanced degree portion, I think with some creativity and a good business planner, you can easily weave that into a strong national interest argument because of the just like Philip said, the segment of our country right now of the Latino segment is humongous. Yeah.
Or maybe having the right attorney might help in cases like these, right?
Sure, that is key. Having the right legal team at your side to help you navigate something that complicated.
Right.
Yeah.
So,
sorry.
No, please go ahead, Rob.
Identify the need and then connect the dots. That's what you got to do. Identify the national interest and then connect the dots in the proposed endeavor. It's just very explicit, and I that one alone, I think I could come up with about 35 different ways that we could make a strong argument on her behalf.
Well, Javier, if you're looking for an attorney for yourself, maybe get in touch with Rob and Philip. The details are scrolling below, so you can note them down. And we are also going to, I'm also going to read out the details for you. So if you are looking to get in touch with Rob, you can give him a call on the number 512-293-3023. I would like to repeat the number, 512-293-3023. You can also email him. His email ID is robmelvin@melvinlawgroup.com. Rob Melvin at melvinlawgroup.com, and his website is www.melvinlawgroup.com. And if you're looking to get in touch with Philip, you can give him a call on the number, which is 979-776-1325. I would again like to repeat the number, 979-776-1325. 1325. You can also email him. His email ID is Philip, PHILIP at dosrodlaw.com. Yes, and you can also visit Philip's website, which is www.philiprodlaw.com. So make sure to get in touch with Rob and Philip. They'll be able to help you with your case. I know it will be a little complicated and a little tough in comparison to others, like Rob and Philip mentioned, but they are the experts and they are surely going to help you. Thank you so much.
Just to let your viewers know, Rajni, both of those telephone numbers for Philip and I are also WhatsApp numbers. So if you have any WhatsApp users out there, they can send WhatsApp messages through those channels.
Well, perfect. What's better than that? Rob and Philip are just a WhatsApp message away, guys. So get in touch with them right now. Right. And also, I have one question which was actually posted 2 hours back, and it is from a girl named Kripa. And she says, I have an approved I-140. I'm waiting to file my I-485. My current employer told me that they won't file my I-485. Can I change my employer for I-485?
Well, Kripa, it's not clear what visa you're talking about there, unfortunately. Because what we're discussing is an EB1A visa, which does not require an employer. So maybe some clarification would be helpful. As Rajni mentioned, if you'd like to, you can reach out to us, offline, and we can get some more information about your particular situation and do our best to answer your question.
Perfect. Let me take one last. Rob, Tamer says, does the premium processing affects the approval percent in the EB2? What do you have to say?
Back when I was young, it was the $64,000 question. Now it's the $64 billion question, right? Depends who you ask. I know some very well-seasoned attorneys, immigration attorneys, that have done tons of EB2 NIWs. They say premium processing is the biggest joke, the biggest waste of time, and it's just a throwaway of money. I know others that say it will actually prejudice you because you're putting heat on them. Remember, these are bureaucrats. I was a bureaucrat. You want to do the least amount of work that you can to get the day over so you can draw your check and build your pension. These are not go-getters. If they can kick you back an RFE in a premium processing case and then kick the can down the road, it's probably what's going to happen. I can't say it with 100% certainty that it will prejudice you. I've heard others speculate that it will. My opinion is they're worthless because of the retrogression. So why, unless there's some like insane pressing need to know the answer in 45 days that I would be glad to discuss with anybody offline. We try to talk our clients out of using it. Some people were so afraid of Trump winning that they insisted we used it. We used it, and they had to go through all the same stuff that anybody else had to go through. Thank goodness they were approved.
Yeah, and let's think about what premium processing does. What Rob mentioned is USCIS. You can't blame them. They've got a lot of work on their desks. And what we're asking them to do with premium processing is cutting down a 10 to 13 month process into less than 45 days, 15 to 45 days. You've got to think about what that does. If we had a project that normally takes 10 to 13 months and we had to cut down that short period of time, they may have a lot of questions. And so what that may lead to is a request for evidence. So again, you're going to get a different answer based on who you ask, which immigration lawyer you ask. But yes, in some cases, maybe premium processing is the way to go. But what we have seen is in the majority of cases, it may not be the value that people think it is.
In that vein, of all the comments I've heard on premium processing, and I've heard hundreds, if not thousands, I have never heard somebody jumping up and down saying, yay, I'm so glad I chose premium processing because it was so wonderful, and it was so beneficial to me. Not once.
But Rob and Philip, people are so scared of RFEs. As soon as they get the RFE,
They're
they
coming.
panic and go into that chaotic zone and chaotic mode. So but RFEs can sometimes also be helpful for their cases, right? So in situations like this, how should they deal with? I mean, what should they do, and how should they deal with that?
As Rob mentioned early on, you go into, and we always explain this to our clients, potential clients early on, you have to go into it expecting an RFE, right? What we're proposing for our clients oftentimes is a very complicated endeavor. They're highly specialized, they're highly skilled. So there are going to be questions about the process. So we tell our clients an RFE is probably going to come. Just expect it. What we do is we're going to be ready with additional evidence if we need it. For example, Rob mentioned the expert letters earlier. Those aren't required in the initial submission. They're not required. The business plan in most cases is sufficient. So sometimes some clients, in order to preserve resources from the initial submission, may say, let's not submit the expert letters right now. Let's submit the business plan. Let's submit the best initial submission we can. And if and when we get the anticipated request for evidence, well, then we provide that additional evidence. Like Rob mentioned, we keep a little bit back just so that we can respond effectively to a request for evidence and provide a clearer picture to USCIS of what our client is trying to do. So again, the takeaway is, in this visa category, a request for evidence is likely to come. Just be aware of that up front so that you're not surprised by it when you get it.
The only case that I can remember us having where there was no RFE was the proposed endeavor had a direct impact on the amount of filing fee income generated to USCIS at an exponentially humongous amount. For some reason, that case sailed right on through without any RFE. It was amazing.
Yeah.
Well, I think that's a great way to actually put it. You should go with the expectation that you will get an RFE. I mean, expect the worst and you will never be disappointed, how they say it, right? But thank you so much, Rob and Philip. It was so great having you both on our channel and on our show, Immigration and Jobs Talk Show. We had an amazing show. We were actually supposed to have this for an hour, but we actually did it for an hour and a half and we didn't even realize it. So thank you so much for being here. And even after doing it for so long, we couldn't even cover half of the questions that we actually planned for you. So maybe how about we do another episode on the same topic and we get into the depth of it.
Anytime.
Perfect. So guys, if you're looking to get in touch with Philip, you can give him a call on the number 979-776-1325. His email is philip@dosrodlaw.com. His website is www.philiprodlaw.com. So make sure you give him a call, WhatsApp him, email him, and also check out his website. And if you're looking to get in touch with Rob, you can give him a call on the number 512-293-3023. His email is robmelvin@melvinlawgroup.com and his website is www.melvinlawgroup.com. So make sure to get in touch with the both of them. And like they said, their numbers are also available on WhatsApp. So make sure that you also send them a text on their WhatsApp numbers. They are just a text away. So again, thank you so much, Rob and Philip, for being here. Any closing note from the both of you?
No, thank you very much for having us on. It's been a pleasure. It's an honor to be on this show. We know you have a lot of viewers. We know that your show is putting out a lot of good information to all of your viewers, and we're honored to be a part of it.
My only thing to say is, India, keep your chin up. It can only get better, and I think it's going to get better for you. I think you have a lot more people in your corner than you think you have, and I am very hopeful for you, not only just in the EB2 NIW category, but also hopefully bringing down the retrogression numbers and the weight that you have for your visas or your adjustments of status. So keep your chin up. Let's keep in there. Let's keep fighting. And we're here to help you out.
Thank you so much. Thank you so much to the both of you. Can't wait for the both of you to be back on the show with our next episode. And thank you so much again for being here. You both have a great day ahead.
You too.
Thanks. You as well.
Ciao. Thank you.
Guys, thank you so much for tuning in, and thank you so much for posting those amazing questions in the comments below. You can continue posting them whenever Rob and Philip are going to be back. Maybe we can take those questions and ask them in the second episode, or whenever they are back for the next episode, or maybe we can get in touch with them, write to them and get a reply from them, and we will post the reply in the comments below. So you make sure that you are continuously posting your question in the comments below. But for now, I'll have to take your leave. But you make sure that you are always tuned in to Immigration and Jobs Talk Show. So stay tuned with Immigration and Jobs Talk Show for every immigration update. I'm Rajni Bharara, your host, signing off for now. I'll see you very soon. Bye. Keep watching and keep subscribing.
All right.
Bye. Hi everyone, welcome to Immigration and Jobs Talk Show. I'm Rajni Bharara, your host, and before I move ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very, very important disclaimer, welcome back everyone. I am your host Rajni Bharara, and today we have the privilege of hosting attorney Ruby L. Powers, a distinguished leader in immigration law and the founder of the acclaimed Powers Law Group, PC, based in Houston, Texas. Ruby is a board certified immigration attorney with nearly 20 years of extensive experience in navigating the complexities of immigration matters, including family and employment based cases, asylum, and deportation defense. Well, Ruby's commitment to her clients is unparalleled. She combines her professional expertise with personal insights as a child of an immigrant. Her compassionate approach has earned her recognition as a respected author and speaker, with her insights featured in major publications such as the Washington Post and the New York Times. She has been honored with prestigious awards like the AILA Advocacy Award and has been listed in the Best Lawyers in America and Super Lawyers. In today's episode, we will delve into recent immigration updates, what's next for DACA recipients in 2025, and Ruby will share her insights on evolving landscape of immigration policy and what it means for DACA recipients moving forward. So join us for an enlightening discussion that promises to empower and also to inform. And now, without any further ado, let me very quickly give a warm welcome to Ruby because it's her first time on Immigration and Jobs Talk Show. Hi, Ruby. Welcome to Immigration and Jobs Talk Show. How are you?
Good. Thank you so much for having me. I really appreciate it.
Of course, it's a pleasure having you. It doesn't happen every day that we get a chance to actually do a show with you. So thank you so much for being here, Ruby. And now, guys, I would also like to tell you that Ruby will be sharing a presentation on recent immigration updates, what's next for DACA recipients in 2024. So without any further ado, let's get into that presentation. Let's listen what all Ruby has to say about the future for DACA recipients and what's going to happen in 2025. And Ruby, the stage is yours. Please go ahead.
Thank you, Rashi. I appreciate it. So this is a hot topic, and we also are going to take other questions. I'll just briefly go over this for those who this could be of interest. We don't know the future, but we can take a lot from the past and make some suggestions on what we think might happen. And so I wanted to share this, and you did a great bio intro of me. So thank you. Board certified law firm, 15 years old, Powers Law Group in Houston. I'll go ahead and keep going. So for DACA, the Deferred Action for Childhood Arrivals, it was announced in mid-June 2012. I remember that moment. And it came live only 2 months later in August 2012. And it really gave a hope and for many people who were brought to the U.S. Many of them didn't even know they were not U.S. citizens. I remember having many consults with those, finding out for the first time when this program came out. And it was a way for those to get work authorization, a status, and be able to be in the U.S. for 2 years at a time. And it's been a great program for these last 12 plus years. But the thing is that we've seen a lot of different litigation. In September 2017, under the Trump administration, he was challenging the legality of it, which, the long story short, is it went all the way up to the Supreme Court. And the Supreme Court said the reason why you're trying to get rid of it is not valid. So, but it didn't it didn't say you couldn't get rid of it. It just said the way you're saying the reason why is not good. And so then it was continuously challenged. And so basically from 2017 to now, it's been in litigation of some sort. And what that really means is that the people who were eligible to apply new DACA have not been able to since around that September 2017. And the thing is that you had to be a certain age to apply and meet certain requirements. And so many of those people who were just not old enough to apply before September 2017 have not been able to take advantage of the program because it's been in litigation, and it continues to be in. And so in 2023, a federal judge in Texas ruled DACA illegal, and then it went up to the Fifth Circuit, which listened to oral arguments not too long ago. And honestly, it hasn't given a decision. The Biden administration, which really only has about 1 month left, does support DACA, but they haven't been able to get a DREAM Act, which would make it more solidified. See, DACA is part of executive action from the presidential power, from executive order. And so that is the thing, is that we really haven't had immigration new laws in such a long time. And so that's really where basically what happens is that sometimes the presidents are making opportunities based off of their executive power, and then it later gets challenged in other administrations. But ultimately, we've been waiting for Congress to actually act and make laws that apply to immigration, but we haven't seen that in many years. And so as we've seen it, if the Fifth Circuit were to rule against DACA, we know it definitely would go up to the Supreme Court. But we have seen the circuit be more favorable to, anti-DACA and more favorable to Trump mentality. And we've also seen the Supreme Court rule not in favor of DACA necessarily. And so we think that what could possibly happen is that Fifth Circuit will probably say it's illegal, move it up to the Supreme Court. Supreme Court will either take it to be heard or not. But ultimately, the fact that right now all you can do is renew and advance parole is what you can do. You cannot apply new DACA. And if you look at the numbers, you can see that a lot of people are not in the numbers have dwindled since originally, it's because a lot of people have been able to move on to something else like legal permanent residency. And so we're a little confused as to what's going to happen, because there was a lot of talk, maybe even just a few weeks ago, with Trump, President-elect Trump, saying that he was not so favorable about DACA, let's say, especially in the campaign trail. But then just recently, it sounds as if he's more favorable. So that's really where the confusion lies, is that we don't know what to expect. So the DACA recipients are primarily from California, Texas, are living primarily in California, Texas, and New York. And there's about 500,000 right now. The oldest DACA recipients is about 43 and a half years old. Many of them are married with children in school. Some could even be a grandparent by now. And they've been educated in the U.S. by virtue of being eligible for it. And so we see a lot of, unfortunately, it's like they're having to, build their lives on their home on the sand, because they don't know what's going to happen. And many of them are have American spouses, American children, and have been living in limbo. So this is that contradictory approach. We're honestly confused. We don't know what to listen to, because we've also seen this quote from Donald Trump: "We have to do something about the dreamers. The people were brought here at a very young age." I've also heard about when I did a lot of advocacy in DC. I once heard in an office, they said that if we were to give a pathway to citizenship for DACA recipients, then it's a way. One sort of approach is that it's a way of rewarding the parents for bringing in children illegally, and because one day those children who could get a pathway to citizenship could petition for their parents, and so I think that's been one argument from the Republican side as to why they weren't pro Dream Act. But I haven't heard that out in the world very much in the news, but I've had, that did give me a way to think about different perspectives. So it's confusing, because what do you listen to? Is he pro DACA? Is he against it? What's going to happen? I mean, I think very likely it'll go to Supreme Court. Whether Supreme Court will take the arguments, listen to it and cert, I don't know. And I think that's where a lot of uncertainty is. But one thing that could happen, because they have the White House and narrow numbers, but in the House and the Senate, is they could try to put a Dream Act through. And I don't know why they wouldn't, if they finally could move it forward. So we'll see. I wish I had more certainty, but I think that's one of the things we're going to see a lot in this on this times, is that we don't know. What was said on the trail, is the campaign trail, is going to be done. What's not going to be done. I think one thing, just to be in a precautionary mode, is to go ahead and renew DACA maybe early. You're supposed to do like 150 days. Some people are applying even earlier just to make sure that they get it, because they don't know what will happen. Getting your documents in order, having a consultation, evaluating what your options are. And so that's really what we're seeing, a lot of people wanting to renew early. And we're also seeing a lot of people wanting to do the advanced parole, because one aspect is being able to apply brand new, and that you cannot do that right now. You cannot apply brand new DACA. And if you don't apply on time, if you have more than a year lapse between your DACA expiring and it's considered a new DACA if it's been more than a year, and you wouldn't be eligible for it because there's no new DACA. It's just renewals. And so that's the reason why it's so important to be timely filing. And the advanced parole is an option that gives people a legal entry, if you will. And the biggest thing to note is that you would have to have enough time on your DACA. You would have to have a valid passport that has enough time on that. And then you would have to have either humanitarian, educational, or employment reason. And then by doing that, you would have to have the proper information, evidence to establish that. Now, one of the things to note is that it's been taking about 3 months to get the advanced parole. And we only have a month left of this administration. So when the election results came out, some attorneys were saying, like, should we even offer this? Should we not? I think that as long as people understand the risk and consequences, then people should feel free to apply. But we don't know what will happen. We don't know if January 20th, he says no advance parole or something. But then again, the other thing I will say is it's important to note, where is the source of power? Is executive action, order? Is there a rule? Is it a law? Is it a policy interpretation? And honestly, this is huge, especially under the Trump administration, because then it gives you clarity as to how long and how it could be changed. Could it be changed with just the stroke of a pen by the president, or would it require a lot more action by multiple people or Congress? And so these are all the things to consider. And I think that's just a good takeaway in general as we analyze the future of so many things, including H1B, other visas, interpretations. So much of immigration is not necessarily because of a law necessarily. It's about interpretations and policies and different executive actions and orders. So this was just an example of the documents that would be needed. We're still filing for folks, but we are letting them know that we might not get approved in time, and under the new administration, we don't know what will happen. The advanced parole, so if a person hasn't already gone advanced parole, traveled and come back, then you're really on borrowed time right now, because we don't know what to expect. But if a person entered illegally, let's say one time, and then later got DACA, if they did have the advanced parole entry, then and they're married to a U.S. citizen, then all things being equal, no other complications, we should be able to adjust. We should be able to adjust them inside the United States, and so that's why that legal entry is so critical. And hopefully, people have already gotten it. It also can be helpful for traveling if we're going to do like a perm process and trying to do consular processing with DACA, which gets more complicated. I think one thing to note is that finding alternatives. So like there used to be almost 1 million or so DACA recipients, and now we're down to 500,000. And I don't think that many, it's because they had a DWI and they got disqualified. I think it's more because they were married to U.S. citizens. They were able to do the provisional waiver or the advanced parole, DACA belly, what we call, and were able to find a way to a pathway to legal permanent residency. The other thing would be is if they were the recipient or a beneficiary or a derivative of an I-130 or labor certification from April 30th, 2001. This is under the 245I provision. It's old. It would probably be because if their parent was a beneficiary and they were underneath it, potentially they didn't even have to be alive at the time. That could act as a legal entry. That gets more complicated, so I'd rather explain that in a consultation. Provisional waiver is still an option. The provisional waiver right now, but they were taking on a line. They're saying they're 4.5 years. The most recent waivers we got approved for 2.5 years. Just recently, we've seen a lot of approvals. Asylum could be an option as well, but the biggest issue is if you don't apply within 1 year of entry, you need to have an exception, change circumstances, exceptional circumstances, and being in DACA up until it goes away potentially, and then applying could be considered exceptional circumstances, but that would be something I'd say look at the moment. The other potential thing would be like military parole in place. If your spouse or child is in the military or was in the military or Ready Reserve or a vet, that could be an option. We also, during the Trump 1.0, I'm just going to call it that, the first administration, there was a lot of concern that the military parole in place would go away, but it never did. But I think I'm still going to bring that up because we don't know. There's also the U visa, which is a victim of a crime, but it has to be a specific a qualifying crime, and you have to get the certification. One of the things, a couple of things to note is that under Trump 1 is that he had said that judges could still deport someone even if the U visa is pending, which really gives pause because under Biden, they said, no, you can't be deported while it's pending. Just, there's discretion, but that's not going to be their policy. The other thing is that, what do you mean pending? Well, it's because there's only 10,000 visas a year. And there's a lot of demand since this program came out around 2008. And so it's taking about 10 or 15 years to get a U visa right now. And those are the estimates with the application rate plus the visa availability. T visas are not met as much, so it's a little bit faster. Like within a year or two, you can get them, more like a year and a half. But what those are sort of more of a unique thing. I think a lot of attorneys are screening better for those. You could be a victim of trafficking through labor, or the sexual doesn't have to be just one, but the labor could be like withholding payment, coercion, holding documents, and things like that. Cancellation of removal is when you've been here 10 years or more, good moral character, and extreme unusual hardship to U.S. citizen, spouse, parent, or child. That means it's more defensive. You have to be in court for you to proceed in that way. There's also special immigrant juvenile status, and that one is really more for younger folks and things like that. So it's a two-part aspect of family law, order, and then USCIS. I think just in general, what I'm telling a lot of people is that be prepared. We don't know step one, good, you're listening to this, good, you're looking into it. It's know your rights, know your information, know what your options are. Having a consultation with an experienced immigration attorney, I think, is so critical because I think a lot of times people just go with whatever they hear in the news, and sometimes that can be very sensational, and it's not specific to their situation. One of the best things that came out of DACA back, 12 years ago was that it got people going and having consultations. And I kid you not, some people were already eligible for things, but they didn't know because they didn't go to an attorney to evaluate, or they were given bad advice. And so that's what I would say is check the reviews, make sure that it's a reputable person, attorney, make sure that they've had cases similar to yours, that they've had experience, and if anything, go get a second opinion. As well. It doesn't mean you don't trust them. This is your life and this is important, and you want to make sure that you have the right information that you're making that decision. And then write down what is being said, so that way, if some key facts were to change later, or laws or interpretations, it could mean that you might be eligible for something later that you didn't know about. So it's important for everyone to know what their rights are. And I mean, for those who are in the U.S. and don't have a status, it's important to have children or spouses, having guardianship arrangements, having wills, having documents in order. I think having the taxes and civil documents scanned in one place so that someone could quickly email that to an attorney if they're hired, if the person's detained or held. Having the key numbers ready so that someone else can jump in action, such as maybe calling a lawyer that's been like pre-screened, and that maybe they're not hired, but at least the lawyer knows about the case and has document. For example, all my consultations, we keep notes and we have an intake. And so if someone were to call later, which, the firm's 15 years old, we can quickly pull that information, start from there. That helps us to be able to move forward, especially if there was something we had to act quickly. And what I mean quickly is that if a person is detained, if, for example, they have a prior deportation order, like even just in the news, there was a woman with a deportation order and 2 U.S.-born twin children that are only a few months old, and she was deported. And so, there could be options with stay of deportation, having ways to do cross-control discretion, but that's what we know now. But in the future, a lot of those things are going to change and be a little bit harsher from what we're hearing in the news and from Trump's campaign policies and promises. So we'll see what happens. And I think having a few trusted sources that you can always go to and stay up to date. For example, we team up with a lot of the consulates and nonprofits so that we're finding out about things maybe before some things are out there in the news, and that can help us give that information to our clients. But also we put out a lot of content in our on our Facebook, our X. We're also on Blue Sky as well, Instagram and TikTok. We regularly have a lot of content. And we also have a newsletter in English and Spanish that is out there, and we just summarize the key points from those 2 weeks at a time, so that way it's sort of a digest, if you will, of what the key things to know are. So there's information about how to reach us, our rubypowerslaw.com and our number. But for the most part, that's more about what's going on in the DACA. And it looks like we got a lot of questions too. And we can talk about non-DACA things as well. But if anyone has any questions, I'll do the best I can.
Thank you so much for that amazing presentation, Ruby. It really helped a lot to understand each and everything about DACA. So guys, if you have any questions from Ruby that you would like to know, that you would like to get an answer of, so please make sure to comment down, make sure to post your comments in the comment section, and we'll be taking your question. Also, you can give us a call on the number 425-436-6335, and you can put the access code, which is 988888. Yes, make sure to dial this number and put this access code, and we'll put you through. Thank you so much. And Ruby, I would like to come back to you, and I would like to ask you a really controversial question related to DACA, because some people who don't side with DACA and who don't favor DACA call it a way to support illegal immigration, right? So, but what do you have to say, and what do you think? Does DACA encourage more illegal immigration, or does it provide like a humane solution for integrated young people?
That's a good question. So I see both sides, having even mentioned that what I had heard when I was at a Republican senator's office about why there's some pushback to having a pathway, because what they were saying is if we were to give green cards and citizenship to DACA or Dreamers, that there's no restriction on petitioning for their parents. Like with the special immigrant juvenile, you sever parental the relationship, so therefore you can't petition for the one that is the one you sever from. But with this scenario, you couldn't put a pause. I think the way I look at it, there's a way I look at it, there's way different, there's a whole spectrum, right? Is that the children were brought here with no control over anything. In fact, like I said, some of them thought they were US citizens because their parents didn't tell them otherwise. And then to wake up one day and find out that they don't have a status, like this was, just a wonderful gift that helped quasi remedy the dilemma, because when I say quasi, because it's still in limbo and it's been pending 12 years. And unfortunately, the people who were too young to take advantage of it by the time Trump, paused it in September 2017, haven't been able to take advantage of it. And they are still very much dreamers outside in the world. I think it's a humanitarian quasi solution for something that we should have given more of a permanent solution. I think when you do things like this to fix problems, it can appear from like one perspective that you're encouraging illegal entry or unlawful presence in the US. But the reality is that they were so stringent on the requirements, like you had to be here by this date. It was like 5 years before the eligibility, and you had to be this age, and you had to go to this school or do this program, And in fact, a lot of people, when I still talk to people, I'm like, why don't you have DACA? And they're like, oh, I didn't do this school, or oh, I didn't have enough evidence, or oh, I came 2 weeks or 3 weeks too late or something. And there's still a lot, what we still call dreamers, the people in theory, the large group, and then the DACA recipients are more of a smaller section. Anyway, I'm more of the pro-immigrant side, and that I really think the U.S. should still do something more. But I'm glad that
I think as everyone should, because America is the nation, U.S. is the nation built by immigrants, right? So people should be pro-immigrants. But then, how do we? Is there a way to, Ruby, also balance national security concerns with humanitarian considerations for undocumented youth?
Yeah, there is, but like, let's just go on DACA, for example. If you get a DWI, one DWI, you're out of it. You're
Yeah.
out. You're out of the running. I mean, like TPS is easier than DACA. DACA, you had to have, if you had more than like a few misdemeanors, you get kicked out of TPS, but they didn't specify DWI. I mean, like one DWI. I mean, I'm not saying that you should have that, but like that's an example of something that could put people in danger. Like you get one, you're dead, you're gone, on the DACA, for example. So like it is really stringent. And the fact that a lot of them have been in the US for so long, I mean, the DACA recipients that I know, they're like stellar, community members. Yeah, there's always the concern about, security. I used to work for the Committee on Homeland Security many years ago in DC. That's always a concern. But I think that the Dreamers are really a subsection of those who are, quasi-American citizens in a way, because they've been here so long, and in the culture. And I think that's what makes it so much easier for them, to marry U.S. citizens. And it's almost like they're already citizens, but they just don't have the document to prove it. And I'm not saying DACA recipients are U.S. citizens, but because we don't want to say a false claim. But I'm just saying, like, culturally and educated and things. But yeah, there's always the concerns. But I think that they're not the ones that are the most prone to the issues that we would need to be as concerned about.
Right. I mean, also they don't know any other way, right? Because they have been there since the time they have been on this planet. So, well, there are still so many controversies and so many things surrounding DACA, but hopefully it's going to be better for the DACA, recipients. But also with that, and for the Dreamers, of course. But Ruby, I would also like to know from you that people are really waiting until the court gives its decision, right? And it's going to happen in 2025. And now that the new administration has taken power or has come into power, not many people are, people are a lot more stressed about what's actually going to happen now, right? Because though they say that they are favoring that, but nobody actually knows what might happen. So I would also like to know from you that what role does the public opinion play in shaping the chances of, things coming in favor or things going against it?
I think it's huge, and I think that's where we need to consolidate our power in that. I'll give you an example: family separation, the zero tolerance policy of like the summer of 2018, when it was happening even a couple of months before, but it really wasn't. People weren't piecing it together. People didn't know what was going on, and it wasn't until about mid-June when the reports were starting to get to the reporters, and they were piecing together what was happening. I went down to the border Port Isabel detention facility, and there weren't a lot of attorneys that were there initially because they didn't know the pro bono attorneys. It took a little while to get there, but they were there soon after. I did like 5 or 6 interviews. I don't know, it was a ton of media, and that day after meeting with all those parents who had been separated and had no idea where their kids were, completely traumatized. And within like a day or two, Trump reversed the zero tolerance policy, and ACLU had the lawsuits that forced the government to put the kids and the parents back together again. And they had a deadline to get them all together within a couple of weeks. But for the public outcry, that wouldn't have happened. And that's really what taught me the importance of maybe you don't have the House, and maybe you don't have the Senate, maybe you don't have the White House, but you do have public opinion. And that's where we need to rally together if something is completely egregious. And I mean, we've even just seen recently, I think the last day or two, like tech companies are trying to rally Elon Musk and Trump to have more help in the H1B or the skilled worker visas, because they know that there's such a shortage and they need help to fill those needs. So they're using media, they're using their connections to try to get that attention. So, those are just a couple of examples. And I think we need to band together. And that's really, as an immigrant advocate, having to use media is to get out there, the stories out there is so critical.
Right. And it's only because of the public opinion and public views why the new administration came in power, right? I mean, very well put. Thank you so much, Ruby, for your answer. And now also because, nobody's really sure that what might happen in the next year, what decision might come. So if it is negative, do you think that the DACA recipients should consider like alternate visa options or pathways to permanent residency?
Yeah, so that's the reason why I put that in and I see a couple of really good questions. I think we're sort of on topic right with what we're saying right now. That's the reason why I put the alternatives there, is because like I mentioned, there used to be about 1 million, now there's about 500,000, but a lot of them it's because they got the advanced parole, they were married to US citizens, or they got the provisional waiver and they're going that route, something along those lines. So I think the best scenario, or some of them have perm cases pending, and are trying to do the D3 waiver. And so what I would just say is that, yes, try to have a backup plan, be working towards that if possible for legal permanent residency. One of the questions was how quickly could, when the new administration takes office, which is January 20th, how quickly could DACA protections be reversed or strengthened?
Yeah.
Should we expect immediate changes? Well, again, Fifth Circuit still hasn't made a decision. Then we've got the Supreme Court may or may not take up the question at all. They might just not even take it up. Supreme Court also sort of has their own schedule. So usually their decisions come out in mid-June, depending on what happens with the timing there, but what we have heard is that Trump is planning to have hundreds, I don't know how many, like a lot of executive actions and orders on day one. So I think that goes back to what I said, where does the power lie of the thing that we care about? Is it in a rule? Is it executive action? Is it order? I mean, we really can look to the prior Supreme Court decision as well and what was done since then. There's also talk about would there be, if they were to get rid of DACA at some point, and again, we're still waiting for the Circuit, potentially Supreme Court, right? So you can't just completely get rid of it. They still have to go through the process. But what would there in the future, let's say it does go away, would there be like everything goes away this day, like the day your card expires, or would it be like a generous, phase out period of, I don't know, a year or something like that? All of those questions have been sort of circulated amongst the, immigration attorney community, and we're not sure what the answer is going to be. So, but I think it helps at least to think about those possibilities. But bottom line, if you have DACA, be thinking about what your backup plan could be if you could move to something else. And we also don't know what new things will come up. But what I will say is that Trump 1.0 got rid of about 50% of the legal options for immigrants. And so what I think what will happen is that a lot of the paroles that came out, a lot of the discretion that came out under Biden, I think a lot of that's going to go away. And I wouldn't be surprised if advanced parole were to go away for DACA as well. So there's another question, like, I want to travel to see my family, but I'm scared it could affect my DACA.
Yeah.
I think that you should, if you want to apply for it, if you have your enough DACA time, enough passport time, enough, and get that advanced parole out, see what happens. I know it's like, I'm telling you, see what happens, but I mean, the thing is you don't know until you try. And I know it does take resources, filing fees and money and things like that. But who knows, maybe you could get it really quickly. Maybe there's no harm to it in the future. There was, I think Cornell University sent out, this was like about a month or so ago, a note to all their students. And they said, if you're going to travel, come back by January 20th.
Yeah.
And so I think when we heard that, we're like, oh, okay, we should tell everybody the same thing. I mean, honestly, remember when Trump went into office, there was the Muslim ban like that first week. And I remember trying to calls from friends and clients saying, my husband's mid-flight, what do I do? So that's why we're saying try to get your travel done by January 20th, because then we'll all sort of like hold down and figure out what's going to happen after that. I don't know. There's what we know and what we don't know. I can just tell you from experience and having gone through Trump 1.0, and then you have to make a decision for yourself.
Right. I mean, everybody's really stressed out and people are really worried what might happen, because the 1.0, everybody saw what all happened in the 1.0, and now they're really scared because he and his administration has gone out there and said each and everything what they're going to do. So now people are really worried. So, but we'll have to see what might actually happen, what might actually take place. And but I don't think so. But Ruby, before I take our other viewers' question, I would also like to know from you that people are really into this chaos mode and have gone very chaotic. So to help them, understand things, what would you like to tell them, that how should they ease it? And I mean, and be like not go into that chaotic mode and like be a little calm down.
Well, I think the best thing would be to, because see, fear is a paralysis. And that's what I really became so evident when I was at the detention facilities during the family separation era. And that was what it was done intentionally. It was done to cause chaos and fear to the parents as a weapon of emotional and distress. And unfortunately, that's a lot of Trump's modus operandi. He says a lot of different things, and then you don't know which one is he going to do and which ones he's not going to do. So I think there's a little solace in the fact that we've gone through one administration, so we have a little bit of an idea of his playbook. But I think he's had 4 years to get more organized, and he has got Stephen Miller in a higher position. And I think we're going to see a little bit more laser focus on whatever their intentions are. So I guess what I would say is know that they're not going to do everything. Some of it is hot air and a fear tactic. Having a consultation, second opinion, having your documents in order, trying to find good self-care coping mechanisms where you don't let this consume you. Yeah. And know that in theory, this should only be about a 4-year situation. Again, the judges he puts in place, the policies he put in place can last longer than 4 years. But when there's still a room for litigation. And in some cases, that litigation can stall for years as well on different fronts. So I think that's another thing to give you a little bit more pause and to know. It's just that the uncertainty, I mean, I've had a lot of clients tell me, I can't eat, I can't sleep, I'm losing weight, I'm doing this, I'm doing that. And I'm like, I'm trying to just give them as much positive, let's look at whatever positives, and that, listing off what you're grateful for, the gratitude, I think exercise, I think that's really a lot of what we have to do in this next administration.
Thank you for that positive answer, Ruby. And let me quickly take Girish's question. Okay, Rahul is here. He says, thank you, Ruby, for your answer. And then Girish wants to know that any changes expected to U visa under Trump administration, any chance of removal of bona fide determination review process? What do you have to say?
I think, I don't know if I should say this out loud, but I think, okay, if you were just to think, how can you make lives worse for immigrants? And that would be one. It would be get rid of the bona fide determination. I don't know. Will you do it? Will you not? I mean, that was a great program that came out a few years ago, letting people have that work authorization while they're waiting that 10 or 15 years. I hope he doesn't get rid of it. I don't know what he's going to do. But if he were to say, how I want to make things worse for immigrants, who are especially U visa applicants, that would be something that would probably be under his playbook. The other one I mentioned before is, saying that just because you have a U pending doesn't keep you safe from deportation. I think that is an easy thing he can tell judges, and then they would have to not use it as as a form of relief that could keep them here. So I don't know. I hope he doesn't get rid of that, but it's probably fair game as a possibility.
Okay. Well, Girish, I hope you have got your answer. Thank you for your question. If you have a follow-up, please continue posting the question. Meanwhile, let me take this other question. This is not related to DACA, but still I would like to take this. This is actually about H1B. So ZQ says, is there a possibility that the H1B visa program will be scrapped? I think I saw something about it here in another show.
Well, I don't think so, but I think he might make it more stringent. So let's go back a little bit. One thing that Trump did for H1B, I mean, he did a lot of stuff with H1B and employment based, but one thing he did was he created that registration process where the company just puts like a little form, it's not that difficult, and says, hey, I want to put my hat in the ring for this applicant. And so then, then it was like a lottery, right? Chosen. And then only if you were chosen, then you would put the whole packet together. In reality, that made it a lot more cost effective for the companies, I guess applicants, and it was a lot less work for attorneys, because before we had to submit it for every single person, and then they would take the lottery from all the packets. So actually that was one thing that was more efficient. And then there was a lot more streamlining over the last couple of years as well. I don't think he'll get rid of the whole program. I think, and actually just like 2 days ago, there was DHS was strengthening the H1B program. That's announced a final rule that'll go into effect January 17th, conveniently, 3 days before the new administration goes into effect. I don't think he'll get rid of the entire program. I think he'll get a lot of pushback from business. But I think he could make changes that make it a little bit more difficult to try to, I don't know, in his mind, protect certain U.S. workers. But I think there's a way to have a win-win where you're protecting U.S. workers, you're protecting the U.S. economy by allowing us to bring in skilled labor, and you're still allowing the H1B program to flourish. So that's my answer.
Well, ZQ, I hope, I think that's a great answer. And ZQ, I hope you have got your answer. In case you have a follow-up, please continue posting it. Meanwhile, let me take the question from Vikas we already have taken, Anusha. So Anusha says the Biden administration announced new rules in 2024 that affect DACA recipients. Eligible DACA recipients can get healthcare insurance through the Affordable Care Act starting November 2024. A new policy on D3 waivers will help DACA recipients who have earned a degree in the US and have a job offer in the field of study to get work visas faster. What, according to you, will change in these rules?
So the have a job offer. I don't know some of these rules. I mean, there's a lot of new things. I think right now Biden is trying to get some things out like right now because we're like a month away, But what I've also seen is that a new administration can come in and find ways to try to reverse some of that activity. So I think it goes back to where's the source of power or where's this and how quickly could something be reversed. And so I think that's more of that's probably my answer. So we're just going to have to do a little bit of a wait and see right now. But one thing I will say is that when you do get a new administration, a lot of times it takes, some things can be almost immediate. And then for the most part, it took almost 3 to 9 months to change a lot, for Biden to change a lot of the Trump policies. It's almost like, turning around a cruise ship or something. Like you've got a lot of, bureaucracy, you've got a lot of operations, you've got a lot of training, and you've got to like move things, around if you are going to do that, like about face. And so, and it's also about prioritization. What is really his priority? You hear a lot of talk about mass deportation. that seems to be a thing that was in the news a lot. I think now that we're getting closer to H1B season, we're getting some of these rules from the Biden administration, where I think, and also the tech market is trying to advocate for more H1B, skilled labor visas. I think that we're starting to hear that, but we don't really know what to believe that he's going to prioritize and what he isn't going to.
Yeah, only time will tell. But still, thank you so much for your question, Anusha. I hope you've got the answer. If you have follow-ups, continue posting them. Even after the show is over, we'll still try to give you an answer. We'll share the questions with Ruby, and we'll try to get an answer from her so that we can, reply to the comment. And now RK is also here. RK says, could we see more regulation to restrict immigration, such as removing H4EAD, removing DACA, wage-based H1B, remove the CBP1 app, etc.?
Yeah, I think a lot of that's fair game. I don't want to cause, fear, but the H4EAD was a huge win, right? It was huge.
Mm-hmm.
But it took forever to get that. And I think that would be a way, if you were in the playbook of how can I make immigrants' lives worse, that would be one. Getting rid of DACA, that would be another. So a lot of, it's like a death by 1,000 cuts. Like, how can I find a whole bunch of ways to mess it up? I think that's fair game. I think there's like a list. I'm sure they have. Steve Miller, somebody has a list. And they're like, okay, which ones can we do day one? Which ones are going to take a little more effort? Which ones should we focus on? So I believe that as we get closer to January 20th, we've got to sort of filter through the media and the news of what their Homan and Steve Miller or Trump are saying, as to sort of try to get in the mind of what they're going to do. But that's sort of the way I'm approaching it. And then in the way, like, if you anticipate, it's just like trying to mitigate risk. If you say, like, for example, there's hurricanes in Houston. What do? What's your hurricane plan? What's your flooding plan? Or there's a freeze. If you think about how are you going to mitigate the risk or minimize the amount of damage, then that's the best way to look at it. It's almost like we're in defensive mode, right? Like, I think under Biden, we were really proactive, offensive mode. We could do stuff. There was more options. And now we're going to get back to defensive mode. And we need to be ready to think through what would we do if that were to happen. And then if you think through what the worst case scenario, then it gives you that power because you've had time to think through and you can start visualizing how you can try to find a backup plan for that.
Right. But Ruby, is there a possibility or are there any steps that Biden administration can take to mitigate the impact of an favorable ruling?
On which thing? On the DACA or which thing?
Yeah, the DACA. Yeah.
Well, like we mentioned, Trump's been very inconsistent, and just recently he sounds like he's a little more pro DACA this last week or two. I've literally been shocked. Even I've talked to non-attorneys about it, non-immigrants about it, and they were shocked too. I think in the wild scenarios that could happen, what if they were to actually pass a DREAM Act? It might not look like the DREAM Acts that the Democrats were proposing. But if they have the House, the Senate, and the White House, what's to keep them from doing that? It might be more restrictive, might be more limited. But I think you got on one hand, Fifth Circuit says no, Supreme Court says either no or doesn't listen to it. And Trump says, let's get rid of this. Depending on the arguments, though, is there any more room for litigation? I think that's the other question would there still be room for litigation that could tell you whether or not there's room for more delay or not. The other scenario could be, maybe it's wishful thinking, but let's go there, is they pass a DREAM Act, and then woohoo. But it could be more limited so that it doesn't encompass all the DACA people. And that's one thing that we have to remember, because under the Democratic DREAM Act, it encompassed more than just the DACA recipients, and that was what was nice because it was a bigger pool because there's so many dreamers who haven't been able to take advantage of DACA.
Right, right. This takes me to this question from the viewer, Nidhi Sinha. She says, I have been a DACA recipient for years now, and I keep hearing about challenges and potential reforms. Should I be worried about losing my status in 2024? Or is there any hope for permanent protections this year?
Well, I think it's related to a lot of what we've mentioned already. Find a backup plan. We don't know what's going to happen to the Circuit Supreme Court. And there could be a hard stop or there could be a phase out period. It could be stalled with litigation. And, like we said, Trump seems to be more pro DACA right now, but we don't know if that's going to be the long haul. So, and I think one thing to ZQ's question up here about is the new government going to be very unpredictable. I think we got to know that there's checks and balances, right? There's the House, the Senate, the White House. There's a lot of lifelong bureaucrats who've been doing a lot of work, government workers in this space, and there's and the Supreme Court, and public opinion and voters, and just because a president's in for 4 years at a time, there's the House, which is in 2 years, and so that's where people really voice their opinion as well. And so I think the government is stable. It's just the unpredictable part, I think, is really on on Trump's policies is more of some of the quasi unpredictability. But we do have a little bit more of a good playbook because of how we've seen him be the president before. So.
Right. I mean, well, talking about Trump, he has always been unpredictable. And so we can't, ZQ, to answer your question, Ruby has already answered it, but thank you so much for your question. Let me quickly take Nidhi's question because we don't have much time. Nidhi says, moreover, what can DACA recipients do if they believe they have suffered discrimination in the workplace due to their immigration status? What do you have to say?
Well, I think this is a employment law matter that's not in my purview. I would say have a consultation with an employment lawyer and explain and go from there and see what happened. There was a deferred action for labor violations under Biden that came out a couple years ago. But I think you're better off exploring the employment lawyer first and then seeing if that other option is still going to be available. But that one is to help give people a status if they don't have one while they're waiting for possible investigation and litigation. So, so I guess we have maybe one or two questions, or we're almost at the top of the hour. I don't know if we
right. I would also like to know from you, Ruby, that are there any, because, I'm sure a lot of people, and especially the DACA recipients, they want to know what legal resources are available for them. So if you can please mention, are there any specific legal resources or organization that DACA recipients should connect with for support?
Well, I think, let's see, there's I'd say, you can always look to the American Immigration Lawyers Association, AILA, for information, reliable resources. They also have a directory for attorneys. There's a lot of different groups that support dreamers. I don't have one specifically. Sometimes some of them are more regional as well. I would say that it is good to frequent the ACLU website and for know your rights and seeing what they're up to in terms of litigation, the American Civil Liberties Union. And then one thing I think is going to happen under Trump 2.0 is that the advocacy groups are going to do more of a divide and conquer approach for litigation, like federal litigation, so that we're not spread thin all over, but we're more of a targeted. So different groups are going to take different litigation and to be able to divide and conquer. So AILA is a great resource. ACLU is a great resource. And then having having a good consultation with an experienced immigration attorney and a second opinion, I think are all really good advice.
Okay, thank you so much for answering that question. Ruby, one last question before I let you go. So, because I know we have already talked about it, but any last suggestion or advice for the DACA recipients? What strategies should they consider to protect their legal status, given the ongoing litigation?
For all statuses, I think, or for DACA,
particularly for DACA.
Renew early if you can, probably. That would be smart. I've already gotten your advanced parole, hopefully, if you didn't enter legally, and have a consultation to evaluate what your backup plans could be, whether it's through if you're if you're married to a U.S. citizen, if you have a 21-year-old American child, if maybe your company wants to sponsor you. Could you maybe switch to some other visa? It's really important to know how much unlawful presence you've had, and your entries and exits. So it's all connected. I would just say consultation, find a backup plan, evaluate, know what your rights are, and continue to monitor the news. But I think of all the communities, DACA recipients and dreamers really do have a place in a lot of Americans' hearts, and I think that they will. I'm hoping that it will continue to prevail in some respect, and that if not, maybe in this administration, in the future. But I mean, it does give me hope that probably 500,000 of the DACA recipients found another way. I think many of them did, to a pathway, and so I think by having had this status, being able to have the advanced parole, more time here in the U.S., I think it's allowed them to have more options. And so I think that's just that having backup plans, knowing your rights, and continuing to stay abreast of the news and reliable sources, and making sure that you're not getting into that, that sensationalism that sometimes can happen. So making sure you're level-headed, trustworthy resources. And I mean, I'll just say, we do have a TikTok, Facebook, Instagram. We're putting out a lot of content out there all the time of just I don't know if I could show that screen real fast, but we want to be a resource for the community, even if you don't become a client, because we know that the information is power.
Right. Thank you so much again, Ruby, for all that information. It was so great having you. And guys, if you want to get in touch with, I think Ruby wants to share her screen, and also show you the platforms they share the content in. So Facebook, Twitter, and then Instagram, TikTok. So make sure that you follow all these platforms, Blue Sky. So make sure that you follow all these platforms, and yes, get yourself updated with everything that is going on in the immigration world. And with that, you can also, of course, subscribe to Immigration and Jobs Talk Show, because we come up with these shows and we make sure that you are updated with everything that goes around in the world in the immigration field. So thank you so much, Ruby, for being here. And guys, if you want to get in touch with Ruby Powers, you can dial the number 713-589-2085. I repeat the number, 713-589-2085. You can also email her. Her email ID is contact@rubypowerslaw.com. And you can also visit her website, which is www.rubypowerslaw.com. So make sure to get in touch with Ruby for anything related to DACA or any immigration-related cases of yours. But thank you so much, Ruby, for being here. It was so great having you. I mean, it was your first episode, but I really enjoyed this doing with you. I hope you can be back soon. Thank you so much for being here.
No, I appreciate it. And I'm glad to get all these questions. I want to be a resource for the community out there. Really great questions. Really made me thinking on my toes. Rajni, thank you so much for having me and the team. And yeah, let's do it again. Love to be a resource.
Thank you so much. Thank you so much for your kind words. And we are hopefully will be having you back, I think, now in 2025 next year. So until we meet again, happy holidays, happy New Year, and Merry Christmas, Ruby.
You too. Thank you.
Thank you so much. Guys, thank you so much for joining us on this amazing webinar. We are going to be back with Ruby with another great webinar. So make sure that you subscribe to our channel for all the updates, everything related to immigration and all, so that you receive all the updates regarding the shows with Ruby that we are going to do. So make sure that you subscribe to our channel. And for now, I'll have to take your leave. Wishing you all happy holidays, Merry Christmas. And also, I'm going to be back before that too, but still wishing you that. But for now, I'll have to take your leave. Bye for now. Take care. And always keep watching and keep subscribing to Immigration and Jobs Talk Show.
Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm very happy to have you join us. And before we start off with today's show, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Thank you so much, folks out there, for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and on X. So please feel free to join us, by commenting, especially with regard to our topic of today. And before I tell you who's going to join us, you can also join us on call by dialing this number 425-436-6335, and the access code is 988-888. And once you're in, you just say hello, we will be able to hear you. So, folks, today's topic of discussion is Trump 2025. Who's on his new team and what does it mean for America? I know there has been a lot of discussions and news on this. Every day you hear something about Trump's team, and we are all excited to know what's going to happen once Trump returns to office. And, I'm very, very excited because today we have a truly distinguished guest joining us, someone whose name resonates in the field of business and immigration worldwide, by the way. And so, ladies and gentlemen, it is an absolute honor to introduce Charles Cook. Thank you so much, Charles, for joining us. And
Charles, thank you very much for having me.
Thank you so much, Charles. This is probably our second time, and I'm very excited that we're going to have this discussion today.
Well, I'm looking forward to it because nothing gets the blood going more than talking about Donald Trump.
I know. Passion comes running in, right? Both ways. So, Charles, folks out there, Charles is a globally recognized business and investor immigration attorney and a fierce advocate for sensible immigration reform. So, I'm sure it's going to be awesome if you could join us, especially with your questions. You can comment or call us. And, Charles, maybe tell us what's going on with you these days.
Well, with me, we're in the United States, we're getting ready for Christmas, hence your Christmas theme. And it's of course a great time to be alive. And I'm looking forward to my grandchildren coming to my farm this weekend and having just a wonderful and joyous time.
Absolutely. I'm sure. Will you be playing Santa?
No, I'm not big enough to play Santa. I don't want to ever get big enough to play Santa. But if my checkbook counts, yes, then I'm playing Santa. It just depends on how you approach it.
It works. I'm sure it's going to be very exciting. And here's wishing you and your lovely family a happy Christmas season, happy holidays, a good time in your farm. And I'm sure it's going to be awesome with you.
Thank you. It's going to be a good time. But we have to get back to the topic at hand, don't we?
Yes. So
you probably
what can folks out there expect?
You're probably not aware that even though Trump doesn't become president until January 20th, I believe.
Yes.
He's already basically acting like the president. And we literally are in our very first, right now, as we speak, the very first Trump crisis of his second term, in that he's basically telling Congress to shut the government down today at midnight. There's literally 2 votes that have failed. President Musk has put his imprimatur on some items here. So as co-president, Donald Trump and him are deciding, even before he's president, what's going to happen to America. And if this little taste of chaos is enough for you, we can jump right into the immigration stuff, because chaos will rule supreme for the next 4 years.
So yes, this shutting down of the government, is it true? What's going to happen? So it's like the transition period, or?
No, well, it's really interesting. The reason it's shutting down is because the government doesn't have a budget. So no budget has passed, and there's no budget. The government just stops working. Now, the interesting thing, part of that, Nepal, is that the Immigration Service, USCIS, is actually not funded by the budget. So USCIS keeps operating. But ICE is funded by the budget, which is the immigration enforcement side. The consulates are funded by the budget. They shut down. And at midnight tonight, the budget is over. So what I heard literally just before coming on the air, that they're trying to consider a plan C, since plan A and B have failed. Plan C will be a series of votes on a series of proposals that will ultimately lead to the government not shutting down. But Republicans who control the House, and in our system, the House controls the budget. All budget bills have to come out of the House. Republicans only have an 8-seat majority. And they have about 35 members who are basically insane. And they basically love shutting down the government's the greatest thing. They hate the government. Isn't that ironic? They became congressmen so they could hate the government and shut it down. So they need Democrats to support the bill. But if Democrats, look, if you want us to support the bill, you gotta give us some cheese. You gotta do something for us. And that was the very first bill that President Musk came down and said, no, this is terrible. This is terrible. We can't do this. And so Democrats are now sitting on the sidelines going, not really our problem. We don't have enough votes to pass our bill. What are you going to do? So it's literally a chaos show right now, Nipasa. If it wasn't so tragic, it would be funny.
It would. I know, it's crazy. I think we can only keep guessing until it really happens. So let's see what's going to happen after midnight tonight.
I'm sure these things never happen in India. I'm sure it's nothing like this.
No, never heard of anything as such anywhere, actually. All right. So let's go on. Let's go on to our topic. And I have a few questions. So let's dive right into our first one. So given the Trump administration's historical stance of immigration, how do you foresee the key changes or continuations in immigration policy if he returns to power after January 20th?
Well, it's interesting. I've seen a lot of stuff on a lot of websites, particularly from India, about how Elon Musk is going to temper the hawkish nativist movement within the Trump administration. And to that, I say, you're delusional. President Trump said that his primary key advisor on immigration is a man named Stephen Miller. Stephen Miller is the grandson of Holocaust survivors, Jewish, and truly hates immigrants. The irony doesn't escape anybody. He was the principal architect of all of the anti-immigrant nativist movement in the first term, and his position has been elevated into the second term. And people will say, well, they're only going to go after illegals. It's just the undocumented people. That literally is not true. There are already laws allowing Trump to deport people. They just need money to do it. What was evident in the first term will become more evident in the second term. The lowest levels of legal immigration that we had since 1789 were during the Trump years. Why? Because they're going to do certain things to, one, slow down every process. Now, Biden has been no jewel. He's been no great immigration god to anybody. He's done a crappy job as far as I'm concerned. But Trump will intentionally destroy the system. So I'll give you a great example. One of the things that Biden did fix was the naturalization process. People had green cards, become citizens. Under Trump, those were taking about 2 to 3 years. The last couple of years under Biden, it's been taking 4 to 8 months, much quicker to become a citizen. Green cards. The Trump administration is the administration that did not use all of the available immigrant visas that I had to sue them on back in 2020. They also are the ones that proposed terrible H1B regulations that I had to sue them on in 2018 and 2019. All of those things are coming back, except this time, the people that are in charge have learned their lesson. Everybody under Trump previously were newbies. They were new people. They really weren't ever in government. They didn't know how the mechanisms of government worked. They've now had 8 years to learn, and they now know. So starting with Stephen Miller, who is basically the number 3 or 4 guy in the White House, and then followed behind him on the enforcement side is a guy named Tom Homan. Tom Homan used to be the head of, well, he wasn't even head of ICE. He worked at ICE, but he's been a Fox News contributor on immigration for years now. And he portrays this kind of tough guy. Yeah, we're going to, you lawyers, we're going to arrest you for helping immigrants. Really a tough guy kind of thing. But actually, it's the people below them that are going to make a difference. So the key changes, one, we will see things like a slowdown in immigrant visas. I-140s, for example, slower processing. We will see slower appointment times at the consulates. We will see tougher adjudication standards on a lot of different applications. And we will see things like the H1B visa. We anticipate that sometime in the first year or so, the Trump administration will propose a new H1B regulation on wages and say that, yes, there's a lottery, but this lottery will be on the wages. Whoever is getting paid the most will get the H1B visa, as opposed to just what we have this next year, just a sheer lottery, basically by individual, not by employer anymore. So all of those things, and that's kind of the 35,000 foot view, but we can go into a lot more detail as we talk about this today.
For sure. I mean, I hear about that. We had a few discussions. And I mean, if people who are going to be paid most wages are going to be preferred, then I'm sure a lot of small businesses, startup companies are going to suffer on that.
Nonprofits, hospitals,
Yes.
it would be disastrous. But Elon Musk would get all of his people that he wants to hire. The irony here is that Musk is an immigrant, right? That's the ultimate irony here. And in fact, he appears to have been undocumented for a period of time after he was from a student visa before he got an H1B. And when he was getting his H1B back in the 90s, it was much easier to get an H. There was a lot more H1Bs available. So the irony doesn't escape anybody, but here's a guy that's kind of a nativist that started out as an immigrant. It's something we actually see quite often, which is kind of shocking. Close the door behind me kind of people. So go ahead, ask some more questions. We got some great questions here. I know you've got a lot more you want to ask me. We can even talk about the individuals that we know will be running things besides the guys in the White House.
Yes, absolutely. And you were talking about Stephen Miller. So I think I want to ask about him, when you talk about immigration reforms and, the executive actions, particularly concerning asylum policies and refugee camps. What would you like to say about that?
Well, I have just briefly about that. Biden this last month, this November, appears to have been the lowest number of people that came to our border illegally in about 10 years. So even lower than when Donald Trump was president. These are, of course, Biden policies. The thing that's helping is that Republicans are no longer saying, the border's open! The border is open! They go on Fox, the border is open! Well, if you've got Congressman or Trump yelling that, you know where that plays on the news? Guatemala, El Salvador, Nicaragua, Colombia, China. Oh, the border's open. They said it was open. I'm going to come to the border. Since they stopped talking about it, the numbers go down. How ironic is that? Biden had just enacted this last week some asylum reforms that will make getting asylum, the initial interview of asylum, much harder than it has been. and allow for asylum officers to reject people faster. That doesn't mean that they will. I mean, one thing you have to understand about asylum, people coming to the border, is that desperation drives a lot of people. There's a lot of desperation that goes on there. And you can't build walls high enough. You can't erect barriers big enough to stop desperate people. You just can't. What you could do is have a legal immigration system that paves way for them to come, which of course we don't have. So the reform, now Trump wants to put back into place something called MPP. MPP is called Remain in Mexico. Let's say somebody from India says, I'm going to, they're going to kill me in India. I'm going to come to the United States. I'll go to the border, go to Mexico, go to the border. What MPP says, you're going to wait in Mexico until we have time to talk to you. Well, you know who that was great for? The Mexican cartels. Mexican cartels would rape, kidnap, extort, charge people for that. Their cartels were in seventh heaven under MPP. But MPP didn't stop people from coming, because one of the weird things that MPP did was that if you came in and were tossed back, that did not count as an illegal entry. So the bars that are in our laws that then punish you for doing that were gone. It literally was the least effective program ever created for the border, besides the fact it's probably illegal and in fact was stopped one time by a judge. So these asylum things that you see at the border, that's probably history at this point. The numbers are now equalized. They're fine. More people come in by appointment to apply for asylum than come illegally. So, that, and I know, and it upset a lot of people that were legal here, justifiably. People that been here for 10 years, no papers, and people were coming in right now and applying for getting a work permit. Well, it doesn't sound fair, but that's what the law is, right? So if you do apply for asylum, you do get a work permit. It doesn't put you in front of the line, though. The line is still what the line is. And even if you get asylum, even if you get approved, which only 30% of people do, the reality is you have years before you're going to become a permanent resident. So unfortunately, there was a lot of misinformation. It caused a lot of bad feelings. Immigrant groups cannot afford to fight each other. They need to fight together to make the pie bigger rather than fight over one piece of pie. And hopefully we can come to that kind of understanding this year, because it's going to be really important under the Trump administration.
I hope so. And talking about, border security, you were saying, do you think, that the Trump administration, in terms of border security and immigration enforcement, what do you think is going to look like? Especially with the movement, coming into force, the border czar.
It's going to look really ugly. The image that people have of America, the shining city on the hill, as Reagan talked about, the Statue of Liberty, we might as well burn all that down, because they're coming for people. Now, you have to ask, how are they going to identify bad guys, undocumented? How are they going to do that? Napasa, there's really only one way to do that, and is to look at you. And they'll say, oh, Napasa, show me your papers. Like we live in Germany in 1933 or something. Now, what they will do is they will actually begin with the easy stuff. So ICE, which is the enforcement part of immigration in the United States, Immigration Customs Enforcement, they're inherently lazy. All right. They're not, in order to go find people, they're not going to drive buses through trailer parks looking for Mexicans. They're going to go after first people with criminal convictions. Now, here's the thing that is truly ironic. If you ask an American, just an average American who voted for Trump, how many illegal aliens with criminal convictions do you think there are? They will tell you, and there's a poll that said this, like 4 million. There's 60,000. There's 60,000. Now, there's about 300,000 people that do have criminal convictions that actually have orders of deportation that are not in custody because they cannot be deported. Their country refused to take them. Now, one thing that Trump did that was good last term, that no other president really did, he basically threatened countries. If they didn't take the people that we wanted to deport back to them, he would start a trade war. He would just put sanctions on them. He would put tariffs on them. He would cut off aid. And miraculously, some of these countries actually took people back. China was one of them. China doesn't take anybody back. Cuba is another one. Israel doesn't take Palestinians back. I mean, there's all over the world that people don't go back. But what's the purpose of detaining them? You can't deport them. So the next group of people are those that are simply have removal orders. There are over 1.5 million people in the United States, as far as the government understands, that actually have deep final orders. They've had the due process, they got denied, but they don't know where they are. So they're going to have to put resources towards literally finding them. Now, are they findable? Of course. ICE is already using AI to do that, but ICE is only funded to deport at the most 400,000 people a year. It just was announced that last year, Biden deported more people in 2024, fiscal year 2024, than Trump ever did in any year. So Biden is right after Obama in deporting people. Trump wants to get up there and do that. And, they talk about deporting 8 million, 9 million, 10. That's completely unrealistic. It's not going to happen. But what they will be doing is scaring people. They will drive undocumented further underground. And if you think that all undocumented are Mexicans, you're sadly mistaken. Do you know how many Indian nationals that I know that are undocumented? I probably have a couple thousand that are my clients that are undocumented Indians. There's probably close to 500,000 undocumented Indians in the United States. So it's not just a Latino problem or a Central American or Latin American problem. It's a worldwide problem that we have. So I see this very aggressive type of work. Now, on the flip side, so Holman's going to do that. That's kind of his bailiwick. ICE is going to also do worksite enforcement, and for H1Bs, lots of what's called FDNS, or fraud detection national security visits to H1B visa holders. They're asking for more money in the bill that will likely pass in April or May or March, something like that, to get more officers to do worksite visits for H1Bs. ICE will also be doing they don't really do random audits. What ICE did last time, and they'll do again, they have a phone number. And they say, look, if you are an American and you think you see undocumented workers at a company, call us. And under Trump, they had lists they never even could get to. The Biden administration did no worksite enforcement, none. There was no new worksite enforcement. So we'll see that. But what's going to happen, a lot of these people that own these businesses that employ undocumented workers, typically working on fake documents, they voted for Trump. So when ICE starts going after these businesses who are Trump voters, you're going to start hearing weeping and wailing and gnashing of teeth, biblical level complaining. And what you will see is ICE will back off because Trump doesn't want to hurt his friends. I would love to see, though, an employer site visit to SpaceX. It would be kind of cool. Or Tesla plant. So this is undocumented workers going to be under pressure. This will be nothing like the Trump years, the Obama year. Obama's were worse, honestly. The first 4 years of Obama were terrible. We'll see. We'll approach it, but we won't get there. Mostly because it's a very different world we live in than even just 10 years ago, or 12 years ago, or 14 years ago when Obama was president. So it's gonna be crazy, and a lot of innocent people will get caught up, including a lot of Indian nationals.
So do you think because Biden, during Biden, it was not so strict with regard to in the borders, right? So many people could come in, and
well, that's not true. See, Natasha, I'm going to cut you off because that's literally not true. Okay. There is a perception here that Biden let anybody in. You know what Biden did?
Of course not.
Biden followed the law. He followed the law. 8 USC 208. Anyone who comes to a port of entry is allowed to apply for asylum. Period. Mm-hmm. End of story. It's the law. The law was the problem, not Biden. It's Trump that was violating the law. So Biden did his best to follow the law and then change policy and regulation so he could still be within the law and try to stem the flow. But Biden didn't open the borders. They didn't just say, come in. In fact, it was, as I said, Republicans said the borders are open now. Biden's president. And that just didn't happen.
It didn't. Right. But yeah, thank you so much. I mean, that was very, very intense, but we have so much to cover. So let's go on to
Sorry.
our next. No, it's cool.
Hey, you know
It's
what? I
cool.
need a
It's good
vacation for Christmas.
to Well, I do hope we end with good things and good notes so that people can enjoy their holidays at least.
I hope so. But you know,
I hope so.
there's a lot of people. Let's talk just briefly, if you don't mind, about the people that
Yeah.
will be running immigration.
Mhm.
So they've been identified now. There's two former Trump people that worked extensively in the immigration service in his last term. One guy's name is Joe Edlow. Joe was actually acting head of immigration at one point, and the other guy's name is John Zadrozny. Both of them are true believers in Trump. Now, this is USCIS. These are the affirmative visa people. So one immediate change, we'll see they have to be confirmed first, but some immediate changes within January, February, March that we'll see. We'll go back to interviewing everybody that's getting a green card. Everybody getting a green card will be interviewed. Trump started that. Biden kind of ended it. It'll go back. This includes every employment-based case. Everybody gets interviewed. Now, when you do that, Napasa, and you don't hire more people, what happens? It just gets
Yes, how
longer and
how will it
longer and
function?
longer and longer and longer and longer. That's what leads to 2 and 3 year adjustment of status. Because we've had a lot of clients get approved in the last couple of years on, let's say, an I-140 is approved, file an adjustment. Boom, it's approved in 30, 60, 90 days. Those days are over. They're gone. That's one policy. The other thing that we will see is some changes proposed to the H-1B. We talked about the fee rule, but Biden just changed the definition of specialty occupation, how to prove specialty occupation, and who doesn't qualify for an H-1B. So a BCom no longer is an H-1B. A degree, a bachelor's degree in business is now not a specialty occupation. You need something very much more specific for H-1Bs. Trump will take that to the next level as part of this application. So we're going to see a lot longer visa processing times within the USCIS, and we're going to see a lot more green card processing times. The other thing they're going to do, and this is truly tad, when Biden took over and Urchanu became USCIS director, she let us know that immigration was only staffed at 60% of what they needed to do the work that they had. They were 40% understaffed. So they literally last month finally got fully staffed. What these guys are going to do is shrink that workforce. Again, if you have fewer people adjudicating cases and you have the same number or more cases, it's going to take longer. And so we're going to see these really long visa processing times just to get an H-1B approved, which means a lot more people will pay, when available, premium processing. So immigration will make more money by being incompetent. It's a great deal if you can get it. So those are some of the big impacts we will see. We're also going to see, like on L visas, an even more tightening up of what a manager executive is. We're going to see a tightening up on O's and extraordinary ability. And I think Trump may end the Biden policy on national interest waivers and make those as hard as they were back in the day, because national interest waivers become very easy in the last several years with the Biden policy. And that's a policy. That's literally a day one. I dismiss this order. I cancel it. It's gone. Boom. Overnight, you have a pending case that would have been approved, now gets denied. So if listeners have an NIW pending, they should be premium processing that, because you don't want that still pending when Trump's president.
Yes, and you still got exactly 1 month, you can say, for that. So as soon as possible, get things done. Yeah.
31 days and Trump is president.
Yes, yes. And well, about the H1B new regulations also, we hear a lot of changes coming in. So do you think that is also going to affect, or it's going to be great during Trump's reign?
Well, the ironic part of these new regulations on H-1Bs is that some of them are proposals made by Trump, like the tightening up of specialty occupation. If anybody goes on Twitter, there's a lot of hate towards H-1Bs. I mean, a lot of hate towards H-1Bs. And as a result, Trump hears this, his minions see it, and And they say, what can we do to limit? I mean, they can't eliminate H1Bs. They can't do that, but they can make them a lot harder to get. And a lot of the complaint, of course, is that job shops use these. Now, if you go back and look at the biggest users of H1Bs last year, there's only like one job shop on them. There's only one outsource. I mean, the rest are like Amazon's the number one user, Microsoft, Tesla is up there in the top 10. So it's not that there's a lot of outsourcing jobs here. And that's, of course, you hear from is Americans who were laid off. So as an Indian H1B engineer making $60,000 can do his job. Well, if you're doing a job that somebody else with a less education and experience can do, then you need a different job. I mean, then you're in the wrong job. So it's but there'll be going to be a lot of pushback on these H1Bs. There's not going to be, I don't see any litigation possible on these new regulations. They're well within the authority of the Immigration Service to issue. None of them are truly outrageous. And there are a couple good things in there. For example, if you were previously approved for the same job with the same employer, they're basically going to approve the extension. There's going to be a deference policy. Anything changes, no deference, but deference is a really, really important thing. So that's how I see those H1B rules shaking out. We have to modify how we do a couple things internally at the firm, but for the most part, it's going to be business as usual on H1Bs that we do.
Okay. Now coming back to more questions, let's talk about Vivek Ramaswamy, advocating for merit-based system. So how do you anticipate his policies will reshape employment-based immigration categories or even family-sponsored visa programs?
Well, the good news is that Vivek Ramaswamy has no power over immigration. And there can be no merit-based system or point system unless Congress gets involved. Congress has to change our law. Vivek Ramaswamy can't change our laws. The irony is, of course, his parents were H1B visa holders, right? And would his dad have come under the new regulations? That's a good question. I don't know. Maybe he would have, maybe he wouldn't have. If Ramaswamy and Musk are examples of close the door behind me, I'm here kind of immigrants. The kind I truly detest. People that don't want others to have the same opportunity that we did. America is a big country. It's a big country. I mean, it's not India. It's only a fifth the size of India, right? But physically, it's a big country. Economic power. There is room for hundreds of millions of more people. There is. And there's the opportunity. When we bring an H1B immigrant in, on average, they create 4 to 5 jobs for Americans. On average, they create jobs. H1B immigrants are job creators. They're not job takers. And that's true from the janitor or the guy picking your mushrooms or picking your melons in the field to the guy building rockets for SpaceX. We've got room for a lot more people. We're still living, however, under 1990 rules. All these rules we talk about for employment were created in 1990. We were a very different country. Heck, my cell phone in 1990 was in a bag that I carried around that only reached 3 miles. So we live in a very, very different country. And maybe Trump's the guy to fix it. More power to them if he can fix it. I just don't see the level of competence in the administration doing that. And of course, I see a real nativist streak in Stephen Miller and Tom Homan. They don't want more immigrants. They don't. So do Musk and Ramaswamy have the power against Miller and Toman? Well, Miller and Toman are sitting in the White House. Ramaswamy and Musk are too busy down at Mar-a-Lago. So I think the nativists are going to win the day here, and we're going to have to wait till 2029 to fix stuff again. That's my prediction.
Logical, very much. Thank you so much. Now let's go on. So do you anticipate any changes in approach to also family-sponsored immigration categories, F1, F3, F4 visa categories under Trump?
You left out F2. Again, we've had extra employment-based visas for several years because the consulates who do most of these are under the consulates were slow. So I suspect that there will be a slowdown in visa processing. Heck, the Muslim ban that he's going to put back in place, there will be a Muslim ban. It'll be broader than before. That will slow down massive family-based immigration, which means there'll be more employment-based visas in fiscal year 2026 is my guess. So yeah, it'll be a slowdown. He can't deny the visas. I mean, the visas are the visas. But I also see him bringing back a new the what's called the affidavit of support rule, the public benefits rule, and making it much harder for people to come in who are poor, whose families aren't wealthy. I see them bringing that back. That's going to be quite a fight, as I can tell you.
Okay, thank you for that. I think we should quickly take up RK's question on YouTube before we head on with more questions from us.
There's a lot of great
So,
questions here.
yeah. Do you think for H1B wage base, it would be the highest wage per occupation? And that means if you're the highest paid for your occupation, you're eligible for the lottery, regardless
Oh, no,
another
no,
occupation. No.
no. It will be the highest wage. So you're at Apple and you're getting paid $395,000 a year. You're getting an H1B. You're working as a software engineer at Bob's muffler shop, and you're making $40,000. You're not getting it. You know, this is not across every, like, okay, teachers, software engineers, doctors. No, the highest wages. That's what is going to happen. That's what they want to see.
Okay.
It's a great
And
question. I
yes,
like it,
it
but it's
is.
not going to happen.
There's another one that follows. Example, highest paid teacher. Okay, you've already explained.
It's a
I mean,
RK
the
ran
top
out of space.
professional. Mhm, mhm. Okay,
So
let's
take a
take
look
up
Ankit has a
Amara's.
great question.
Who?
Ankit's got a
Ankit.
great
Okay, let's
question
take
there.
up.
At
Yeah.
12:35:05,
Hello,
and not
Charles,
because he
sir.
said our show was amazing.
Yes, he says. So glad, Ankit, you've been following. And he's saying, I also want to ask that the RFE ask for additional evidence to prove that my job qualities as a specialty occupation. What kind of
Well,
documentation should I submit to demonstrate that position requires bachelor's degree or higher?
well, you shouldn't be following it. Your lawyer should be following it. Basically, you're going to start with the Occupational Outlook Handbook, which describes every job in America and what the educational requirements are. You're next going to look at advertisements for that job from other employers. What do other employers say is required for that particular position? And remember, it's not that a bachelor's degree or higher is required. Under the new rules, it's a specific bachelor's degree is required. So they're saying that jobs like systems analyst no longer requires a degree, because I can teach somebody to do that in a week. I don't need anybody to do that. So a lot of H1Bs are going to lose their H1B when they renew because of this. So you're going to look at what is generally required in the industry. You're going to look at what the academics say the requirements are. You get letters from experts that say a bachelor's degree is required for this job. You get a very detailed letter from the employer explaining why a bachelor's degree, you have to take these classes in order to understand how this widget works. So all those things have to be part, and that's why H1Bs are going to get a lot more expensive, because it's going to get a lot harder to do this.
Right. Thank you so
At
much,
least for
Ankit.
some
I hope
jobs.
this
At
brought
least for some jobs. I mean, I'm filing an H1B for a lawyer. That's easy, right? Requires a JD. Thank you very much. Boom.
So I think he will need an evaluation as well, right? For
Well,
his.
the evaluations are done for the individual. Do they qualify for the job? You want to get an expert opinion that says this job at this company and in this industry, this requires a degree. And here's how I know, because I've been teaching this subject at Harvard for the last 30 years and blah, 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 blah. That's what you kind of need. And again, you're going to pay those guys. So H1Bs are going to get more expensive.
Mhm. Okay, let's take up Rogers now. This is from LinkedIn. Feliz Navidad, guys. Well, Merry Christmas to you too, Roger, and to your family. And he says he has a question. I have a green card that got expired when I was 11 years old. Is it possible to renew it even though it passed 30 years since then?
Well, it's a question. Roger, are you in the United States? If you're in the United States, that green card's still valid. I assume it's a pink one. It should be a pink one, or maybe even it's probably not a green one, but it's probably a pink one with no expiration date. If you've been in the U.S. the whole time, the card is fine. If you've been out of the country, that card's expired, right? That card's done, because if you're out of the country for more than a year, you abandon your residence. But if you've been in the United States, you can just file a renewal. Just file a 990 and get a new card. Piece of cake.
Even though
Better
it was
question:
30 years.
if you're in the United States, why haven't you naturalized?
Roger, tell us more about yourself. Which is the one you have? Which color is it? Pink or green? And yeah, why have you not naturalized if you're still in the US? All right. Cool. So let's take up Tamara's question now. I have sent my RFE response for STEM approval to USCIS. It is reflecting as received on portal. How long does it take to get an update? And in scenario where it gets denied, what options does Tamara have?
Generally, it takes 30 days or less on a STEM OPT extension. Gets denied, you will have 60 days to leave the United States. Or change status to a visitor or go back to school. Those will be your options.
Okay. Thank you. Thank you for taking that up for Tamara. And let's go on to one more. Let's take Chandra's question. My employer is a small business and doesn't have the same resource as large companies. How can we prove that they have the ability to pay my salary and fulfill the job requirements for the H1B?
So we just had it. We just won an RFE on this issue that another lawyer had lost, and we actually did a motion to reopen and won it. You start with the employer's tax returns. So is the amount of money they claimed as taxable profit for the business, is that more than your salary? If so, you're fine. If you were already working there under OPT and you're getting paid the salary, you show your pay stubs as part of it. You also look at the person's tax return, company's tax returns. Do they have assets? Do they have carry forward profits? All those things are part of the consideration and are very case specific. So, if you've got that and you're an RFE and your lawyer is not handling it right, just give us a call. We're happy to help. I'm very proud of my partner, Danielle Claffey. She just won. There's a fellow who used to be an H1B worker, a fellow from India at a state agency. And there was some weird stuff going on where he was blamed for something that wasn't his fault. And he went to a different employer and he ultimately got his I-140, became current, filed, and immigration denied it because they said he did something bad at his employer. And he came to us, and it's taken us a year, and we had to file litigation in federal court. But yesterday, he got his green card. They reopened the case and gave it to him. So fighting hard is worth it most times, because immigration makes mistakes and presumes the worst of immigrants all the time. They presume the worst.
All the time, yes. But yes, kudos to you, your team, and Danielle out there. A big shout out. And folks out there, you can contact... Yes, you can contact Charles Cook, have a one-on-one consultation, and you can call him up on his number. His number is 404 949 8154. Let me repeat that, 404 949 8154.
But don't call now. Don't call now. I'm on the show.
Right after the show, maybe. But yes, you can even email Chuck, and his email address is chuck@immigration.net, and go visit www.immigration.net to get to know more about Charles Cook. Thank you so much. And let's go on now, Charles, to my next question. I have this, and that is the Trump 2025 team really appears to blend restrictive and reformative voices. So how might their combined influence impact DACA, and other programs supporting undocumented youth?
I'm glad you asked about DACA. DACA is kind of apart from what Trump has done and will do going forward. The DACA has a strange history. Started by Obama. Trump ended it in September 2017. At least he thought he did. But litigation was filed because Trump ended it wrong. He was required to follow the Administrative Procedures Act, and he didn't. And they're just obstinate. They just never did it. So litigation kept on going, and you couldn't file a new DACA, but you could keep extending your DACA. Biden comes along and says, "Oh, we're going to do it the right way." Biden extends DACA. And then a court says, "Yeah, you extended it the right way, but we don't think you have the power to do it." So the court ended it, but said, "Yeah, they can keep extending people with DACA." It's about 500,000 people. Now there's been argument on appeal of that decision at the Court of Appeals. They'll make a decision probably before Trump comes into office saying DACA is illegal, but then it will be appealed to the Supreme Court. And during this time, DACA will continue. In order for Trump to cancel it, he has to go through this same process that he didn't go through before, but which Biden did, and it takes a year. So DACA is not going away. DACA is going to be around for the next year and a half. Supreme Court won't even hear the case until 2026. What we're telling people, my advice, we have thousands of DACA clients, is if you have DACA and it expires in 2025, you should be filing your extension today. File your extension today to get that extra time, that extra year on the back end, year and a half, 18 months on that back end, because this way you're good till 2027, and you don't know what's going to happen in 2027. So that's kind of where we are with DACA, but Congress isn't going to touch it. Trump spoke approvingly of it in an interview on Meet the Press a couple weeks ago, but Stephen Miller runs immigration. He hates DACA. So it's not going to get approved. Congress isn't going to do anything. The best we can do is fight to keep it where we're at.
Okay. Thank you so much for, for the detailed explanation. And yes, I have one more. And that is, with Trump's renewed push to end birthright citizenship, through executive action, how feasible do you think it is going to be under constitutional law? And what challenges might arise if his administration attempts to implement such a policy?
I was talking to a friend of mine at the ACLU, which is the American Civil Liberties Union, about this, and they already have the litigation ready to go. Trump will issue an executive order on day one that says anybody born in the United States whose parents weren't citizens or permanent residents are not citizens. By the way, this includes children of H1B visa holders, by the way, are not citizens. And he will order the Department of State not to issue passports. He will order immigration not to approve petitions. And it will be immediately challenged in federal court. It will be immediately struck down because it is contrary to the plain language of the 14th Amendment, which says that any person born in the United States subject to the jurisdiction or thereof, which means not diplomats. Diplomats' kids are residents, they're not citizens. And that's been interpreted this way for 150 years. There's the seminal case on this is Kim Wong-ark from 1898, who Kim Wong-ark was a Chinese-born person, a U.S.-born person whose parents were residents. That is, they were physically in the United States. We didn't have permanent resident back then. They said, look, he was here. Parents lived here. He's a citizen. Period. End of story. And this is a fringe legal theory that it shocks me that anybody with a soul would agree is a good idea. We fought a civil war over whether somebody born here was a citizen. And it is outrageous that in the 21st century, we're having to do it again. Shame on these people. Truly outrageous. But there will be a fight. There will be a fight. That's why I'm telling clients, if you've got a CLID and you're undocumented or you're having a visa and your kid was born here, get their U.S. passport right now. Get it now and avoid the heartache later or the headache later.
That's a good one. And it's a point to be noted, folks out there. And yes, I hope you have been noting good points throughout this whole show, by the way. And going on. So let's take up a few more from our audience before we leave. And I think RK is back with another one asking, will there be legitimation for H1B about contract for bona fide job at the time of filing? And what is the difference from what is happening now?
Well, you will, under the new rules, if there's a third party site that they're working at, that third party site will be viewed as kind of a co-employer and will be required to comply with all the rules on H1Bs, including posting, et cetera, and wage. It's going to make it a lot harder on these companies. It's designed to make it harder on these companies to do the H1Bs. So yeah, it's going to be much harder. I'm glad I don't have any clients like that. All my clients are direct hires.
But thank you so much for taking that up for RK. And RK, thank you for participating. I wish you could join us on call. I mean, anybody could join us on call. So I'm really looking forward. But yeah, let's go on to Ajay's question. In the RFE, they've asked for more evidence about my employer's ability to pay the prevailing wage. What kind of financial documents can we submit to address this concern? We
already talked about this. This is a question I answered before. Tax returns,
similar one, like yeah,
things like that. So it's I think it looked like the same one, but tax returns, analysis of tax returns, profit from the previous year, current employment with the company, assets the company has that they could liquidate. All those. If it's a closely held company, you can look at if it's an individual. We had one recently. We won where it was an accounting firm, and basically it was a sole proprietorship. So we used the sole proprietor's income to show that he could afford to pay somebody to do that job. And it explained that now that they won't have to do it, so they'll make more money. So it's kind of again, requires a level of skill that you get when you've been practicing law for for 40 years that you don't get with a brand new lawyer.
Mhm. All right, all right. Thank you so much for taking that up. And let's talk about Elon Musk's, given that his influence on the technology sector, how do you think his involvement in the administration is going to affect policies on high-skilled immigration visas, whether it's H1B or STEM-related pathways?
He will be the contrary voice to Stephen Miller, telling Trump, don't cut out STEM, don't cut out H1Bs, don't do this stuff. But Stephen Miller is going to win that argument. Just is. You have to understand that. Stephen Miller is like a son to Donald Trump, an evil son, but a son nonetheless. Musk will quickly lose focus, and he'll go on to the next thing. But while President Musk is still around, I guess we'll see what he does. But again, I don't see him really affecting policy in a positive way. I don't see it. He's a chaos agent. That's what he is.
Okay, let's see what's going to happen. But I know what you mean. I think it's always most of the time contradicting with many others in Trump's team, right? So let's see what happens. So
True.
what legal challenges? Sorry.
I just said true. It's absolutely true.
Yeah. Yeah. So what legal challenges do you see if Trump seeks to implement similar policies as before? We've been speaking that it's going to happen nonetheless. So with regard to existing federal court rulings against such measures, if you can just
Well,
tell us
actually, we're kind of, I litigate a lot. I was a part of a number of teams that litigated last Trump administration. There's a recent Supreme Court case that makes our litigation easier. There used to be a Supreme Court case that said that if an agency makes a policy, that the court should give deference, should say, you're the experts, I'm not, I'm going to uphold it. That was overturned last term by the Supreme Court. So it is now much easier to challenge policies of the federal government. And I'm actually looking forward to litigating in this context, because I think you have to understand, we won virtually every case filed against Trump. Virtually every case we won. And I would say of the 300 cases we filed when he was president, I think we won 299 of them. We won almost all of them. We will win all of them next time. Because while these guys are, these nativists have a vision of the way they want America to be, our laws don't let them do it. And so we will bring declaratory judgment actions, challenges under the Administrative Procedures Act, and for delayed cases, mandamus cases, and we will win them.
Yes.
And nothing's better than beating Trump at court. Nothing's better.
Okay. Looking forward for a lot happening in 2025 is all I can say. So how do you expect, the potential for litigation to evolve with regard to Trump's immigration policies, especially if they are perceived to be restrictive or discriminatory?
As I said, litigation is going to be awesome. We'll be litigating all these issues. It will not, what's one thing about Trump that's happened that's really important is he's created a cadre of immigration litigators that it used to be like 5 of us in the whole country that litigated these cases. There's hundreds now, hundreds of experienced, qualified litigators. We're going to bury these people in lawsuits. We're going to become the sand in the gears to slow down the deportation machine. And we're going to do that under the law, because we're going to make them follow every jot and tittle that exists in the law to protect immigrants in the United States.
For sure. All right. So I think I have a few more questions. But before that, we should address one more from the audience. Sudhir. All right, so let's take up this last one then I have, and that is, what strategies can immigrants and their families employ to navigate any changes or uncertainties that might arise under Trump 2025 administration?
Well, don't be traveling outside the United States if you're from a Muslim majority country on January 20th. If you're from a Muslim majority country, you should be in the United States on January 20th if you want to come here next year, because that's going to be litigation. If you got kids born here, get them passports. If you are in the United States on a visa, make sure you're meticulous in making sure that visa is extended early at the 6-month mark to make sure you're always in status. Make sure all the lights work in your car so you don't get pulled over for a reason that cops make up that your lights are out. Simply live a perfect life, because that's what the Trump administration will want you to do to avoid you being deported. You don't want to end up in an immigration jail cell. That is a really depressing note to end on, isn't it? And be happy, because people like me fighting for you.
For sure, yes. And you can find Trump's telephone number scrolling on the screen, 404-949-8154. And you can email chuck@immigration.net. So, folks out there, I think it's a wrap for now. I'm so excited that the holidays are coming up. It's the Christmas season. So, here's wishing you, Charles, and your family out there a Merry Christmas and, of course, a great end to 2024. And also to our viewers, if you have anything to say before we go, Charles.
Oh, well, again, we want to wish everybody an extraordinary Christmas season. It is a great time of year to remember the great blessings that we have with our family and our friends. Enjoy this time together and be prepared in a week, in 10 days, to begin the fight again. Have a Merry Christmas and a Happy New Year.
Thank you so much, Charles, for that very sweet message. And here's saying bye for now. And I'm hoping to see you in 2025. And I think by then there'll be so much happening. So there'll be a lot to talk about. So
That there
I'm
will.
looking forward for it already.
Have a happy holiday. Bye-bye.
Happy holidays. Bye bye. So thank you so much, everyone out there, for joining us today. It was great having you. Please do not forget to like, share, and subscribe to Immigration and Jobs Talk Show. We are on YouTube, LinkedIn, Facebook, and on X. And also, you can call me, write to me if you have any queries, and we can direct your questions to our attorneys. And my number is 408-335-6444. And you can also email me. My email address is nipa@staffingly.com. Thank you so much, everyone, and stay back. Watch out, Immigration and Jobs Talk Show, because we have so much awesome content that we have shared with you and a lot more coming up. Bye bye for now. Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm your host, Nipasa Pradhan, and I'm really happy to welcome you folks. And before we start off with today's discussion, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, thank you so much for joining us today. We are streaming live right now on YouTube, LinkedIn, and on Facebook and on X. So please feel free to join us in this conversation by commenting, whatever questions you have, because we are going to have our guest attorney for today, and it's going to be great to have her for an hour where we can also address your questions. So yes, thank you so much for joining us, and it's a very critical topic we are going to dive in today for all immigrants and their families. So yes, with the release of January 2025 visa bulletin, many of us are wondering, what does it mean for us and our loved ones and our future plans, right? And we're going to unpack this for sure. But before that, please help me welcome a very special guest, Attorney Prashanthi Reddy. She is a leading expert in immigration law with years of experience, guiding individuals and businesses through the complexities of U.S. immigration process. Thank you so much, Prashanthi, for joining us today.
Hi, Nipasa. It's good to be back.
Absolutely. And friends, we have a breaking news regarding the upcoming H1B regulations effective January 17. And there are new changes that aim to streamline, the process and address key compliance issues, raising questions about the impact on both employers and employees. So, Prashanthi, before we really dive into our topic for today, I have this question. if you could tell us, what are the key changes in the new H1B regulations effective January 17th, 2025?
Right. So we had an idea that this was coming, but it was coming because they did publish the regulation in the Federal Register, but then they have a comment period, so they were waiting for comments. And then based on the comments, they often change the final regulation. So this is the final regulation, and it's already published, and it was published yesterday, the 17th, is effective 30 days from January 17th. Guys, ladies and gentlemen, it is now official. And this will be the final regulation. And this is a big deal because for a while there hasn't been any regulation on H1B. At least there hasn't been a comprehensive regulation such as this on, the H1Bs. So this is a big deal, and that's why we're, bringing it to you as breaking news. So let's dive right into and there's some very interesting things and path-breaking changes that you'll see, and some of them are, more of what you saw in the past, which is just being regularized now, because of case law and lawsuits, they were not able to implement. So we knew that it was coming, and some of the aspects of this regulation are completely new and path-breaking. So let's dive right into it. As I said, the final rule was, and significant changes to the H1B program have been introduced in this rule. And as I said, 30 days to take effect. So we're talking about January 17th, just days before the Trump administration will take over. And this was done deliberately because they wanted to put it in before the Trump administration came in, so that it'll be difficult now for the Trump administration to make their own rules. This is the rules that the present government wants to have, right? It's good and bad. It's not like the Democratic government is completely free on H1s. No government is. But at least it's a mixed bag, right? So under the Trump administration, in my opinion, if they wouldn't have passed any regulation, then the Trump administration would have passed a much stricter regulation. So let's go right to it. First is they're giving deference to previously approved cases. So if you're filing a extension or an amendment, and if it's been approved previously, and if nothing has changed, if there are no new material changes, then USCIS will automatically approve those cases without again sending requests for further evidence. So that's called the deference policy, which is, already supposed to be there, but now they're putting it into regulation, so it'll be implemented for sure. They've updated the definition of specialty occupation. This rule revises the definition of what a specialty occupation is. This is the very core of who can get a H1B. By revising the definition, that has a significant impact. So they've broadened the range of degree fields related. So right now, as per the regulation, a specialty occupation is an occupation where the job requires a bachelor's degree in a specific field. They've broadened that to include in a range of degree fields that are directly related to the job. So it doesn't have to be one specific field. It can be different fields, as long as those fields you can show that those fields are related to the job, right? So it's not changed drastically, but there is some change. And this really makes a difference because there are some occupations in which a range of degrees are required, and usually those occupations don't get approved for a H1 because then USCIS comes back and says that it's not a specific, it's a range, and therefore we're not approving it. For example, I can give you an example of systems analyst, say, where it says bachelor's degree in engineering, math, physics, computer science is required, and USCIS would previously say that it was not a specialty occupation. Now, as long as you can show that that engineering degree, that math degree, that physics degree is related to the position, even if that's the industry, it's still a specialty occupation. They usually go into the Occupational Outlook Handbook, which is a DOL publication, which is online, which you can check. They usually check that, and whenever there's something in that, in the Occupational Outlook Handbook (OOH), which says that a range of degrees are required, USCIS will generally send an RFE. So this, we can expect that more jobs will open up for H1 and less RFEs, as long as we can show that the degrees are related. CAP exempt employers, they are narrowly expanding what the definition of a CAP exempt employer is. So for CAP exempt nonprofit research organizations or government research organizations, they have included a few more organizations into the CAP exempt employer category by replacing the term primarily research to research as a fundamental activity. So it means that the organization doesn't have to be only doing research. Even if they do other activities, as long as the fundamental activity is research, they can still qualify. In the past, their primary job had to be research. Primary mission had to be research. Now it's not so. It just has to be a fundamental or one of the main activities. The other change is bona fide position requirement, meaning the H1B petitions must now show that the offered position is a legitimate specialty occupation position, ensuring that the job meets all the criteria for the program. This basically means, in short, that, for example, if you're a consulting company, you have to show that you actually have specialty work, specialty occupation work available, meaning that you have to submit contracts and work orders. As you know, after 2020, after the Cessna versus IT-Serve decision, USCIS has not been asking for contracts and work orders. Now they will go back to asking that, but not to the extent that they were asking it before 2020, meaning that they will not ask for all 3 years to show that there is a requirement for 3 years, so show 3 years of contract availability. They will ask, at least to start off, you have a legitimate, contract, even if it's 6 months or whatever it might be for. But the contract requirement has come back. So this is significant because in the past CAP, we've seen that people have applied even without any contracts or anything, any client, especially if you're a consulting company, and they've still approved. Now, if you're not a consulting company, you still have to show that you have a bona fide requirement. So if you are hiring this person for not a contract position, but using them within the company, and you're not contracting them out, then you'd have to show that your company has enough business to require this. So you could show a tax return, you could show contracts work or that your company has with their clients in general, and you can show the volume of business in many ways. Maybe a list of clients, maybe your bank statements, maybe your invoices, to show that you actually have a need for this person. But this bona fide position requirement comes up mostly in a consulting scenario. Then they've also codified the site visits. So USCIS earlier always conducted site visits, but it was kind of voluntary. So you could either allow or not allow the officers into your office, though, I mean, I don't see why you wouldn't, because if you didn't allow them into your office, they would write a negative report and then your H1 would get denied or revoked, and there would be a black mark against your company. So now USCIS has actually codified their authority to conduct site visits, and they can, by regulation, deny or revoke petitions if a petition refuses to cooperate with their visit. Third-party requirements, they have specifically said for consulting companies, H1B workers assigned to a third-party work site, the job requirements of the end client are important rather than what your internal job requirements are. This is also significant. So if you are hiring someone to work as a consultant, say at AT&T, and the position is that of a software developer, then they will want to look at what AT&T's requirements are to hire a software developer. And if they require a bachelor's degree in computer science, then it's a specialty occupation. Otherwise, it isn't. So you'd have to have much more accessibility to your client and get that information from your client, or get a letter from your client stating what the requirement is. So we're back with, end client requirements, submitting end client requirements, or purchase orders which have the end client requirements. Another very, very important change, and this is, I think, a 360-degree range, which is basically the rule now allows H1B to be self-sponsored. Very important. You can file your own H1 even if you are a controlling partner in your company. Very
Wow.
important. This was never the case. So you always had to file through another company, or you had to file through your consulting company. This rule allows certain owners of petitioning entities to self-sponsor. Of course, there's a limitation on the amount of the H1, the period of the H1. You can get it for 18 months and then get it for another 18 months. And then I believe you can get it, for a longer period of time. But you have to keep in mind that though the H1 could be self-sponsored, when you're filing a green card, you could still have issues filing your own green card, because so this works for H1Bs, but when you have to file a green card, again, you'll have to find an employer who's willing to sponsor you on the green card. But this is really important for a lot of entrepreneurs out there who are already able to do their own business, but are not doing it because they are they are restricted because of the existing H1B regulations, where you can't really sponsor yourself because there has to be an employer-employee relationship. So they have really widened this, loosened it, whatever you want to say. And even if you are managing your own business, as long as you are doing more than 50% of the job is the H1B specialty occupation job. If you're also doing the job of managing your company, which may not be a specialty occupation job, you can still do that. As long as the majority of the time you're doing, so over 50% is your specialty occupation job. So that is very, very significant. I left out the best part for, the last, but
For the last.
that's very important. And then there are other some more important rules for F1s. So revised cap gap rule. So now you will be authorized to work under cap gap or remain in status under cap gap until April 1 of the next year. Before it was October 1st of the existing year, now it's April 1 of the following year. So that's also significant for F1s, because they often see that when the H1B gets delayed, if it doesn't get approved by October 1st, then they have to scramble and go back into F1 status, file for, student status for another semester, file for OPT, CPT, whatever it might be, to remain in status until the H1 gets approved. So they are taking that out. No need to, because it's extended until the next year, April, and H1s don't take that long to get approved.
A little more relaxed.
Little more relaxed, for sure. I mean, for the most part, 99% of the F1 students will not have to file for an extension to extend their cap gap. Another last change is maintenance of status documents. They want you to send your status documents while you're filing the initial petition itself. So they might ask for more documents with reference to your status. Right now, we just send the H1s, and we don't necessarily send documents from the start of your entry into the US. So now they want all the documents, I think, from the entry of into the US, from your first entry, and they might want all your pay stubs, all your W-2s, to make sure that you maintained status throughout your. So that's something that they never used to ask for before. Maybe in random cases they would, but now they want that in every single case. So these changes, as you can see, they're a mixed bag. There's some positive and some negative, and that's to be expected. So we have to wait and watch how this actually impacts consulting companies,
Yeah.
how this impacts individual H1B petitions, especially the self petitions, how they process them, whether there will be a lot of scrutiny and they have so much scrutiny that they won't actually approve any cases, or the scrutiny will be as it should be under the regulation, and they actually start approving these cases.
Let's see what the 2025 holds for us. But these new changes sound really good, and I really hope that this is going to benefit most individuals under H1B or who are planning to go for an H1B visa. So thank you so much, Prashanthi, for highlighting all those new H1B regulations and also these new changes for F1 students. Thank you so much. Thank you so much. It was great. And these are some of the latest updates, friends. I hope you noted down. And you can always go watch it right from the very beginning, whatever Prashanthi has shared. These are new updates that you wouldn't want to miss. And Prashanthi, we have some folks out there who have questions for us. I think we should address them before we jump into our visa bulletin questions for January 2025. And some of them are from your channel. So let's take them up quickly, please. So Sudhindra, Sudhindra, sorry if I'm pronouncing your name wrong, but he says, hello, I do have a query. My I-129 was approved on November 25th. I'm still waiting for I-797 form. So will this new H1B changes affect my case?
No, this is only going to be from January 17th. That is, cases filed after January 17th will have to be filed under this new regulation.
All right. Thank you so much for addressing this one, Prashanthi. Now let's take up Shree's question. Hi, H1B petition is applied on November 24th for extension. Is this third-party placements through consulting apply for H1B applications applied after January 18th, or will it still apply for already applied ones?
Good question. It should only take, it should only be, I don't see that it is retroactive, but I can cross-check. It should only be applicable for petitions that are going to be filed after the 17th. But again, I'll cross-check. And then I'll let you, Nipasa.
Sure.
Nipasa, I'll let you know, and then you can let Sri know.
We
But
can leave
as far as I know, regulations are usually not retroactive. They're always only come into play once they've been once they're active, once they're published
Once
and the
they're
comment
active.
period and the 30 days is over. Yeah.
And these
But
changes are
it's
going to be effective on January 17th,
17th,
2025.
17th, correct. But if it's otherwise, I'll let you know.
Okay, thank you, Shri, for commenting. And if you have any other questions, keep commenting. And otherwise, you can join us on this conversation, folks out there, by dialing this number 425-436-6335. And the access code is 988-888. And Abhishek, hi, thank you for joining us. Charwak, we will address your questions, but please stay with us for now. So, Prashanthi, let's get to our visa bulletin for January 2025. We have some questions also, so let's jump right into them. So, given the significant retrogression in the EB2 and EB3 categories for Indian applicants, what strategies can individuals take to potentially expedite their visa process?
Nipasa, shall we go through the January visa bulletin first, just to give people
Sure,
an idea as
let's do
to?
that.
Okay, so basically, for starting with the employment-based categories, for dates for filing, there's been no change. For final action date, there has been some advancement for both EB2 and EB3 categories. Let's go into that. So final action date, EB2 has moved up by 2 months to October 1. China is advanced by 1 month to April 22nd, 2020. All other countries advanced by 2 weeks, so not a big leap, but still something's better than nothing. It's moved to April 1, 2023. So India moved by 2 months, China by 1 month, all other country by 2 weeks for EB2. For EB3, India moved up by 3 weeks. 2012, China moved by 2 months to June 2020, and all other countries moved up by 2 weeks. So again, India 3 weeks forward movement, China 2 months, and all other countries 2 weeks. So you see that EB2 and EB3 both have moved forward moderately, not drastically, but any forward movement is good. EB3 also, there's been an advancement. India moved up by 3 weeks to December 1, 2012. All other countries, except of course for China, advanced by 1 week. So very short advancement to December 8, 2020. And then going to the family-based categories, India, China, and worldwide advanced by 1 month for F1. That's unmarried sons and daughters of US citizens. Now they're on November 22, 2015. Philippines advanced only by a week to 2012, March 8, 2012. F2A, spouses and children of permanent residents. Again, Mexico advanced by 1 month. And India, China, and other countries advanced by 3 weeks. For F2B, that's unmarried sons and residents. For F2A, the only change is Mexico. Married sons and daughters of US citizens, Mexico went up by 1 month, Philippines by 2 months. All other countries went up by 2 months as well. Of course, not US, not India. The most backlogged, which is brother and sisters of US citizens. Philippines went up by 3 months. India went up by 1 month. Any advancement is good because it's very rare. Now that was the final action date table, but but the dates for filing table, which we presently can look at, has also changed for family base. So Mexico went up by 3 months. India, China, worldwide. For F2B, Mexico went up by 3 months. That is unmarried sons and daughters of permanent residents. For F3, married sons and daughters of US citizens, India, China, and worldwide went up by 3 months, which is a good advancement. And brothers and sisters, that's the F4 category, which we were just talking about, 5 months to 2008. India advanced moderately by 2 weeks to 2006. So always look at the dates for filing tables, because those, if USCIS is allowing you to use those tables are usually ahead of the final action date table. It's just that you won't get a green card immediately, but you'll be able to file for a 485 and be in a 485 status and get, the advanced parole and employment authorization as well.
Right. Any advancement is good, and this is very rare to see. So all these good advancements are good news, and thank you so much, Prashanthi, for going through the visa bulletin for January 2025 for us and highlighting those important changes in the advancements for both the dates. So now let's go to our questions, if that's fine. But before that, Sudhindra has said, "Thank you, Prashanthi ma'am. This eased my anxiety. Kudos to you both." Thank you for your question, and thank you for that, Sudhindra. So going to our question, we see the significant changes in EB1 and EB2 categories for Indian applicants. So maybe if you could tell us a few strategies that individuals can take to potentially expedite their visa process.
Right. So we see, even though there has been some forward movement, there's still retrogression for EB2 and EB3 for Indian applicants and Chinese, people from China as well. So, in order to navigate this, there's some things we can do. There's not a lot we can do, of course, other than advocacy to change that. But some things is to see if you qualify under EB1. So if you possess extraordinary ability, or you're an outstanding professor or researcher, or you've served as a multinational, you've worked as a multinational executive or manager, you can consider applying under EB1 or see what you can do to make yourself eligible for EB1. You can file under NIW if your work is substantially intrinsic to the US and helpful to the US, then under EB2, you can file under national interest waiver. The advantage of this is, even though it's still EB2, you can bypass the labor cert process and thereby gain some time, because the labor cert process takes more than a year now. Always make sure you file concurrently. If your dates are current, don't file the I-140 first and then wait. I mean, you could do that, but in order to speed up the process, you should file both the I-140 and 485 together, because by the time you get the I-140 approved, maybe your dates will no longer be current. So concurrent filing, even if the I-140 gets denied and you lose your money, concurrent filing might be the way to go, especially if the dates have become current. Cross-chargeability. If your spouse was born in a different country with a less backlog, so if she's not born in India or China, he or she, then you might benefit from your spouse's countries of birth. Always make sure you cross-check your spouse was not born in this country as you. And last but not the least, always maintain your non-immigrant status. Ensure your current visa remains valid, so that while you're waiting, you don't accrue unlawful presence and then have to leave the country.
Thank you. Thank you so much, Prashanthi, for addressing that and for highlighting those changes. And before we go into our next, let's take up Prabin's question. Does this rule apply for transfer and extension? I think he's talking about the new H1B regulations.
It applies to everyone. Transfer, any H1 that you file, cap, extension, transfer, amendment, anyone.
But after the date, January 17th, 2025, Prabin. Thank you for your question.
Correct.
And thank you for participating. Let's go on to our next question now, Prashanthi. So, how does the advancement in family-sponsored categories, such as F1 and F3 categories for Indian applicants,
Yeah.
impact the expected wait times for green cards?
Well, so unfortunately, as we've seen, right, there's no significant advancement. There is advancement of 2 or 3 months, but as you've seen, F4 categories still remain backlogged. So I would say, in order to prepare to, so that when your case gets current, what you need to do is document ready, right? So keep all your documents ready, especially your birth certificate, marriage certificate, those kind of documents. You have to keep them ready. So that's one thing to keep in mind. Other thing is stay informed. Regularly check the monthly visa bulletin for any changes in priority dates. And keep yourself updated. Don't miss. Sometimes the priority dates are available only that 1 month, and then they become unavailable the next month. So get an automatic email, and you can register to do that so that you get it into your inbox whenever there is a new visa bulletin. That way, you won't forget to check. And the reason I was talking about document readiness is you might not have your birth certificate, you might not have your marriage certificate. Perhaps your birth certificate was never registered. Then you need a non-availability certificate. And this is since you don't have it and you don't have control over how long it'll take, because this has to be done by the register of birth and deaths in the town that you were born. Do that in advance and keep them ready. And then, of course, as I said earlier, consider alternative paths between the employment-based and the family-based, and see which one has shorter times and apply for both if you're able to, right? So that's another way to kind of be prepared despite the retrogression.
Thank you so much, Prashanthi, for highlighting that as well. And family-sponsored categories, I think folks out there are pretty tensed how to go about this, and especially with all these backlogs that have been significant all the while. And I think thank you so much, Prashanthi, for addressing this again.
You're welcome.
Let's go on to our next question now. Let's take up this one. Can you explain the implications of the EB5 category, showing a favorable environment for investors? And what does this mean for those considering applying for an investor visa?
So while the visa bulletin shows that the dates are pretty good and current for most countries, including India, You have to keep in mind that the processing times for EB5s are not good. So while the priority dates might be available, your processing times are about 4 years just for USCIS to process it, which is ridiculous. I don't know why they're doing this I guess they're doing this because they don't want to give out EB5s. There's no other reason. They're trying to stop the EB5s or kind of stall them or reduce them, whatever it is. So processing times are really, really long. So you have to keep in mind the processing times when you look at the total time taken to get an EB5. And while you might, if you're outside the country especially and you're investing that kind of money, and if the processing time is taking 4 years plus, even if your priority date is available, and then takes another 2 years to get a permanent green card by removing conditions, then you're already looking at 5 to 7 years, and then we don't know what the priority dates will be then, right? We're only looking at the priority dates now. So do it, but keep in mind all these things with reference to processing time and how that might impact you. And keep in mind the requirements of, the 1+ million and the 800,000, depending on where you're investing, and that you need to create and preserve during this time 10 jobs, 10 full-time jobs. So you have to continue to have those 10 full-time jobs. And if you're using a regional center, make sure that you do your due diligence to make sure that the regional center has, has good, good investments. So these are a few things to keep in mind, I think.
Thank you so much, Prashanthi. And folks out there, I would like to tell you that you can also join us in this conversation by dialing this number 425-436-6335. You can join us, and when they ask for the access code, dial in 988-888. Once you're in, you just say hello and we will be able to hear you. And otherwise, folks out there, this is Attorney Prashanthi Reddy, and you can also have a one-on-one consultation with her, and her phone number is there on the screen. Her number is 212-354-1010, and you can also email Attorney Prashanthi Reddy, and that is Prashanthi at reddyesq.com, and go visit www.reddyesq.com to get to know more about Attorney Prashanthi Reddy. Let's go on now, and we have Arpita also, who has joined us with the questions. Arpita, please stay with us. We will address your questions a little while later. Prashanthi, with the visa bulletin, showing current priority dates of most employment-based categories for, other countries, that is, rest of the world, what factors could contribute to these variations in processing times between regions, if you have anything to highlight?
Yes, the processing times, the priority dates are definitely going to be different depending on which country you were born in. It's based on country of birth, remember, not country of citizenship. First of all, it depends on the demand and supply in your particular country. For example, because everyone gets only 7% of the total green cards. Every country gets 7%. So for high demand countries like India, the wait time is much longer due to the country caps, right? Also, each category has, again, a cap. So depending on which category you're filing in and what is the demand in that category. So for EB1, the demand is less. So, the wait time is less. If you're EB2, EB3, the demand is higher. This also, the efficiency of the USCIS in processing these, administrative efficiency also makes a big difference. So processing times, especially if you're filing outside the country, your wait times will differ depending on the consulate that is processing your green card. Even though part of the processing takes place here, the final immigrant visa petition is processed for India, example in Bombay, and Bombay has a wait time because they have only so many slots available for interviews. So that could add to your processing time as well, depending on which consulate. And also USCIS often delays processing of cases. So depending on at that particular time, what USCIS processing times are, that could also account for variations in processing times. So I think all these have an effect on your processing time. Hello, Nipasa? I think we lost you. Oh, there you are.
Ma'am, control here. I'm trying to get in contact with Nipasa again. Let me see.
Okay.
One
Okay.
minute, ma'am. 1 minute, ma'am.
I think she's back.
Nipasa, you okay? 1 minute, ma'am, please. Sorry.
Sure.
Sorry, folks.
No problem.
Sorry, guys.
Thank you so much, Prashanthi, for addressing that for the rest of the world. I think there was some internet lag. I had to rejoin. But thank you so much, folks, for staying with us. This is Immigration and Jobs Talk Show. I'm Nipasa Pradhan with our guest for today, Attorney Prashanthi Reddy. So it's been great having your questions, and I think we're going to address them in a little while. But Prashanthi, if you could also, tell us um, how do the changes in the visa bulletin also affect the family reunification process, especially for siblings of US citizens, the F4 category, which you had touched upon a little bit earlier. But what steps should families take to prepare for possible delays and advancements?
Yes, so the F4 category is severely backlogged for most countries and especially for India, as we discussed. And I guess the only thing we can do is timely file your I-130 petition as soon as possible so that you can, be in the window. Um, Maintain communication, keep in regular contact with NVC if you're outside the country. That's a National Visa Center, to update them on any changes that might have taken place, right? Since it's taking 20 years, you might have had children, you might have gotten married, right? Unfortunately, sometimes the sponsor might be no more as well. So you have to continue to maintain contact with NVC and update them on any changes that are taking place. Also, explore other options. And you might want to think whether you want to file an I-130 or not at this point of time, or you have other ways of coming into the country, or filing a green card if you're already in the country. Consider filing a B2 if you want to come and meet your family members for a short period of time, or consider another non-immigrant petition like a student visa, or coming to work here so that you can, you can reunify with your family members. So alternatives are should already always be looked at. If you are filing an I-130, remember it might be better not to file it if you're going to file a non-immigrant petition. That requires you to have intent on not to immigrate. So for example, like a B2, an F1, you may not be able to file an I-130. You might have to hold off on that and file this first, and then file an I-130 once you get onto a visa which allows dual intent, like a H1. So these are strategies that you have to think about, considering the long processing times for an I-130. And I think an attorney can really help you and advise you on strategizing on the best path forward.
Absolutely. And folks out there, you should definitely contact Attorney Prashanthi Reddy, and you can email her at prashanthi@reddyesq.com. And moving on, Prashanthi, if you could also tell us what potential legal challenges or policy changes could impact the visa bulletin and immigration trends in the upcoming months. We already touched upon the latest updates on H1B regulations, but anything else you want to add?
Well, with the new administration set to take over in January, um, we have to see. Visa limits are established by the law, right? And unlikely to change immediately. However, there might be legislative proposals or bills like the Fairness for High Skilled Immigration Act that could be reintroduced. You never know. For years and years, nothing has happened. I don't expect anything will happen under the Republican controlled House and Senate legislature, but let's wait and see. You can never say never. You know, this H1B regulation came out after so many years. That will happen. Who knows? Policies can always change for governments, right? Um, right now, it seems like the Republican Party under Trump is not pro-immigration, but I'm hoping that they'll surprise us and change their policy. And you know, the Elon Musk and people who have, you know, Trump's ear might have some influence over the present government, and I'm hoping that they'll have enough influence to bring about or you know, bring about some positive changes, at least with reference to business immigration. Court decisions can often influence immigration policies and procedures. I am not sure in what scenario this can go before the court, but if it does, and if they, um, then if they are, you know, if the judge decides that, you know, the visa numbers, the way they're counted wrong, and maybe, you know, family members should not be given a separate visa number, if that's something that they can decide after looking at the interpreting the regulation in the Immigration and Nationality Act, then that's a possibility as well. But we have to wait and see.
For sure, Prashanthi. And I think we should also address some of our questions from our viewers. So let's take Abhishek's one. I noticed the January 2025 visa bulletin has some movement in EB categories, but it's not as much as I expected. Why is the movement so slow for certain countries?
Because the demand is so high and they don't want to release numbers quickly. They want to wait and see because we have the entire year uh, ahead of us. So I think they're doing it slowly. That's for that reason. They want to wait and see.
Yes. Thank you,
If they are,
Abhishek, for your question.
if there are visa numbers still available, then you can see likely that there'll be some movement towards the end of the year, maybe August, September, because the year end is October.
Right. Let's hope for the best. Thank you, Prashanthi, for addressing this. Let's take up Charwak's question. What are the key differences between final action dates and dates for filing applications for immigrant visa applicants, and how do they impact the application process?
Um, right. So the final action date table actually is the date when your priority date is available. The dates for filing table is something that the Department of State introduced to allow you to file applications in advance, because the way they um, the way they calculate it is that they're hoping that by the time you file and by the time the case gets processed, your final action date, priority date, will actually be available. So that's how they calculate it. So it's usually dates for filing are, you know, a few months in advance or maybe a year in advance of your final action date table. The advantage of the dates for filing table and the huge benefit that it has is that it allows you to file your adjustment of status early, before your actual date becomes available. And this allows you to file for a 485 and allows you to maintain status without having to maintain a non-immigrant status. So it allows you to continue to be on 485 for years together and have EAD and advance parole. That has been a boon for a lot of people who have, you know, suffered due to the unavailability of visa numbers, because maintaining a H1 for so many years is very difficult, because a H1 is a very stringent visa status to maintain.
Right. Thank you so much, Charwak, for your question, and thank you, Prashanthi, for addressing this. Let's go on to our questions from our YouTube channels first, and then maybe we can take up Arpita's question. So, Control, if you could display the first one. All right. Meanwhile, Prashanthi, like I have one more question to go. So, given the significant disparities, between employment-based and family-sponsored categories, how should applicants prioritize their visa strategies to align with their personal and professional goals?
Right. So this is again similar to what we discussed with reference to retrogression for the family-based F4 category and how you should maybe look at alternatives. I guess it's the same for this. When you're deciding between, I mean, most family-based categories, immediate relative, of course, is a no-brainer because if you are a U.S. citizen child under 21, or if you're a spouse or a parent, there is no visa numbers required, so you can file immediately. So obviously, if you're one of them, would definitely file under the family-based immediate relative category. But even if you're a permanent resident spouse, you might consider filing that rather than doing EB1, EB2, or EB3. So you have to assess what are the priority dates for each and evaluate. First, assess your eligibility for each category and see what you qualify under, and then evaluate the wait times categories that you qualify under, and file. You can no one you can file for both under certain circumstances, but again, I think you need to speak to an attorney to see if it's a good idea to file under all categories or just stick to the categories that are better, and also be flexible, be ready to change or file under the other a different category if this category gets backlogged. So always be flexible, be prepared in a month's notice to file under your that particular category. It happens to jump forward. So yeah, these are the
Right, right.
few things to keep in mind. Assess your eligibility, evaluate your wait times, of course consult with an attorney, and stay flexible so that you can pivot to the other
Absolutely.
category when required. And when I say pivot, I also mean
Yes, yes.
pivoting between employment-based categories, between EB2 and EB3 as well.
Mhm.
And
Thank you so much.
also, Nipasa, in order to pivot, you have to know there is something called changing of the underlying basis. So you don't have to file a new 485. If you filed under EB2 and you want to pivot to EB3, you can just ask USCIS to change the underlying basis of 85. And this in certain situations is possible even between a family-based and an employment-based category as well. So you might not have to file for a new 485. You can ask USCIS to pivot your 485 to the family-based category. But again, consult with an attorney before doing that.
Absolutely. Thank you so much, Prashanthi, for addressing all these and highlighting the important things to keep in mind. And folks out there, it's always best to consult with an attorney. So it would be great if you could also consult with one, and why not Attorney Prashanthi Reddy? So you can email her about your case, and her email address is prashanthi@reddyesq.com, Prashanthi @reddyesq.com. Thank you, and let's go ahead with our questions now from our YouTube channel. So, Control, if you could display it, please. Um, the first one is: are these rules applicable for already selected H1B applicants whose petition is not yet approved? And please give information about the H1B petition delay happening right now. Prashanthi.
So now, as we discussed, these rules should not be applicable for H1B petitions that are already in pipeline. They should only be applicable for petitions that are going to be filed after January 17th, as per regulation. And again, I had said that I would cross-check that and get back to you with reference to if there's something written in the present regulation, because it only came out yesterday, makes it retroactive. In
Yes.
general, it's only regulations are only are take into effect from the date that it's published, or the date that they say it will take into effect.
Thank you so much, Prashanthi, for taking
And
this up for Indhu.
Nibasa, about the H1B delays happening right now. Um, in my
Yes.
office, I'm not really seeing those delays, but perhaps you are. Perhaps this is with reference to your particular case, and there could be some reason for it. Maybe you're going to get an RFE, and that's why they're taking longer to respond. I mean, if you want to overcome that, just convert your case to premium processing. If you can do that, I know it's a lot of money, but if you want to get approved faster, that's definitely one way of doing it.
Right, right. Thank you. And for an RFE, you have around 45 days to respond to it, right? Or 60
Actually,
days, is
more
it,
than that.
Prashanthi?
Depends, but
Okay,
usually the maximum time is 80 something days. So there's plenty of time to respond to an
okay,
RFA.
okay. All right. Thank you so much, Prashanthi, for taking this up for Indhu. And I hope this was very helpful for you, Indhu. And even otherwise, you can always contact Attorney Prashanthi Reddy. She could guide you personally on your case. And that is prashanthi at reddyesq.com. Let's go on to our next question. This is also on a YouTube channel. How long does it take to get a receipt if you have filed an H1B transfer in premium processing? New employers sent the FedEx last Friday and it dispatched on this Monday. Still, after 5 days, don't have a receipt number. They have filed in premium. Is there a delay going on nowadays? I never faced this much delay in premium transfer. Is this normal?
Yes, because it could be that, usually what happens is I would like to advise that, file online because you get a receipt immediately if you file online. So try to make that into a practice rather than FedExing your case to USCIS. Of course, I understand in some instances you cannot file online because you have a H and you want to file then H1 together so that both process together. And in that situation, you cannot file online because you can't file a H4 online. But otherwise, I would suggest file online and you'll get the receipt immediately. But with reference to premium processing, you should usually get an email within the first 1 week of filing with the receipt. But I'm not surprised if you didn't. I wouldn't panic. Sometimes they don't, and that doesn't mean that they're not processing your case. It might just mean that they as yet. Um, and I've noticed premium processing, they do, it's supposed to be 30 days. They never take the 30 days. It's usually processed within a week or 10 days. The only thing to make sure is that FedEx was delivered and that you have confirmation of the delivery. After that, I wouldn't worry too much about not getting the receipt within the first 5 days. Wait and see.
5 days. Okay.
Not
Thank you
yet
so
time
much
to
for
panic.
not yet time to panic. Yes. Shaba Kahal, thank you so much for your question, but I think you'll just have to be a little more patient and wait. Thank you, Prashanthi, for addressing this one. Let's go on to our next control. If you could display it, please. This is from Pradeep. Is Indian Chartered Accountants considered for H1B specialty accusation for accountant job? I have only Indian Chartered
Occupation,
Accountant
yeah.
certificate.
Right, occupation, I guess. Um, CAs
Yes.
he can qualify to work as accountants. They cannot they cannot work as CPAs in the US so that they cannot file taxes, but they can work under a licensed CPA as an accountant. And yes, an accountant is a specialty occupation, and yes, you can file a H1 for an accountant.
All right. This is good news for Pradeep then. Thank you. Thank you, Prashanthi, for taking this one. I think we have one last one from our.
And the other question he had was if I only have an Indian Chartered Accountant certificate, is that sufficient? Actually, you require a bachelor's degree, your degree in accounting, but your Chartered Account certificate, along with your bachelor's degree, if it is in can qualify you or make it if you send it to the evaluator, which your attorney will do. They can consider it to be the equivalent of a bachelor's degree in accounting. So yes, using that, it's possible to qualify as an accountant.
It is. It is. So the evaluation is much needed since he must have done it from an Indian institute. I mean, his studies. So evaluation is a must before that, right? Thank you,
Correct.
Prashanthi, for taking this up.
Yes.
This one is, I think, our last one. I have never traveled to US and working with Company A. My H1B petition got approved with Company A. Now the project is being wrapped up and Company A is not willing to send me. Can I transfer my H1B approved petition with Company B and travel to US? If yes, what will the process be and how long does it take?
Yes, you are cap exempt in this situation because you have previously filed a H1 even though you worked. But of course, or how they exempt is often the interpretation of who is cap exempt and often change. USCIS right now will consider to be a cap exempt case, but moving forward, if USCIS gets more strict with reference to the interpretation of who is cap exempt and who is not, they might insist that in order to be cap exempt, you have to actually start working for the company. But as of now, yes, you are cap exempt. You can file for another H1 and then get your visa. Once you get an approval, if you already have a visa, you can use the existing visa and the new H1B approval to travel as well.
Okay. All right. Thank you so much, Prashanthi, for addressing this one, and thank you, MD Nazim, for joining us with your question. And I hope that was, good. Good. I mean, if you have more questions, you can keep commenting. Thank you. And Prashanthi, maybe we could take up, if you still got a little more time, we can take up Arpita's question.
Sure, one more
I am an
question.
Indian national. All right. I am an Indian national currently working in the US on H1B visa, and I'm interested in applying for a green card under EB3 category. However, I'm concerned about the per country limit and potential retrogression. Can you explain how the EB3 category works and what are the specific requirements and procedures I need to follow to increase my chances of a successful application and given the current visa bulletin?
Just that you apply under EB2 category if you qualify. Just to let you know, in order to your job should require either a master's degree or a bachelor's plus a 4-year bachelor's plus 5 years of work experience. So if you qualify under EB2 and you file your I-140 under EB2, then if EB3 becomes available or shoots ahead, then you can always file your I-140 under EB3. This way you can have an EB3 as well as an EB2 application. This gives you more flexibility and you can use either or. Depending on the dates. If you file under EB3 to start off with, if you file your labor cert under EB3, then you will not qualify under EB2. So if you are EB2, and then you can always, downgrade to EB3. But if you don't qualify for EB2, which may be, yeah. So if you don't qualify though for EB2 and that's why you have interest in filing for EB3, then by all means, go ahead and do it. The requirements are the same. You have to file a labor cert. You have to have a bachelor's degree. Or if you're doing EB3 under specialized workers, then you can have even less than a bachelor's degree. File the labor cert first, and once it gets approved, you have to file the I-140.
Okay. Thank you so much, Prashanthi. And Arpita, all the best. I'm sure you will figure out what's going to be best for you. And I think it's always best to consult an attorney. And why not contact attorney Prashanthi Reddy? You can call her directly, and her number is 212-354-1010. You can also email attorney Prashanthi Reddy. Her email address is prashanthi@reddyesq.com. And please go visit www.reddyesq.com to get to know more about attorney Prashanthi Reddy and the law offices of Prashanthi Reddy. Uh, Thank you so much, Prashanthi. It was great discussing, the latest updates on the new H1B regulations and also the visa bulletin for January 2025. Thank you so much for joining us.
Thank you.
Well, I think it's going to be Christmas coming Wednesday. I still hope that I'll be able to see you, but even if not, here's wishing you Merry Christmas to you and your whole team out there.
Thank you. And like to wish you and the audience that's listening happy holidays as well.
Thank you so much, Prashanthi. Thank you. This is it for now. Folks out there, thank you so much for joining us. And that's all we have for today's discussion. Yes, if you found this session helpful, please don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. And also hit the bell icon so that whenever we have discussions like these, you are notified. And yes, don't forget to follow us on social media because we are there on not just YouTube, but also on Facebook, LinkedIn, and on X. So yes, follow us for updates on future episodes and webinars. And remember to stay informed. It is the first step to making confident decisions about your immigration journey. Thanks for watching and stay tuned on Immigration and Jobs Talk Show because we got a lot more coming up. And also look out for our 4 p.m. Show, which is Daily Immigration Dose with my co-host Sam. So yes, see you then. For now, keep on having a great day ahead.
Hello and welcome to today's episode of Immigration and Jobs Talk Show. I'm your host Sam and I'm back again with a very exciting episode that is lined up for you today. So before diving into today's topic and announcing the name of our very special guest, here's a very important disclaimer. That is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. So, folks, once again, welcome back to Immigration and Jobs Talk Show. I'm your host, Sam. And today we are diving into a very critical and timely discussion. That is, how will the Trump's administration impact EB2 and IW, EB1A, and asylum applications? So, as we all know, folks, that immigration policies have been a very significant, we have seen a very significant changes in recent years, and also understanding how these changes affect highly skilled workers, individuals of extraordinary ability, and those seeking asylum is more important than ever. So, to explain and clear all your doubts and to guide you on the right path, we have an expert with us today. Please join me in welcoming attorney Amin Yacoub, an expert in immigration law with an impressive track record, with a strong background in litigation. And before his current role at Bogan Months and Months, Mr. Yacoub ran his own solo practice, helping clients navigate complex immigration and litigation challenges. As an EB2 exceptional ability and NIW immigrant himself, Amin understands firsthand the complexities of the immigration process. His personal experience drives his passion for delivering top notch legal representation to his clients, ensuring not only quality but also efficiency. With a nearly 99% approval rate in securing EB2 and IW and EB1 visas for his clients, Mr. Yacoub is a true leader in the field. So, I mean, first of all, welcome to Immigration and Jobs Talk Show, and it's an honor to have a show with you. How are you doing?
Good, and thank you for the kind introduction. It's a pleasure to be here.
Absolutely, and it's an honor, to have a show with you, and we are really grateful that you are here with us. So, thank you so much for joining us. And also, I would like to ask that before diving into today's topic and going to talk about today's episode, I would like to know that were you expecting Trump to be back in White House?
Yes, I did actually. I would say I did expect him to be back when Musk, especially, joined forces with Trump, because Musk hasn't failed yet in any of his endeavors. So it meant a lot when he joined forces, and he was like giving $1 million a day to people and stuff like that. So it's just I felt like he's going to come back to office to correct the economy as well. So people are feeling it here in the U.S. and feel like they need to have a better economy, and that is usually the number one drive for the presidential election in the U.S.
All right. So, I would also like to ask that how do you think that under Trump's era, how do you see the future of US? Do you think it will be a new era or a nightmare for US?
Yeah, I think we've seen Trump before, so it's not like we're just exploring a new candidate here. So we've seen him from 2017 up to 2021, and it was, 2016 up to 2020, and it was not a bad year at all. Was the economy went up and everything was, in terms of immigration, nothing actually changed during his era. I would say Americans were, at least according to polls, were feeling satisfied with the economy. Were feeling satisfied with the low mortgage rates, interest rates, and everyone had kind of a chance in applying for jobs and having employment in Trump's era. But of course, people blame the COVID-19 2020 on what happened during Biden's administration. But my point is just the last period that we actually witnessed Trump doing work as a president of the U.S. He was not as bad as the media might actually show, and it's all like a political fight in the U.S. Media is trying to show a picture of Trump. He's like anti-immigration and anti people who are willing to actually help the U.S. be a better country. And that's not true. And that's why I'm interested in talking about immigration under Trump, because it's a completely unpopular opinion if compared to whatever is going on the media or whatever is going on the newspapers. So that's how you. So the other party here is the Democratic Party. Everyone tries to influence the public somehow so that they vote for them, so that they actually get them to the seats of power. So we just have to be neutral and watch closely and wisely in order to see what is true and what's not true.
Absolutely. And also, as you mentioned, that media has portrayed Trump in a little different way. And we can see that, even when Trump was serving food to in McD, then also that, that social media post just spread like fire. And it was also giving a different opinion that he's serving because he wants vote, or there was some kind of other opinion, that people were portraying in a different, actually in a little negative way. And
Yeah,
on the other side, if we look upon the Democrats, then I would say that for Democrats, the media was a bit lenient. They were more supportive, right?
yeah,
So
yeah.
I think that's why. But also, I would like to know from your side that can you be a little specific about that why Trump won in this election? Instead of, as media plays a huge role, and what media was portraying, that what people believe, but out of that also, people supported Trump and made him choose him the leader. So can you please go ahead and share the reasons behind it?
Yeah, so you're asking about my personal reasons why Trump is coming back, not the objective reasons here, or
That's
not.
okay, you can give your reason.
Yeah. So again, Trump is a businessman. He has more knowledge about the economy and how it works. And we have seen, so that's kind of objective and subjective at the same time. We've seen Trump before doing his job as a president from 2017 up to 2021. And we have seen the vice president, Kamala Harris, doing her job as a vice president from 2021 up until now. So when we compare both candidates. We basically see two people who are not new people to us. They have been in power. They have been doing things. So we can just observe and see, was the economy better under the first or the second one? Was every aspect. So what was immigration better and faster for under the first presidential candidate or under the second vice president who's currently still in office? And by doing that, just a simple analysis to me, it seems kind of obvious that we can see that actually Trump, even asylum, nobody would actually wonder that. It's like asylum was much faster under Trump, and I'm talking about affirmative asylum. So that's an immigration issue, and of course, this is one of the biggest uh, portions of the policy of Trump. So he's not anti-immigration; he's anti-illegal immigration. So what he wants to do is to vet people coming in so that he focuses all the efforts, all the efficiency of USCIS on legal immigrants and basically move things faster. In 2017 up to 2021, what we usually had happen was they actually accepted people in asylum in 5-6 months. They scheduled an interview in 5-6 months. Now an interview would be scheduled in 6 years. So we are seeing a completely different era in immigration under Biden's administration. And everyone is so panicking about Trump. Everyone is so panicking about Trump and immigration. Again, because of the media here. So that's why, I feel like it's important to actually show what is true and what's not. And my opinion, may convince you or not, but I'm relying on data here, and I'm relying on statistics as well. Approval rates of EB2NAW and EB1A under Trump's administration and under Biden's administration. So hopefully that will be useful, and hopefully that will actually make immigrants relax a little bit when they think about applying for EB2NAW or EB1A under Trump, not under Biden, because everyone is so panicking right now. And I want to say, do not panic. This is not going to be worse. I think it's going to be much better actually for you.
Wow, that's great. I think this is really insightful, and this conversation, I'm loving it from my side. And also, I mean, before delving into the questions that we have prepared for today's topic, there's one more question that's intriguing in my mind. That do you think, as Trump says, that there will be a mass deportation from the very first day that he'll be joining the office in 2025? So, do you think that that will happen, because there are millions of people and practically that's not possible? So,
Yeah.
what's your thought on that?
So is it possible? Yes, it is possible. Is it practically possible? Possible? I don't think so. He tried to do the same thing in the first year he actually took office in 2017, and he couldn't. And when he's saying mass deportation, again, we have to be very specific about what kind of population he's actually trying to deport. So anyone who has legal papers is not subject to this mass deportation. But anyone who has entered the country without any legal papers, without a visa, and they entered through the borders and they came to the US unvetted, probably he will do his best to deport these people. Now there is a status in between, which is people would actually come through the borders and try to obtain a legal status. So the question becomes, what happens to those in between people? So they would be in a safer condition than those who actually came to the US and remained without papers. And you would be surprised. We actually have many unvetted people coming through the borders. And I don't think that's wrong to actually, make a legal move regarding undocumented immigrants or people who have never respected a rule in the immigration law. I think that happens normally in all countries around the world. So no country actually allows anyone to come in. You have to have a visa. So it's not like something out of the ordinary here. But if you do have paper, no one is going to be able to touch you because you have to be before a court, which we call procedural due process, before an administration, whether Trump or anyone else, actually has any decision over you or deporting you. So if he decided to deport someone with legal papers, let's say a CO8 pending asylum status, then he would actually advise USCIS to refer them or defer them to court. And once they're referred to the immigration court, then they would have what we call a day at the court. So they can represent themselves, they can have an attorney, and if they won the case, they're going to be remaining here in the US legally. If they lost the case, then they will be deported back to their home countries. So that's important to clear some, again, complexities regarding the mass deportation and the media, hyperbole statements that's like, just people are leaving, people are going to be, Trump is going to basically take people, arrest them, and remove them from the US, all immigrants. So generalization is not accurate here. And it's important to distinguish between all these strata of people and immigrants in the US.
All right, that's great. So thank you so much, Amin, for explaining that and taking that question up. Now I would like to shift our topic, shift our eyes on this topic, that how will the Trump administration impact EB2 NIW, EB1A, and asylum applications? So, I mean, my first question to you is that how might the Trump administration focus on merit-based immigration affect the adjudication process for EB2 NIW and EB1A applications?
Yeah, so that's one of the most important questions that we actually get on a daily basis right now. So how would he impact those kind of policies? So first, we have to distinguish between what he can do and what he cannot do. So as a president, he is having very specific authorities that he actually allowed to do. So, for example, we have the matter of Bansal right now, which is the landmark decision behind the EB2 national interest waiver. Is he allowed or is he authorized under law to basically reverse a court decision? That's a no here. So the answer is no. Is he allowed to change immigration law, the ENA Act of 1990, which actually put forward the national interest waiver, the EB2, and most employment-based immigration visas? The answer is no, because Congress has the authority to actually put it, reverse it or change it, amend it with a majority of votes, which is very, very difficult to do because we have, again, even if we have right now a Republican Congress, we still have people who are believing in the immigration under Republicans and under Democrats. So people would be rejecting any kind of change or radical change, I would say, to the ENA Act itself, which has been existing since 1990. So what kind of impact would Trump be able to do to immigration would be direct impact. So even though he has control over the borders, he can actually advise Homeland Security to not allow people in. He doesn't have much control over USCIS except as directive opinion. So he would be giving a directive statement to USCIS saying, well, please try your best to do better when it comes to evaluating the national interest waiver or whatever. And my idea, again, would be that he would actually broaden the scope, not as people think, that he would actually make it exclusive to scholars or scientists. And I believe so because he even suggested to give a green card to everyone who's graduating college from the US. So what we're seeing right now is Trump is probably pro legal immigration for the talented, for the people who are actually making a difference to the US. And people who are making a difference would be called, the EB2 NIW applicants and EB1A extraordinary ability applicants. So probably I would actually expect some broadness, and that is going to be broadening this kind of categories. And I'm not the only one who thinks so. I'm not the only immigration attorney who thinks so. So people who are versed in the field actually agree with me. So I believe he is going to be giving directives to USCIS to accept more applications under EB2NIW and EB1A if really the person is going to be making a difference. And that question remains a question to be answered in the case itself, in the petition and the exhibits. So whether a person is going to be making a difference or not is basically proved in a case, which is usually like 200 up to 400, 600 pages of documentation. So it's a completely objective way of evaluating what Trump is about to do here regarding the EB2NIW and EB1A applications. And I think they're going to be much better than right now, even though we do have a direction from Biden's administration when he took office to try to grant as many EB2NIWs to people who are working on AI, for example. But from the statistics posted by USCIS, what we're seeing is a drop in the acceptance rate down to 65%. So that direction didn't help much, which shows the nature of the direction. It's not binding. It's just suggestive to the president.
Much, Amin, for your answer. And also, I would like to ask, and being a little specific about what specific changes to evidentiary requirements for EB2 and IW petitions can we expect under a Trump's administration based on past policies?
Yeah, so that takes us back to the matter of Donosar. So the matter of Donosar as a landmark case actually places all the evidentiary requirements that are required for EB2NIW and basically if we complied with the case law, which is the matter of Donosar, and the ENA Act, we complete the case correctly. So there is no say of a president here. It's all legal work. It's all decided by a court. We cannot bypass a court. President cannot bypass a court. The court itself may revisit the decision if it wants, but at the moment, it has been existing since 2016. The matter of Donosar. Before then, we had a case called New York State Department of Transportation. So we have multiple case law that basically a body of case law precedents that actually put forward the evidentiary requirements for EB2NIW petitions. We never rely on what the president says or what the president did not say. We rely on case law, we rely on the law itself, for regulations, and we have to comply, us and USCIS officers. If a USCIS officer might be subjective somehow, he or she might actually make a decision that is not relying on the regulations. And in that situation, the correct action is usually an appeal. Or a motion to reopen, of course. So it's just a matter of complying with regulations. I do not believe.
Amin, can you hear us? I think due to some reason he might got disconnected. But there's no problem, friends. Still you can continue posting your questions, and we are definitely going to take them for an hour as Amin Yacoub is with us for an hour. So till the time Amin will come back, we will try to have him back again with this episode. But you don't go anywhere. We'll be coming back with another short break. So don't forget to join us here. We'll be right back.
Yeah, I don't know what happened, but I'm back
Uh,
now.
no, no worries, no worries. I mean, not to worry anything about it. So, yeah, I was saying, everyone that Amin will be back again with a very insightful discussion as we were going on. So, Amin, please go ahead and continue with your insightful information. We would love to
Yeah.
hear.
So where did it go off so that I can continue from where I stopped?
That's okay. You can give a brief about it.
Okay.
Yeah.
So I think the last question was, would Trump be able to actually influence the okay, now I see.
Yeah.
So what specific changes to evidentiary requirements for EB2NAW petitions? Again, I said briefly, based on past policies, he only can give directions, but for specifically EB2NAW applications and EB1A. For EB2NAW applications, we have to rely on the matter of Bansal, which is produced by a court. So only a court can revisit that landmark case. No one else can actually change it. A president cannot interfere with the court decision and produce another decision. So that's regarding the evidentiary requirements for EB2NAW and also the regulations in place. They're actually an extract from the ENA Act, which was passed in 1990. Again, it's not expected from the president under the Constitution to have the authority, which he doesn't have, obviously, to actually change something in the ENA Act itself by direct will. So if that needs to change, the Congress has to change it. Now, what remains is the EB1A, which is not a part of the question, but I can cover it. EB1A is also placed by the ENA Act. So again, Congress will have to change the law for us to actually change the evidentiary requirements. Now, what the USAS officers might actually have from Trump's side is, please broaden your interpretation of the law a little bit, or narrow it. And I believe what we're going to be seeing, according to what he said multiple times regarding legal immigration, and that he is pro-legal immigration, and also because now we would have Elon Musk, who's an immigrant himself in his administration, we will be seeing broadening of that interpretation of those evidentiary requirements that are put forward by the law itself, the ENA Act, and the matter of Danasar court decision.
Amin, I would like to ask from you that you are saying that we are going to see a broader aspect. We will be seeing more opportunities, for EB1 or for everyone. So I would like to know it from you that how can you explain it in a bit that how we can see a broader opportunities, because most of the time we are seeing that Trump is trying to implement this and trying to reduce or making the immigration process a little lengthy. Yeah.
Yeah. So now I will use some data, but I don't think I can share the screen here, but it's accessible. You can just type in Google USCIS statistics based on EB2NAW. So you're going to find the graph going up in 2017, 2018, 2019 of the number of petitions, EB2NAW petitions, and EB2NAW approvals.
Amin, I'm so sorry to interrupt, but if you want to share your screen, you can also do that. Or you want us to share, then you can share the link in this private chat and we can share it from our side.
Yeah, okay, sure. Just give me
Yeah.
1 second.
Yeah, sure.
So here's
Will be
the
clear.
link.
Yeah, you
This
can
is just one statistics, but we have multiple statistics as well. We can go through this one and
yeah, I think control, if you could please show this data. Yeah, I think we
yeah,
have.
can I control it? Can you scroll down a little bit? So yes, zoom in. So we have here 2017 as well was up. If we looked at here, it's going to be 2017, 2018, 2019 under Trump. And then 2020 was the COVID. And then 2021, Biden's administration. and then 2023 we're still in Biden's administration. Now we're going to see that the blue line, which is the receipt, EB2 or EB2 category in general receipts, is still going up, but the green line, which reflects the approvals, is starting to go down under Biden's administration of 2023. In 2024, it went down even below. So what we're seeing here, except of course in 2020, which is an exception, is a rise in the petitions and a rise in approvals under Trump in 2018 and 2019, and in 2017 as well, based on another statistics. And if we can you go down a little bit? I want to show you something else. Yeah, next page, please. The one below this. The one below this. Yes, here. So here we're looking at the O1 petitions, for example, STEM and non-STEM related. So they kept going forward and upwards since Trump, again, had a hiccup in 2021, went bad a little bit, and then it went up again. So O1 is not as influenced as EB2NAW and EB1A because they're non-immigrant visas. So we're not going to be seeing the same difference on E2s, O1s, and L1s as we're going to be seeing a difference on EB2NAW and EB1A because they allow people to get green cards, basically. Can you go to the next page, please? Next page. Yes, here. So here we actually see approval rates. If you could zoom in a little bit, it's towards the right end of the table. So 2018, that was under Trump, that was 97%. In 2019, that was 97%. That's for EB2 in general, but it's included. The NAW is included in there. You would actually see the petitions included in all of this. In 2020, we have a high percentage rate, but then it dropped down towards the end of the table to in 2023 down to 90%. Again, that's including the EB2 petitions that are sponsored by an employer, not only the national interest waiver. And that was published by USAS. It's not like something that I drafted for this live stream. So if we just took a look at the data, we're not going to be finding a source that would actually collaborate the statement that Trump's era was bad for EB2NAW and EB1A, especially. Maybe it was a little bit stricter when it comes to the H1Bs, which I agree with, but it's not the same for EB2NAW and EB1A. And I do not believe there is any reason to actually think that Trump's coming back would actually make things worse, because they haven't. So why would I be convinced that Trump would actually come and say, well, let's change it to 40%. So why didn't he do the same thing in the past administration if he wanted to do it? So it's kind of unconvincing to me. And based on what I said, again, the court has to change its decision. And I don't believe that's going to be happening anytime soon. Congress has to change the law. And I don't think that will be happening anytime soon either.
All right. I think that's great and that's very well explained. And thank you so much, Amin, for the data also, because that's pretty much very clear from our side also. And we can see the stats. So with this, we can have a clear picture about it. So again, thank you so much, Amin, for that. And meanwhile, I would also like to, greet our viewers, Ram, Jitendra, and Maisha. I mean, these are lovely viewers who has joined us for today's episode. So I think welcome to everyone. And here we have a question from our viewer from LinkedIn. That is, at the moment, how long average time to process EB1A and EB2 NIW?
Yeah, so regular processing usually takes 8 months up to 12 months for both EB1A and EB2 NIW. If someone would like to have a premium process, they have to pay an additional $2,805 to USAS, and that would actually allow them to receive a decision in 15 days for EB1A and in 45 business days for EB2 national interest waiver. So a decision means an RFE, an approval or a denial. So it does not mean that they're going to get an approval faster or like they're going to get so a decision can be very general. What usually happens is a premium process, especially for EB2NAW, would actually, and EB1A as well, would actually influence USCIS officers to produce RFEs. And it has been the case since, I would say, last year, middle of last year. And that's because the applications went up. Again, we have to consider that everyone who came through the borders, illegal immigrants, they stood in the same line before USCIS, but from the asylum side, because we have two types of asylum: the affirmative asylum for people coming through the borders in a port of entry, like an airport, using their passports and a US visa, and people coming through the borders without passing through any CBP officers, without having a visa, and basically, getting their way into the US borders through Mexico or anywhere else. So all these people combined, which is unfair for affirmative asylum applicants, of course, they're all in the same line before USCIS. So people are asking me and asking multiple attorneys, what's happening? Why are applications being late? And what's happening in all of this? What's really happening is whoever came into the U.S. through the borders, they're standing in the same line as everyone else. So now I-140 applicants, they're paying a fee called an asylum program fee, which is an additional $300. So the USCIS started charging the additional $300 fee so that they actually try to do whatever it takes to hire more officers to get the process going, because we have more than 4 million people who came into the U.S. through the borders undocumented. So what I'm saying here, or what I'm trying to get at, is if Trump really stopped whoever coming through the borders undocumented and only allowed legal immigration, things are expected to go faster in 2 years or 3 years, because we already have millions of people before USCIS. So it takes some time to actually finish the cases that the extra cases that they have, the frivolous asylum cases, and so on. So right now, as I said, just to summarize briefly, it's just 8 months up to 12 months regular process, and 45 days premium process for EB2 national waiver, 15 days premium process for EB1A.
All right. So thank you so much, Amin, for answering this question, and thank you so much, Mai Cho, also for participating in today's session. In case if you still have any follow-up question or would like to know about any other topic related to immigration, then please go ahead and dial on this number, and you can also give a call on this number and can also participate in today's session. And you can also comment us with any other different topic or any other follow up question that you would like to ask from today's attorney. All right, so now I would like to take Jitendra's question, and he's saying that I'm a physician applying for an EB2 NIW based on serving underserved communities. Could changes to the program's national interest definition under Trump affect how these cases are judged?
U.S. will always welcome physicians, especially if you're focused on underrepresented people or underdeserved communities. And there is always, of course, I have to note here, a shortage is not a reason for the EB2NIW eligibility, because it's covered under the PERM process regulations. So if you are sponsored and you have a full-time job offer and you're basically before the Department of Labor doing the labor certification, what we call the PERM process, there is an exception for having a shortage in your field. So the argument, the same argument does not apply for a waiver. But what I'm saying is a waiver is actually not relying on the shortage, but it's relying on you serving those kind of communities. So that's different. But what I'm here, if you want to apply as a physician, your chances of approval would be really high because USCIS really appreciates doctors and physicians, especially if you're really about to serve or you have a proposal to serve the underdeserved communities or people who are being basically without doctors. But again, even though it sounds the same, we're not going to be arguing the shortage. We're going to be arguing that you're going to be serving those kind of communities, which is kind of different.
Absolutely. I think healthcare is the most important sector in any nation, and that's like a backbone of any country.
Yeah.
So I think that's very well explained. I mean, from your end, and to Jitendra also, if you want to know any other topic or if you have a follow-up question, then please go ahead and feel free to comment us on this session. All right. So, I mean, I would also like to ask about, are there any specific fields or professions that may be favored or disadvantaged under a Trump administration concerning EB2 NIW and EB1A applications?
I wouldn't say fields or professions. I would actually say how the case is prepared. So if someone is trying to argue that basically they're going to be a management consultant, but they're not going to be contributing to any specific field. There's just going to be a management consultant. That's not good enough. The proposed endeavor, of course, has to be very, very specific. It has to highlight how it would actually bring the difference in the U.S. To what sector or sectors, and technically, how would that happen? How would it cause that kind of difference and impact on that sector? So anything that is not specific enough would probably be denied. So it's not really about the field itself. It's about the specific proposed endeavor. And if you do have a specific proposed endeavor in even arts, that would be accepted as opposed to having a very general proposed endeavor in being a physician or in being an engineer. So it's not about STEM versus non-STEM. It's not about being an engineer or a doctor or an artist or a theater production company or whatever. It's about the specificity of the proposed endeavor and how can we convince a USCIS officer that you have already had some success in the past, which we should have prove in the petition, of course, and all the documents, and that you're aligning your education and professional experience and past contributions to your proposed endeavor in the future, which will bring in that difference, which is going to make America a better country in the future, or even a sector in the U.S. a better sector in the future through business or scholarship.
Right. And we really hope that America becomes great again, as Trump says, and that's how America feels. So, all right. We also have another viewer, Knife here, and Knife is saying hi. Hi, Knife. And the question that Knife has is, do you think that Trump government can be doing all what he talking, and if not, what are the challenges?
I don't think Trump will be able to do so because we have laws here. The Constitution, you have to understand that the U.S. is a democracy, right? So its rule of law is dominant here. So Trump cannot be a one man who's doing everything. So we have the judiciary, and we have the Congress, and we have the president. So three branches of the government. They have checks and balances, of course. The Constitution says or documents basically the relationships between all of them. So Trump does not have any authority to actually reverse a law that was enacted in 1990, which is the ENA Act that provides most of the immigration visas. Trump does not have the authority to reverse a court decision, which is a landmark case. It's a precedent. So a court can only revisit and reverse that decision. Trump cannot do so. He cannot basically interfere with the court judgment and say, well, I'm going to reverse it tomorrow because I feel like it. What Trump can do is give directions to USCIS and CBP officers. Now, all these directions binding. The answer is not really. They're suggestive, and they are not binding. So USAS, and based on what I showed on the statistics, has been doing favorably. Basically approving many petitions for EB2NIW and EB1A under past Trump's administration. So there's no reason to believe that in the next Trump's administration, he's going to be doing something different. What I think is he's going to be actually broadening the visas, EB2NIW and EB1A, to some extent, so that they accept more talented people. Because now he is having Musk in his administration as well, who is, I believe, is an EB1A or EB2 nationalist waiver himself. I would say probably he is either EB1A or EB2 NAWs, although some people argue that he's EB5. But why would he choose EB5 if there is a higher category? So, we should ask him this probably.
All right. So I would like to say, Kinfi, thank you so much, and my apologies for mispronouncing your name. But Kinfi, if you still have any questions that you would like to ask from our attorney, then feel free to post them, and we are definitely going to take them up. All right. So Amin, you are explaining fantastically about all the questions that we are taking up. Here's another thing that I would like to know from you, as you also mentioned about the border and about the security. So we all know that Tom Homan being appointed as border czar under Trump's administration. So how do you think that his approach will affect the border security, asylum policies, and immigration in the future?
So the question here is about asylum as opposed to EB2 NIW, or?
I think, okay, let's take about asylum, EB2 and IW, because we are taking that as a topic. So yeah, please go ahead and talk about it.
Yeah. So again, the affirmative asylum wouldn't face many challenges in the future, in my opinion, because these people enter the U.S. legally using a visa, and they are documented. We basically, USAS can easily, in connection with the FBI, can figure out if someone is or has been a criminal or not in their home country. So they vet people, and vetting is important to get people in. Affirmative asylum, in my opinion, would actually go faster. People would have interviews scheduled faster than 6 years, in 2-3 years from now, because we have to, again, the USAS has to decide millions of cases so that it actually creates that faster process in the future after people, undocumented people came in through the borders. So that's number one regarding affirmative asylum. Affirmative asylum people who actually applied and got the CO8 legal status, which is a pending asylum interview, and they're waiting in the US legally for the interview. They shouldn't be fearing anything, again, because they are documented. And the first sentence in the USAS receipt that they have received actually says you may remain in the US lawfully until you are scheduled an interview. So right now, they shouldn't be fearing any changes in anything. Also, you have to understand that from a legal standpoint, laws cannot be applied retroactively. It's unconstitutional. So even if Trump, let's say, which is, I would say it's an 0.01% chance. Let's say he said, well, now I believe that I want to get rid of affirmative asylees who are living in the U.S. legally with a CO8 pending asylum interview. That cannot apply to you because you are already here. You're already having the CO8 legal status. You already have the documentation. So that probably will stop people in the future from getting the same card as you, the CO8 employment-based, not employment-based, it's called the EAD, Employment Authorization Card. And that will prevent that for the future, not apply to the past or the present. So that's important to note because status quo will remain the same it is right now.
All right. So,
Yeah, I think there is an interesting question here, if I may reply to it. It's by Kavya.
is saying that for EB2 NIW applicants, there's a speculation that USCIS could enforce higher education or professional thresholds. So, do you think that applicants with advanced degrees but limited publications could be at risk?
Yeah. So I wanted to reply to that question because there is a misconception that is going around that you have to have publications and citations to have an approved EB2 and AW petition. And that's not true. So we have three kinds of applicants. We have the scholar applicant for EB2 and AW. We have the entrepreneur applicant for EB2 and AW. And the entrepreneur is not expected to have any publications or citations. And we have the professional path, which is a third unexplored path somehow, which is basically someone working somewhere in the US saying, through my employment in that institution, let's say nonprofit, I will be doing some novel technique, and that novel technique will bring in the difference on the US nationally and on the field itself, and therefore will have substantial merit and national importance to the US. So for the second and third paths for immigration under EB2 and AW, you wouldn't expect to have publications and citations. Only as a scholar, we would expect you to have publications and citations. So it's not going to affect you in any way right now or even in the past, since I would say the matter of Donosar, which actually reversed the New York State Department of Transportation. And the matter of Donosar said you can have a proposed endeavor that is important for the business, for entrepreneurship, for arts. So it broadened the criteria for EB2 and AW to actually cover multiple non-STEM fields and STEM fields that are not scientific or scholarly based. So that's regarding this question. Regarding the advanced degree question too, the ENA Act itself, which belongs to 1990, so it has been enacted for some time and never changed, is the one that actually states that you have to have a master's degree or a bachelor's plus 5 years of experience. No one can change the ENA Act except the Congress itself. Now, if the Congress decided to change it, that Congress needs the majority of votes, which is very, very, very difficult to get when it comes to immigration. So my answer is there is not going to be a change to the advanced degrees requirements for EB2 and AW, and there's not going to be a change or possible change for the criteria itself for non-STEM, STEM professionals, entrepreneurs, and scholars. All paths would be the same probably for the next 4 years. It would be interesting to see if he would really broaden the EB2 and AW category or not, show his directions to USCIS officers. But otherwise, I don't believe that there's going to be much change in this practice.
Wow, that's so insightful. And okay, so thank you, Kavya, for your participation and for your question too. So here's another question, that I would like to ask: that how might the reinstatement of policies like remain in Mexico affect the asylum seekers' chances of success in their application?
Yeah, that's a very interesting question. So if that person is Mexican, for example, and he or she has a visa and they can come into the U.S. Through a legal way, then probably they wouldn't face much challenges. Now, if that person wants to come illegally into the U.S., probably that statement will apply to them. Now, if that person is not Mexican, and let's say he or she is from Argentina and they traveled to Mexico and they wanted to come through the borders, Mexican-U.S. borders, then USCIS will actually try to stop them by, again, building a wall or whatever, and that will be through the CBP officers at the borders. So if Trump changed the policy again and tried to spend a lot on building that wall, that would be number one. Number two would actually be, and he tried to do that before, actually. He tried to sign an agreement with Mexico, which we call in immigration a third safe country agreement. If you are an Argentinian living in Mexico, do asylum over there. Do not come to U.S. To do asylum, to seek asylum. And that's crazy because Mexico may not be safe for Argentinians or for even Mexicans. So he tried before to pass this kind of international agreement, and he failed. It's very difficult to do. And because Mexico is also in the NAFTA agreement, which changed to the USMCA agreement between Canada, US, and Mexico, it's very, very difficult to try to build a different agreement, especially for a safe third country, saying, well, anyone who is in Mexico on a Mexican land will have to apply for asylum in Mexico, and he or she would not be allowed entry into the US. So it's very, very unexpected. I hope that covers all types of people who might actually come from Mexico, whether Mexicans or non-Mexicans coming to the US legally and versus, of course, illegally.
Absolutely, and I think that's very well explained. So, to our viewers, also, friends, if you are navigating, your immigration journey, or have any doubts, or need any type of guidance related to immigration, then please feel free to contact Attorney Amin at the number that is provided. That is 407-578-1334. So this is the contact number that you can call him and ask your doubt. And with this, you can also email him on yacoub@boganmonths.com. And you can also visit his website, that is www.boganmonths.com. So these were the contact details that I would like to share. And now moving ahead with my one more question, I mean that I would like to know about family-based immigration, right? So
Yeah.
now I want to know that how do you anticipate Trump's approach to family-based immigration will impact the individuals who are applying for visas or seeking asylum?
Um, Applying for visas or seeking asylum.
Mm-hmm.
So if someone is marrying a U.S. spouse, they are allowed to adjust status based on their marriage if it's a bona fide marriage. So if it's a good faith marriage, of course, and we could prove that that you can actually skip all the asylum process, you can skip all the visa process, and completely go ahead and apply for the I-130 and the I-485, I-765, I-130 and one, and basically get all the cards you can get in the least period of time possible under USCIS. So family-based immigration is highly recommended if you do have an American spouse, or if for example you have a father or a mother who is a U.S. citizen. Now it differs from, again, it's just the categories are different. So you would have a first preference for the spouses, father and mother, and first preference is actually for the spouse. Second preference is for the mother and father. Third preference will go towards sons and daughters, and fourth would be the brothers and sisters. So the lower the preference, the more years you would have to wait. Otherwise, there is no interrelation between visas or seeking asylum and family-based immigration. We can see some cases where basically a person who is applying for asylum in the middle, having a CO8 card, for example, pending asylum, waiting for the interview, he may actually marry someone in the process. And just by marrying an American citizen, that will completely change matters into getting the green card through marriage, not through the asylum process. And later on, after they have the green card, they can basically send a letter to USCIS and ask USCIS to withdraw their asylum case and basically go ahead and do the green card through the marriage-based immigration, which is family-based. Otherwise, there is no foreseeable impact on these types of visas.
Absolutely. And I would like to know from your side that it's almost 1 hour that we have reached. But I have some more questions from my Facebook group. So if you have some time, is it okay for you to give 5 to 10 more minutes to our audience?
Yeah, sure. 10 minutes are okay.
All right, that's pleasure. Okay, so we can see here. I hope you can see my screen, right?
Yeah, I see it.
Yes.
So, what a
Yeah.
pending EB2NIW affects you in getting H1B visa? Waiting time can acquire H1B while there is a pending EB2 G1 holder. Thanks, Brian. Yeah. So that's an interesting question. So the H1B especially is a different breed of visa. So we call it a double or a dual intent visa. It's an immigrant and non-immigrant at the same time. And that basically means there is no contradiction whatsoever between the H1B and EB2 and IW, because EB2 is an immigrant visa. So applying for a double intent visa like the H1B at the same time was applying for EB2 national interest waiver, which is an immigrant visa, that does not show any contradiction in any intent. So you can go ahead and apply for the H1B and also apply for the EB2 NIW. But the trick here is to maintain your legal status through the H1B, because otherwise you may actually fall out of legal status since the dates are not current yet for the EB2 NIW. Meaning that if you got an I-140 approved, you would have to wait some time before you can apply for a green card and a combo card. So that means between the approval and applying for a green card, you would need to maintain legal status through the H1B. So it would be highly recommended to actually go ahead and secure an H1B before you apply for the EB2 national interest waiver.
All right, that's wonderfully explained. And here's another question that is do we need to submit ETA 9089 and related for EB2 and IW self petition?
Yes, it's a part of the regulations. So even though it sounds and it reads like it shouldn't be submitted, because it's basically a labor certification application for the firm process, you must submit it. You have to complete specific sections in the 9089 form. Right now, they have produced a new one, so you would have to download the new version and use it. And once you comply with the regulations and fill it out and sign properly, you have to include it in the submission. Otherwise, you will probably get an RFE requesting you to do so.
All right. So, moving ahead, here's another question that before submitting or mailing the petition, do we need to create an online account on USCIS?
No, you don't need to create an online account on USAS. I would say it would be helpful to do so, but you don't have to. You're not required to establish an online account on USAS. Now, it's helpful because it allows you to track the case, to actually get notifications whenever something is going on. If they updated your case, for example, into decided or approved or issued an RFE, you will get notified if you do have a USAS account. Now, if you're doing this through an attorney, your attorney would actually have access to your case and would actually get the notification from USAS on your behalf. So you don't have to do it if you have an attorney. I would recommend doing it if you're doing this on your own and would like to stay updated regarding any changes that may happen to your case.
Absolutely. I think taking expert advice is mandatory in immigration process. So, friends, if you still, need any guidance or need any help, then here's the contact details of our attorney that is mentioned, and you can see the contact details like phone number, email ID, and also the website that is being provided on the screen. So, please go ahead and share your, any information or any doubts that you have, and I'm sure that attorney Amin Yacoub is definitely going to take them up and he's going to solve them. All right. So, I would like to ask a few more questions, if you allow. That is,
Yeah, of course.
Yeah, that's great. And I don't know why. Yeah, that's great. My screen is visible now. So which part of the ETA 9089 need to be filled for EB2 and IW? I have already filled in the Appendix A and final determination forms.
Yeah, that's all what you need to actually provide for the new version. So it's just final determination and the appendix A. So basically, education, experience, certification, skills, which is appendix A, and then the two pages where you have to sign basically as the beneficiary, and that's all. And the preparer, of course. So you would have to sign. If you prepared your own 1989, you would have to sign twice on the two page towards the end.
All right. So I think that's all from my end because I have covered a few questions that I wanted to ask from you. And yeah, I think, I mean, it's almost time for our very insightful session. And it's just 1 hour we passed and we didn't even realize. So from my side, it was a very, amazing, a wonderful experience and obviously an honor to have a show with you. And you were outstanding. You were clear. You made up a very great points that that was very insightful and that was very eye opening too with the datas and with all the facts and stats that you brought up. That was great. So how was your experience in today's episode? How it was?
It was amazing. I really enjoyed my experience, and I actually really enjoyed the questions as well. They're very, very interesting questions from your side and from the audience side as well. It was really a pleasure being here, and thank you for the invitation.
Absolutely. And I think the questions, those were, interesting, but even the answers, those two were very much interesting. So I like that too. And there's another comment from Freelance Mastery also.
Yeah,
So
let's do that as the last question and move
all
ahead.
right. That's
Yeah.
great. So it's that what if my case was submitted under Biden's administration and got adjudicated when Trump's administration? Which administration am I entitled to?
Yeah. So probably that question has to do with the importance of the proposed endeavor than which administration would actually adjudicate the case, because they're the same USCIS officers. People think that, again, Trump is going to remove all USCIS officers and replace them with other USCIS officers. So they're just the same officers deciding the same cases under the same legal framework, whether under Biden or Trump. But your question might have a hidden question, which is there is a difference in the importance of there is a difference in the importance of policies between Biden's administration and Trump's administration. For example, solar energy is very, very important for Democrats and for Biden's administration, but it may not be as important under Trump's administration. So, since you have filed your case under Biden's administration, your case should be aligned with Biden's administration's importance when it comes to policies regarding solar, etc. Again, these are not black and white. So you have to understand that Trump is not like he's not going to dismantle the solar energy when he arrives. Again, like the biggest producer of electric cars is by his side right now. So we actually that's why.
I think due to some reason, Emin, can you hear us?
Yeah, yeah. I'm just saying, last thing I wanted to say is um, there there is not going to be a huge difference in policies and the importance of those policies, because right now Trump is more convinced of not solar but basically clean energy and stuff like that. But he's not willing to sacrifice oil and gas either. So we're going to be seeing a new Trump administration basically focusing on all energies, probably nitrogen as well. He talked about nitrogen cars, but he said, well, they're risky. So now that Musk is on his side, probably we'll be seeing a different approach towards electric cars, towards solar energy, and towards policies that Trump was in the past kind of reluctant to accept as important. Otherwise, to answer your question directly, your application will be decided based on the policies that are considered important at the time your application was received. So when you have received your USCIS receipt under Biden's administration, that's the time limit, that's the time estimate where actually the officer has to look around and say, you have complied, you're actually contributing to an important policy under Biden, not Trump.
Wonderful, wonderful. So, yeah, I think, Amin, we also took the last question of today's episode, and that too very well explained. So, again, to our viewers, also, guys, if you are navigating any immigration journey or having any doubts, then please go ahead and contact our attorney, and he's definitely going to help you out. And I mean, from my side, as I also said, that it was a wonderful experience to have a show with you. And you were also saying that you also enjoyed the questions that we prepared, the audience they were asking. So big thank you to attorney Amin Yacoub for making this session a brilliant one and bringing a very insightful and a very eye-opening stats and facts about today's topic. And I think, yeah, that's all, and to our lovely viewers also who participated in today's webinar, thank you so much to everyone. Keep on posting your question, friends, and we are definitely going to keep them on asking and try our level best to provide a best solution to you. So thank you so much, everyone, for this amazing session. Don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. I'm Sam, signing off for now.
Thank you.
Thank you so
Have a
much.
good day. Bye-bye.
Hello, everyone. Welcome to Immigration and Jobs Talk Show. I'm your host, Napasa Pradhan. And before we move on with today's amazing discussion that we have lined up for you, I have this important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks, thank you so much for joining us wherever you've joined us from. We are streaming live right now on YouTube, LinkedIn, Facebook, and also on X. So please feel free to drop your questions in the comments if if you have any, especially with regard to our topic of discussion for today. And it's going to be amazing because we have none other than well, our guest for today is Justin Rivera from Wasden Immigration Litigation, a senior immigration attorney at Wasden Immigration Litigation, and his passion lies in guiding individuals and businesses through the intricacies of immigration law. Well, Justin brings years of experience from top law firms and the Texas Attorney General's office with a proven track record of success in achieving the best outcomes for his clients. So today it's going to be awesome because Justin is going to join us once again. And today's topic of discussion, well, I will tell you what is it. But hi, Justin. Thank you so much for joining us today. It's so good to have you.
Hi, thank you for having me. Yeah, and I believe today's topic of discussion is going to be kind of just a roundup of the year. The different things, some of the different things we've seen in 2024. Maybe looking ahead a little bit on what we can anticipate moving forward.
Absolutely, yes. So, what shaped U.S. immigration in 2024? And we're going to do a complete recap. And thank you so much, Justin. I'm excited for today's discussion.
Sure thing.
So, folks, if you have any questions with regard to our topic, please feel free to drop them in the comments. We will take them up. We will address them a little later in our webinar today. And to start off, Justin, I have some questions prepared. And if you could tell us, USCIS recently announced that medicals are now required at the time of filing for the I-485 applications and reversing the previous policy allowing submission with an RFE. So, how will this impact the adjustment of status process and applicants' preparedness?
So yeah, this actually replaces a long-standing policy. It was something that had been, I believe USCIS had this policy in place for 25 years. Could be wrong, but I think it was something close to that. Anyway, traditionally, you weren't having to worry about presenting medicals at the time you applied because you would then just get a request for evidence. And then at that time, you could get your medicals taken care of. Now, the validity period of the medicals, that had been an issue. They had been much shorter than they are presently. I believe now they've moved them out to where they last a significantly longer time. They're still fresh, essentially. The argument basically posited by the service is because of that, let's just get the medicals when we're filing. And if you don't present them to us, we're going to reject your application. But that way, when we're actually processing the 485, we don't have to worry about issuing an RFE on medicals. We can just go ahead and approve. Beneficial in theory, and I think long-term, probably something that's going to be good. The issue will be its short-term implication. The announcement came out with next to no notice period. It was pretty much almost immediate, which inevitably is going to lead to an uptick in rejections, probably even improper rejections, where people are jumping the gun on implementing the policy before it was actually implemented. So that's going to be the short-term impact of it. I'm hoping that the long-term impact of it is of benefit in that it does create a situation where now that these are absolutely necessary at the time of filing, you present them and you're able to have your I-485 processed a little bit faster.
All right. Anything new added to the list? A list of medical examinations that you'll have to go through?
So I mean, the thing about it is it's kind of a constantly evolving animal. It's something that at any time there can be some sort of alteration or change made to what's being required. So that's the other side of the coin with medicals is, sometimes you would often be like, let's not worry about the medicals now. When they process your case in X amount of time, years or however long, if the policies have changed, we'll have to get new medicals then anyway. So as a result, just wait till the RFE comes out and address it then. So you do kind of have to look at what's the impact of that, because obviously USCIS is not going to say, oh, this is required when we're adjudicating, but it wasn't required at the time you submitted your application. So we'll probably just let you go through. It would shock me if they did do that. It would be practical, but it would be surprising. So I definitely think there could be an instance where, if something new comes out that's required, someone gets an RFE where they say, hey, now you have to, provide a new medical. But, that being said, it's not that big of an issue, or it shouldn't be that big of an issue. And hopefully, like I said, the underlying goal for them is to move down those adjudication timelines and make the process faster. And hopefully this does that.
Absolutely. Looking forward what this change would bring. Yes, for sure. Let's go on to our next question, Justin. And, what are the most significant immigration policy changes introduced by Biden administration or Congress in 2024? And how do they reflect the administration's broader immigration agenda?
So I think that they did some positive stuff. I mean, give them credit where it's due. I'm looking over here because I wrote them down. They did automatic extension of the validity for green cards to 36 months for LPRs who timely file before I-90. They are increasing the H2B cap with 65K additional for next year. That's positive. TPS for Lebanon, that's positive as well. From a practical practicing perspective, primarily dealing with, work-related non-immigrant visas and immigrant visas, I think that they have tried to speed up processing, which is positive. But the other side of that, at least in my opinion, is I think that when they've introduced these new premium processings for things that traditionally didn't have premium processing, I think that they have kind of pushed back against actually using premium by issuing requests for evidence. And I have traditionally been of the thought process that just by virtue of filing and premium processing, you're not really increasing your probability of an RFE. I may have to redact that statement after what I've seen over the past couple months. because I do feel like there has been an uptick in premium processing requests for evidence. So while it is in theory they're trying to do things to help the system, I do still think the system kind of gunks itself up to kind of give the adjudicators more time. But I think overall, the Biden administration, over the past year, they have taken steps to improve how the process is and streamline things. So that being said, with that administration moving out, we'll probably see a little bit different of an implementation moving forward.
Right, right. And just a few days left, before Trump joins the office. So, what do you think is happening in this 1 month? Almost a month, I think we still have a month.
You might see a flurry of action going out the door as they hurry to try and finalize policies in the Federal Registrar. I know that there had been talk about there's the extension, the automatic extension for H4 EADs, and then the L2s. They may make that. They may put that in the system permanently. They may make that through policy something that remains. That would be a positive, obviously. You might see some other small changes or designations, but the fact of the matter remains is anything that's not just like made law, something that's just an act, or like designations of TPS and things like that. Those are things that can be reversed with very little action that has to actually be implemented. It's the actual rule-making changes that take a lot of time to be modified. And those kind of permanent things, if we see that through the last month, that would be very beneficial. So we'll have to wait and see where it is on their priority list. But
Right.
I'm hopeful that we see a couple more positive changes.
Me too. Me too. All right, Justin. So, how did the Deferred Action for Childhood Arrivals or DACA program evolve in 2024? And were there any major legal or legislative updates affecting Dreamers?
So I definitely will say that I will definitely say here that DACA is not a main part of my practice. I mainly do, work based. That being said, I try to follow DACA. I did see that there was expansion for healthcare. So in the ACA marketplace, it was actually in the beginning of November. People who were on DACA were actually able to buy into the marketplace to get health insurance, which is awesome. And then there's faster work authorization for people that have earned a degree. I know that that's a policy that they're implementing or wanting to implement. So those were the two big alterations that I saw. A lot of, and I genuinely mean this, not like it's not a situation where I'm like a lot of people are saying, and I'm just bringing it up. I've had a lot of conversations recently about where DACA goes with the changing of the administrations. And I try to point out to those people that in terms of what the new administration wants to do for immigration, they've laid out a lot of track in terms of what it is they want to do. I think everybody is very familiar with the fact that they want to do the mass deportations, ending birthright citizenship. They've now talked about deporting pro-Palestinian student protesters that are on temporary visas, ending parole programs, and ending TPS programs. From what I've looked at, I haven't really seen DACA on the table. And I think the reason for that is because it is, generally speaking, a popular program. I don't think that there's a large amount of pushback against DACA, even from people that are more restrictive in nature for immigration policies. So I definitely think that you're probably going to see DACA in the news, and people discussing DACA and whether or not it's going to be altered or attempts at removal. All that is to say, my opinion would be I don't see it going anywhere, just because it doesn't seem like it's something that they have high on their to-do list.
Okay. Okay, thank you so much, Justin, for the detailed explanation. And folks out there, thank you so much for joining us. You can keep commenting if you have any questions. Type them in the comments and we will be able to address them in this show. And thank you, Priyanshu, for your question. We will address it a little later. So stay with us, all right? So, Justin, my next question to you is, did the US immigration system witness any new visa reforms, particularly related to the H1B program or family sponsored immigration? And if yes, what were their implications?
So a really big one for the H1B was the beneficiary-centric lottery. Moving away from the idea that multiple petitioners are able to, quote unquote, game the system by putting an individual in, a multitude of times with the intent of just making sure that they get selected. Now it's beneficiary centric, meaning regardless of the number of sponsorships, it's one person is entered one time. There's no real way for you to utilize multiple registrations. So that was a very big change because I think in the past, there's been this idea that there are certain types of companies or joint groups of companies that will seek to work together basically to improve their odds of selection. So that's gone. Increased fees was another thing. You saw fees going up. You saw the introduction of the I believe we call it the asylum fee now, this extra $300 fee that's supposed to be utilized for people for USCIS to reallocate at the border. That was something. Online payment was another thing. Being able to file applications online and actually have legal representation for those H1B payments. The credit card payments, I think, was another thing, at least for me. I hadn't really used that at all in the past, but now that's something that I think is becoming more common now, just the ability to just use the G1450 form and make a payment from a credit card rather than having to just use traditional checks over and over. I think that's been beneficial to streamline the process. There's definitely been, I don't want to say attack, but USCIS has focused on multi-registrations from past lotteries. That's something that I've seen. An increase in notices of intent to revoke for people that they believe were sponsored by an organization that colluded with other organizations to increase the probability of someone's selection. This is something that's being kind of fought on in court. Our firm, Wasden Immigration Litigation, actually has some cases active in this manner regarding this factor, but it is something that we continue to see. And it's something that might continue into next year. It just really depends on how much USAS is trying to push the issue. The other thing that I've seen personally is an expansion on the scope of notices of intent to deny and notices of intent to revoke as they relate to previous alleged assertions of fraud or misrepresentation. Kind of giving you examples here, I've definitely seen situations now where people are trying to extend a current non-immigrant status. Maybe they're trying to extend an H4 or an H1B, and they get a notice of intent to deny, basically saying that they are ineligible due to an admissibility based on a perceived finding of fraud or misrepresentation based on a prior non-immigrant visa. A lot of times this is an F1 issue, particularly with working with some of these, quote unquote, fraud employers. But I've definitely seen an uptick in that as well. Whereas, even maybe 2 years ago, you weren't seeing any attacks on admissibility for people that were extending status in the United States. At least I wasn't seeing them. So that's another thing that I've witnessed as well for the H1B program. Prospectively, I think we've had previous discussions about this. It's definitely, there's a lot on the table in terms of what wants to be done by the next administration coming in to make changes. Realistically, those changes will make the system more restrictive, but we are in a wait and see approach. But kind of curtailing the end of year for what the Biden administration seemed to do with the H1Bs, they really wanted to go after fraud. That seemed to be their biggest goal, was going after fraud or misrepresentations that had been made by companies. And unfortunately, the impact of that is wide-reaching in that it can also impact employees. So the employees in some of these circumstances have ended up having their cap subject H1Bs revoked, which puts them in a circumstance where they're not able to be on an H1 anymore because they're no longer cap exempt. So that has been something we've dealt with as well. But I definitely think fraud, misrepresentation, going to be on the table next year. I think going to be a big aspect of the new administration. Would not be surprised to see a significant uptick in, site visits, FDNS investigations. I think all of that is going to be on the table moving forward.
Absolutely. We are in for a lot of changes starting 2025, folks out there. You just have to stay updated. Research is important, and it's very, very important to stay updated with each, because
everything is so dynamic and it keeps changing, like Justin
Mm,
mentioned earlier. There are always new updates, so you just have to be very, very vigilant, careful, and updated for sure. And
right.
folks, you know what? You can also join us in this conversation, by the way, by dialing in this phone number. And you just have to dial 425-436-6335. And when they ask for the access code, dial 988-888 and just say hello. We'll be able to hear you. Looking forward for you to join us on a call. So also thank you to Yash Chopra for your question. Stay with us. We are going to address your question a little later in the show. All right. And so, Justin, now my next question to you is, how did U.S. Customs and Border Protection, or CBP, and Immigration and Customs Enforcement, or ICE, approach border security in 2024? And were there any notable incidents or shifts in enforcement tactics?
So I will say that according to CBP's website, they have tripled their expedited removal numbers from last year. So I think there was a significant uptick in expedited removal. Now, how does that apply to people that are attempting to enter the United States on a non-immigrant visa? Well, every time you are admitted to the United States, you are inspected. You undergo inspection with CBP. Most of the time, that's people who are flying in. So when you go through CBP at the airport, you open yourself up to inspection. That inspection can be pretty brief and quick. If an officer just makes a very quick determination, says, okay, I don't see anything in your record, you're good to go, then you're fine, you go right through. If there is cause for concern, an idea that there's a problem, or maybe even a notation in the person's immigration record, that person is put in what's called secondary inspection. This is a longer interrogation period. When they're put into that circumstance, they are basically going to be questioned about whatever specific reason the officer initially pulled them in. They'll probably talk about their current non-immigrant visa, any prior non-immigrant visas. They can bring up statements that were made at the consulate, statements that have been made to officers in the United States. All of that is on the table. I have definitely seen, just anecdotally, an increase in my opinion, aggressiveness with officers and how they are operating when they do these CBP delayed secondary inspections. And when they're in that circumstance, they have a lot of power. They have a lot of power over the individual because they're able to make determinations that are long-reaching. If they cancel someone's visa and they place them in expedited removal, that carries with it a 5-year ban from the United States. And that's not even speaking to the reason for the removal. If the reason for the removal is related to fraud or misrepresentation, then you're also incorporating a lifetime ban. So I have definitely seen an increase, in my opinion, in that. The officers, when they do these inspections, they have a right to look at the information that is physically contained on your person. This includes things like a computer, a phone, any of that stuff, social media, emails, all of that is on the table. Just anecdotal, just speaking off from personal experience, resumes have become a very big point for them. They are very, very diligent in reviewing people's prior resumes. If they have a copy of the physical resume on their person or a copy of the resume on their computer, they are looking at these documents very closely. They want to look for, did you list an employer that you didn't actually work at? Did you list an employer that they're alleging you didn't have work authorization to work with? Did you ever verify that you worked with that employer? And if you didn't work with that employer and they were listed there, did you try to procure an immigration benefit using that resume? I have seen a lot of cases over the past 2 or 3 weeks where people were dealing with these resume issues, where they were either drafting a resume or making changes to a resume, and the iteration of the resume, even if it's not the final version, was on their person when they were going through, and they were pulled off, and this issue was brought up. So I would say, just kind of generally speaking for everyone moving forward for the next 4 years, really good idea is, if you're going to carry any form of a resume on your person when you're coming into the US, that resume needs to be 100% accurate and up to date. And also be prepared for any and every item on your person to be open to inspection. So if that means making a determination like shipping your laptop ahead of you instead of carrying it with you on your person, that's something to think about. I know people are not going to ship their phones. I know the world we live in. But if that's the case, maybe be aware of everything that's on your phone, because it is all information that the officer could look at. So yeah, just kind of buttoning that up. I think we've seen higher rates of screening, and I think we're going to continue to see that moving forward as we move into the next administration, because there is just so much power. There is an imbalance of power when there's a CBP inspection underway, because you have someone that's in a room, they don't have legal representation. They are opened up to questioning. Most times these people are not prepared for these questions. They're probably being asked about employment that was 4, 5, 6 years ago, from a time where they were maybe on an F1 or on an H with a different employer. Makes you open to possibly making misstatements. And those misstatements are something that the officer would seize on and, use it for grounds for visa revocation. So I do think that moving forward into the next couple of years, we as counsel and then the employees are really going to need to become simpatico on being ready to deal with these issues, dealing with the idea of increased scrutiny for inspection and making whatever changes we can to ensure that the process is as smooth as possible when somebody's applying. Because at the end of the day, no one's going to just hang out here for the next 4 years under the guise that they're scared to leave and re-enter. It's just not realistic. So we do have to have a plan in place on how we help people moving forward.
Right. Well, thank you so much. And talk about investigation or scrutiny. I think we will not have any more privacy then. I mean,
No.
if everything in your phone can be checked, that means anything and everything in your life can be checked.
Right. And there's circumstances where people have had their emails gone through for, 8, 9 years long of emails. Just an officer just going through everything, typing in employer names, typing in manager, supervisor names, because their goal is to look through everything to see if there's anything that they can find that gives them cause to move forward with revoking a visa. I think it's been more difficult moving forward, and I think it's going to be much more difficult as we deal with the next couple of years.
Wow. Thank you, Justin, for giving us a sneak peek into what we can expect in the future. I think we should address Priyanshu's question now from YouTube, saying, I'm waiting on my green card. What do you think were the most important changes in 2024 that could impact me? Okay.
I mean, if you've already filed and you're waiting for adjudication, then hopefully the process is fast enough that it's been streamlined and you're not going to have to wait a long, long time. If your 485 is pending, and hopefully it moves quicker. My worry prospectively would be a really easy way to make immigration more difficult without having to actually make wide sweeping changes is to really just make small changes that slow down the process. Small things that we now require this, which we didn't require before, or we're going to start requiring interviews for everyone in this type of category, even though we haven't done that in the past. That was something they did before with the introduction of biometrics in categories that traditionally hadn't required biometrics. It's adding steps to slow down a process to make it much longer and more difficult. That would be my worry moving forward. I would definitely hope for you that you're hopefully able to get your 485 adjudicated before the end of the year. If not, hopefully before, maybe February of next year. If that's not the case, it'll be another wait and see. But I'm hopeful that they do seem to be operating under the desire that they're trying to move cases as quickly as possible. So for you, I would just say, the changes in the medicals, that shouldn't have affected you because you've already filed the 485. And hopefully you're just able to get everything as quickly as possible.
Me too. All the best, Priyanshu, and thank you for participating with your question. If you have any further questions, you can keep commenting. And now we have Yash Chopra's question. For students on F1 visas, were there any updates this year that made it harder or easier to stay in status while they're studying?
So one thing I did notice that I hadn't noticed before was there had been kind of an expansion on STEM OPT, like what kinds of categories, what kinds of study, what fields qualify for STEM OPT. As a result of that expansion, I definitely saw an uptick in requests for evidence in relation to, I believe it's called the CIP. So it's the specific number that's basically used for the program type. and then the need to show a nexus between the CIP type chosen and the actual STEM OPT eligibility based on the field of study. I think that it's interesting because I don't know if USCIS did that just because they were thinking that people were overreaching on getting people into STEM OPT, or if they genuinely were just saying, how does this correlate? I actually personally hadn't seen any denials because most of the time you're able to get something from the school that provides a very clear-cut explanation. However, I do think that opens up a window into a potential strategy for something that could be used for the Trump administration moving forward. It's possible that targeting the CIP codes a bit harder and making the regulation more restrictive could result in the removal of some fields. We'll see what happens with that, but that is something that I look to, that I wonder about moving forward.
Okay. Thank you for taking that up, Justin, for Yash Chopra. And I wonder if you deal with asylum cases, but we have a next question from Sunita about asylum. So maybe we
So
can.
I don't specifically work on asylum cases, but I will generally tell you that asylum applications, my understanding with asylum is that the process was still difficult. It was still not an ideal streamlined process, but it was still somewhat better than what it was like in the Trump administration. In the Trump administration, I think it's going to be significantly more difficult than it was. I think that asylum is one of the specific things that he looks at targeting, or that his administration looks at targeting, is limiting the ability for people to even apply for asylum in the first place. You're looking at things like Title 42, the MPP Remain in Mexico program, just more generally the border wall. I know that they definitely look at ending TPS for people. So that's something that's on the table as well. But yeah, I would say, just generally speaking, I know asylum is probably going to get much harder. I don't even think the asylum levels were very high this year. And that being said, knowing that, I think that moving forward, it's going to be much more difficult.
All right. Thank you. And Sunita, I don't know if that would be helpful enough, but there you go. Thank you, Justin, for taking that up.
Mhm.
And yes, moving on, my next is also about asylum, actually. The US saw a significant number of border crossings this year. And what changes were made to asylum protocols or Title 42 policies to manage the influx?
So we know Title 42 obviously had been taken off of the table eventually by the Biden administration. A lot of people complained that it wasn't done as quickly as they wanted it to be done, but it was still something that was inevitably done. And so that was beneficial, obviously, for people that are trying to get into the country to apply for asylum. I think that you're going to see a reiteration of that policy somehow. I'm not sure if they're going to use like bird flu or something like that as a justification, because it has to tie to a health concern. But I do think you're going to see that coming up. I think that the Remain in Mexico program is going to come back as well. I think that that's going to be something that's on the table. And I think that you're even going to actually see an iteration of that implemented in Canada, because they have already come out and started making statements about, people immigrate, people come in, illegally, quote unquote, not only from Mexico, but from Canada as well. So we need to increase scrutiny. And how do they do that? They probably implement similar policies that they have along the southern border. So yeah, I think that you're going to see restrictions. I mean, that's what people voted for. They voted for the idea that they wanted to curtail entries at the southern border and to a lesser extent, I suppose now, at the northern border. And so I think what you're going to see is at least a desire from the administration that's coming in to really get a handle on those numbers and curtail them, because that's how they're really going to try to show that they're implementing the promises that they made. And so they have a lot of avenues, I think, that they're going to be able to do. I mean, family separations obviously on the table as well, even though it was incredibly unpopular. You're dealing with a circumstance where this administration's coming in and they know that they've been able to do something like this in the past. So they're probably going to lean towards it moving forward. So I think you're going to see all of that. I think there's no way to me that we're not going to see numbers drop. It wouldn't make sense. I think that there's going to be crossings should go down. If they don't go down, I'd be very surprised.
Okay, okay. Well, yes, I think border security is going to definitely get harder. And now that we have our border czar, Tom Hooman, I think he's going to do everything to make it even harder.
Yeah,
Yeah.
absolutely. It would not shock me if there was everything on the table in terms of what they can do. I think there's going to be more officers hired, more money thrown into this
Yes,
circumstance, the re-implementation of all the policies that they were able to use last time, and then a couple new things that they didn't have before.
for sure, for sure. Well, thank you, Justin, for taking that up. And now, my next question to you, Justin. I'm really rushing through, right? I really hope you're okay with that. But yeah, with the labor shortage continuing in key industries, how did changes in employment-based immigration policies such as the H-2B and the EB-3 visas shape the U.S. economy this year, 2024?
So yeah, I mean, I think you saw it with the H2B expansion. The fact that they're hiring, they're expanding. I think it's by 65,000. I think that they definitely realize that there's a shortage. Actually, Roshni just asked a very similar question, that there are shortages in certain industries, particularly farming, that needs more employees. Like there needs to be more people doing those agricultural jobs because there's just not a workforce there. So I think you've seen, the Biden administration implement policies in order to address that issue. Do those policies remain in place moving forward? I kind of think they do. Just because things like the H2B, it's genuinely beneficial, and I don't see a lot of pushback. In terms of all of the different types of immigration programs that have high approval rating, I don't really see a lot of pushback for the H2B. Also speaking kind of more generally about healthcare and those those other industries that have shortages that are typically filled by non-immigrant visa holders. I'm hoping that there'll be a bit of credence given to them moving forward. I think maybe there hopefully will be more of a preferential treatment to those fields when they're trying to fill them with specific non-immigrant visas, because I mean it's needed. And I definitely think when you kind of look at immigration, there is this push and pull with immigration where even the people I think that are hardliners on immigration will admit that restricting immigration within the parameters, within the fields that have valid shortages, it's nonsensical, because if there's genuinely not a workforce available domestically to fill that need, then there has to be someone else that's willing to come in. And that's where you have to utilize immigration. So I think that I've seen positive movement on that regard over the last year. And I think, I've been critical a lot of the Trump administration and immigration. I actually think you might see that remain as we move forward. I think that that's not something that they're really going to want to push back against, because it has that high approval rating. It just, we don't want to create shortages where there's literally just not people to perform agricultural work. And you're dealing with circumstances where there's just not employees available to do stuff, and people in that field are losing money as a result, and it's being felt by consumers because there's less availability. So all of that would lead me to believe that that's something that it has been trending in the right direction, and it's going to continue to do so.
Wow, thank you so much, Justin, for the detailed explanation, and also for taking up Roshni's question at the same time.
Yeah, it was very convenient.
Yeah, actually, yes, made sense, and thank you for doing that. Well, moving on, what impact did new immigration trends have on American industries? Well, since we spoke about it already a little bit, but healthcare and tech, where foreign labor also plays a critical role, if you want to add anything more to this point.
So I think a big thing to at least address on is tech and where we're going with the tech industry. I think that there's a back and forth right now in terms of what is wanted by people in higher positions of the Trump administration. You have the Stephen Miller side, restriction, America first, curtail immigration as much as possible. But then on the other side of that coin, you have the tech industry people that have supported the Trump administration. Obviously, you have Elon Musk, Vivek, and then there's other individuals as well. Those individuals, it would make sense, want to ensure that the tech industry continues to thrive, and in doing so, utilize, foreign employment. So that's going to be things like increasing or keeping at the same level individuals that are, employed on H1Bs, L1s, TNs, all of that. So I think that, tech is, it creates an issue of who wins out in that circumstance. And it would make sense to me if you saw the tech industry, if they're continuing to grow, continue to utilize these non-immigrant visas without as much pushback as I think you may see in other industries. And then to be truthful, there has been conversation about, is there almost a two-tiered system of the way you look at the allocation at this point, where, if you're the big company over here and you apply, your process is a streamlined approval. If you're a smaller company or maybe a consulting company, do you go through a more rigorous, detailed process that requires you to jump through a couple more hoops? And I do wonder if that's going to kind of be what we see. I think it's been something that's already existed with the Biden administration. I mean, personally speaking, I've worked on both sides. I've worked with very big companies and very small companies. Everyone gets RFEs at the end of the day, whether you're a big company or you're a small company. The detailed nature and the specificity of the RFE may be a little different if you're a smaller company than you are a big company, especially if you're a third-party placement company. And so I do wonder how that's going to be impacted moving forward with tech and what we'll see there. For healthcare, kind of speaking on what I said before, industries that have legitimate need and have shortages, hopefully moving forward, we're going to see that factored into the analysis of visa allocation.
Yes, I think it's very important to be proportionate, in all levels so that, these needs are met optimally, I guess.
Right. Yeah. I mean, especially if there's literally just not availability. I mean, if you're in a situation where you're an employer and you need to fill a position and the applicant pool is tiny and the applicant pool is being overfished because there's so many companies that need these people, you have to find that somewhere. That position doesn't go away. Need has to be serviced. So in order to do that, you have to, look to what your other options are. And that includes, bringing people in.
True. Well, thank you, Justin, for taking that up. So did 2024 bring about any significant changes to family reunification processes or humanitarian visas, such as the U visas or the T visas? And how did these changes address the needs of vulnerable populations?
So again, as I said kind of earlier, not my specific wheelhouse, but I do have a cursory understanding of U and T visas. So for the U visas, I know that they made some tweaks essentially to the eligibility category, basically moving it to where you needed to prove not only that you were assisting law enforcement or attempted to assist them, but that the actions were helpful to law enforcement during the investigation. So I know that the goal of that, I think, is supposedly to streamline the process. But obviously with changes can come additional scrutiny. So whether or not that helped, you would have to speak to someone who specifically works on those kinds of visas. But I know that the goal was to make the process better as a result. Now, with the U visa, you do have that 10K cap. And I know that there's a pretty big applicant pool for that 10K cap. And I know that cap gets met pretty consistently. So I know that there's a long processing, and that's probably something that's going to continue. I don't think that that's going to be at the top list of the new administration's to-do list for immigration. The T visa, I know that they wanted to streamline the process for victims of human trafficking. They made changes to eligibility qualifications, and then they wanted to modify what they call the bona fide determination process. So I know that those are both situations. If you're unfamiliar with it, T is, victims of human trafficking. U is basically people who can help the government because they either witnessed or were a party to some sort of criminal activity against their will, and they're now seeking to use that information, and they want to help the government, and in return the government seeks to help them by giving them a visa. So those are two different ways that people can qualify for that. And I think 2024, outside of those changes, those were the only ones that were made immediately aware to me. In terms of what you're looking at prospectively moving forward, I doubt that there'll be a lot of change. I don't think that there'd be any reason for there to be a change. Again, this is another one of those circumstances, kind of like the H2B, where you look at these visa types, the U and T, and you say, what's the approval rating of these? I don't think people push back a lot against helping people that are victims of human trafficking, or people that were, victims of criminal activity that are trying to rectify that issue. So I think you're probably going to see a lot of status quo moving forward.
All right. Thank you so much, Justin, for taking that up. And folks out there, you can call in to ask your questions, and maybe take this opportunity to have a one-on-one, like short consultation, you can say, with Justin if you have any questions for him. And you can call in this number, dial this number 425-436-6335, and when they ask for the access code, just dial 988-888 and say hello. We'll be able to hear you. And yes, looking forward if you can join us. And so, Justin, many applicants faced lengthy processing delays this year, and how the policy changes or staffing improvements address challenges, faced by those awaiting green cards, visas, or even citizenship approvals this year.
So, I mean, generally speaking, as they're one to do, USCIS has asserted that they've increased processing times and that there's been significant improvement. Now, the idea that there's been significant improvement and then the actual day-to-day, people with boots on the ground implementation of it may be two different things. Kind of going back on what I'd said before, I mean, advanced parole is better. That has sped up significantly. I know that fiance visa petition timelines have gone up, and then also citizenship, the N400s, those have been processed faster. The other thing has been that expansion of premium processing into categories that previously didn't have premium. That is, in theory, supposed to speed up processing times. What it looks like in reality, though, is that though they're basically taking those fees and turning around and issuing a request for evidence. That's not to say that it's an absolute certainty, 100 out of 100 you're getting RFE'd. But I personally, like I said on a previous question, have definitely seen an uptick in the issuance of RFEs for premium processing cases. And honestly, some of the RFEs are lazy. I say that meaning, specifically, I have a case presently that has a request for evidence pending on it that is asking for someone to show that they have continued to maintain H1B status at the time they applied for the benefit. Well, this isn't an extension. It's a change of status. The person's in a different status and is changing status to H1B. So if you were going to ask about maintenance of status, those questions should have been about the person's current non-immigrant status, which is not H1B. So there's basically an RFE that was issued for a nonsensical reason that has to be addressed, because if you don't respond, then you open yourself up to a denial. But as a result, when the RFE is responded to, it goes back in the queue for processing, but it buys the officer time. So even though they've issued something that has no real rational basis, at the end of the day, it takes time. Takes time to get to us in the first place. Takes time to draft a response. Takes time to send back to USCIS. And all of that gives the officer more time to handle the adjudication and still operate within the auspice that they are fulfilling their premium processing obligations. So that would be my thing. Is I feel like with premium, some people say you're buying yourself an RFE. I don't 100% agree that you're buying an RFE, but I do feel like the RFEs are being used as a method to delay adjudication, whereas their proper usage would be to ensure proper adjudication and provide additional information as needed.
All right. Thank you so much, Justin, for addressing that. And, I also have a couple more questions from our YouTube channel, if you don't mind. We'll quickly
I got
go
a
through
couple
them.
quick minutes.
Cool. So let's go with this first one. Control, if you can zoom in a little bit. Hi, my interview was on 16th September 2024. What does this mean? This is the image that...
It means your application's pending. Like, I'm sorry, I can't really give you a lot more than that. Your application's pending. Now, that being said, what can you do about your application pending? You can look at your processing times and see if your application has fallen outside of the parameters of processing times. If they have, then you're eligible for a service request. So I would look into that as a possible avenue to remedy it. Another thing that you can do that I've talked to individuals about is actually call USCIS and ask them for a specific case update. Some officers are more willing to go into a further level of detail. It just kind of depends on who you get on the phone. But I would look at maybe expediting request if possible, based on service processing times, and then also calling.
All right. Well, thank you so much, Justin, for taking that up. And now moving on, let's go with our next control. If you can just show us. Would you write an amicus curiae, I don't know if I'm pronouncing it right, brief on
Yeah,
2313?
it's an amicus brief. I don't know if I would write an amicus on a case that I'm not familiar with. I would have to look at the facts to actually make that type of determination. Amicus briefs, I mean, that's a process. That's basically you saying that even though I'm not a party to the case, I have an interest in the outcome based on, Ayla's done some of these actually recently on different decisions. There was a huge case a couple months ago for people, and I don't expect you guys to pay attention to this, but for people on this notion of consular non-reviewability. So consular non-reviewability is the idea that a consulate can make a determination, an officer can make a determination on visa eligibility that is above review by the U.S. court system. It basically says if your visa is denied for X, Y, Z, whatever, that is the officer's determination, and a court will not look at that in the U.S. So there was a very interesting case because consular non-reviewability is a powerful tool. It's basically something that, the officers make a decision. You can't really get to the officer to get them to explain their decision, and you can't attack it to try to overcome it. It's very, very narrow routes. Some legal net is one of these, but it's very narrow. It has to be specifically a legal question, not a factual question. So all of that leads to there is a lawsuit for someone who's a U.S. citizen whose spouse is denied entry, right? So they sued under the guise that consular non-reviewability is not as wide in its interpretation as it should be. Meaning there should be specific instances where the consulate's action should be reviewable. For example, if it directly harms a U.S. citizen, right? By saying that the spouse can't enter the United States, direct harm to the citizen is harmed. What is their redress? They can go before the courts. They have standing. So while that case was pending, Ayla provided an amicus brief. And their amicus brief was really attacking the idea of consular non-reviewability. Basically saying that these officers have far too much power. Their determinations not being challenged lead to people making incorrect conclusions. And those incorrect conclusions then become patterned because if they've made that decision before, they'll make that decision again. So all of that leads to this notion of there should be some circumstances, for example, when a U.S. citizen is directly harmed by a decision that remove the bounds of consular non-reviewability. So that was something that they amicused in on to see if they were able to help sway the court's opinion. FYI, they did not. So consular non-reviewability still reigns supreme and exists as an absolute bane in the existence of any immigration attorney.
Well, thank you so much, Justin, for the detailed explanation. Let's move on, Control, to our next one. This is, hi, has anyone had an issue not receiving an H4 EAD renewal rejection notice? Can we have the full one, please? This is the half. I filed my H4 EAD renewal before.
Oh, goodness. I think generally I probably know what they're talking about. If you hit read more, it's probably going to say that they filed their H4 EAD renewal, never heard anything back, and never got a copy of the rejection notice, right? So that is not, unfortunately, that is not entirely uncommon. It's literally something I've had to deal with before too. So yeah, it's not a great situation. Because what it does is if you don't apply before the EAD card, you may not be able to get the automatic extension. So that can happen. And there we go.
Yes.
Yeah.
So I filed my H4 EAD renewal before my EAD expired, but never received the rejection notice. I only found out about the rejection when I contacted the USCIS lockbox multiple times, but they responded me in August, and by then it was too late to reapply for my EAD expired. I reapplied in September, but now the receipt notice that is automatic extension isn't valid anymore because EAD has expired. Has anyone else faced this? Yeah. What should he do?
Yeah, so it's not the first. It's definitely not the first time I've seen this situation, and it's unfortunately it's a tough bet, because the prerequisite of the eligibility is that you're filing that before the expiration. So the only thing I can give as advice, generally speaking, to people who are worried about rejections is your timeline for getting that receipt notice should be at most 2 weeks. So if you're getting to a point where you're past 2 weeks, you need to start checking to see, whether or not the case got rejected. A trick that we use in my field, and I will pass on to you all so that you can use it, is file with a check and contact your bank to see if the check cashed. If the check's cashed, that means USCIS should have receipted your case. If the check has not been cashed and it's been 4 or 5 days since USCIS received your application, that lends itself to the notion that your case has been rejected. So in that circumstance, you may want to jump the gun, especially if your EAD is expiring soon. Jump the gun, submit another application, and just do it as quickly as possible. That way you're able to send another one in. Hopefully the issue is corrected. Double check, triple check, maybe even talk to an immigration attorney beforehand so they can look at it to see if you're missing anything. And then just send another one. Worst case scenario, you get 2 receipt notices. Costs you a little bit of money, but gives you peace of mind, and then you open yourself up to being eligible for that extension. So that would be it. The EAD, there's not a whole lot of reasons why the EAD gets rejected, to be honest. The I-765 application is pretty straightforward. Pictures is going to be the big one because you need the 2 passport photos. I've seen rejection for that before. The other ones is signature. Did you not sign or date somewhere where you were supposed to? And so those would be the big 2 things that I would look at to see whether you missed something in your analysis.
Wow, I love how you answered that. I mean, it's a great trick to also know. Thank you so much, Justin, for taking this up.
Mm-hmm.
Let's go on to our next one quickly, please. If you still have got some time, Justin?
Yes, dwindling, but a little bit, yes.
All right, so should we wrap it up then? Let's look back at 2024. For you, Justin, maybe you would like to tell us about a case or something significant that you would like to share with us today.
Yeah, absolutely. That would be great. Thank you. I would say for, 2024 has not been, it's been decent. It's been a decent year for immigration. The big things that I've really seen are really this honing in on this fraud findings and this idea that, for example, you have these kids that maybe went to school on F1. They needed to join employers for OPT or STEM OPT, and they were approached by an employer who said, "Hey, come work for our company. We'll help you out. You pay us a fee for training, and then after the training's done, we'll put you at a client site. It'll be great. You'll work at amazing clients, Amazon, Google, Volvo, whatever,
Yeah.
And these kids say, okay, and they do this, and they go work at these companies, and they do these trainings. They're maybe 2, 3, 4 weeks of training. They come out of the other side of the training, and they say, well, where's my work? And the company's either telling them, we can't find anything, just hold tight, or just not even talking to them. So that happened to an unfortunate amount of people. This has led to USCIS kind of overall, like not even just USCIS, all of the agencies, all of it, DHS, CBP, everyone. There seems to have been this conclusion that if you did that you engaged in fraud or misrepresentation because you worked with those companies to secure an immigrant benefit, be that your OPT or your STEM OPT application. As a result, you've had an admissibility increases for fraud or misrepresentation. There have been people who've come into the United States and been put in expedited removal. There's been people who've been denied at the consulate. There's been people who've even tried to apply within the U.S. for extensions and are dealing with this fraud or misrepresentation. This has been a wide-reaching thing. It's been something that we've been really working on. We recently had success on a couple cases. There had been previous success as well, but there was 2 very big recent successful ventures for 2 big groups of plaintiffs where they're now moving forward. Those inadmissibility findings are going to have been removed from their records, and they are going to be able to re-enter the United States subject to new non-immigrant visas. And that's great. It's huge. You have people who were in situations where they thought, they would never be able to come into the U.S. again, or they would never be able to adjust status, to become a permanent resident. And so that is what I would kind of close on my highlight for 2024 is coming away with those wins at the federal level, at the court level, knowing that the courts are very likely going. Thank you.
Amazing.
And props go to John Wasden, deserves the shine there. My tacit involvement, I it's nice, but yeah, that I think going into next year is great because it shows us that where possible the courts can be a positive avenue. So when we start to look into next year and you're dealing with things like an improper denial, a denial that just seems ridiculous, or something like that, an incredibly long delay that could require a mandamus action. We all have to realize and be comfortable with the notion that the federal courts are going to be an avenue that must be explored, because it would not shock me if USCIS is not playing fair. And so that I would leave it at that. There is definitely hope going into next year that whatever is thrown at us, we're going to be able to fight it back. If we can't fight back with USCIS specifically, we'll take it to the court where we need to.
Wow. But that being said, amazing. I mean, kudos to Wasden Immigration Litigation for being amazing. And I think, yes, we have great things to look forward to 2025. So thank you so much, Justin. This was great. Lovely. And congratulations to you, Wasden Immigration Litigation, I would say.
Thank you very much. Thank you very much for having me. I always appreciate it. And I'm sure I'll talk to you soon.
Yes, I hope to see you soon. Have a great day ahead, Justin. Thank you so much for joining us.
You too. Bye.
Yes, folks, if you want to have a one-on-one consultation with attorney Justin Rivera, Wasden Immigration Litigation, why not contact him? His number is 844-592-7336, and you can email Justin at support@wasden.law, or go visit www.wasden.law to get to know more about Wasden Immigration Litigation. And also, please do not forget to check them out on LinkedIn. Thank you so much for joining us, each one of you, and stay tuned on Immigration and Jobs Talk Show, because we got more webinars lined up and discussions lined up, and of course, great news and amazing updates. So check out our space, and yes, don't forget to subscribe to us, like, share, and yes, thank you so much for joining us today. Bye-bye for now. Hello, everyone. Thank you for joining us once again here on Immigration and Jobs Talk Show. I'm your host, Nipasa Pradhan, and it's seriously an absolute pleasure to be here once again with another very insightful webinar lined up for you. But before we move ahead with today's discussion, I have this very important disclaimer, and that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, thank you once again for joining us here on Immigration and Jobs Talk Show. And this is a great place for you to be in, especially if you want to know more about U.S. immigration and business opportunities, because we are going to dive into a topic that has definitely sparked significant interest. So, how entrepreneurs and investors can be on the ground doing business in the US in under 6 months. And yes, to help us, dive deeper into the key insights on E2 and L1 visas, we are going to be honored by the presence of none other than our guest for today, um, Mr. David R. Fulmer, an exceptional immigration attorney and a leader in his field. So, Mr. Fulmer is a partner at WR Immigration with over 2 decades of exclusive practice in immigration law. He's been recognized as Immigration Lawyer of the Year and is celebrated for his expertise in assisting companies, entrepreneurs, and even entertainers, navigate immigration challenges. So, for all our viewers, whether you are an entrepreneur, dreaming of setting up a shop in the United States or your business, or maybe an HR professional overseeing visa processes. Well, thank you so much, all you immigration enthusiasts, for being here. And without further ado, please help me welcome our guest, Attorney David Fulmer. Thank you so much for joining us.
Thank you very much for having me, Napasa. I'm thrilled to be here.
Absolutely lovely. And I'm so excited because this is the first time you're here. And we would love to get to know you better. Maybe tell us more about yourself and anything else is something interesting to share if you have any.
Well, I'm lucky enough to live in Los Angeles, and it's an amazing place to live. Our offices are steps from the beach, and I also live about 5 minutes from the beach. So it's an amazing place to be. It's an amazing place to welcome immigrants from other countries, and I think it really exemplifies the best that the United States has to offer. So I'm really happy to be here.
It's an absolute pleasure to have you here, and I can only imagine what a great vibe you must be surrounded with. I mean, the beach always gives you good things, I think, the sunshine and a lot of palm maybe. But yes, I can only imagine. So thank you so much. And well, with regard to today's topic of discussion, how entrepreneurs and investors can be on ground doing business in the US in under 6 months. So, what can folks out there who have joined us or will be joining us in this session, what can they expect from us today?
Well, today we're going to talk about e-visas and L visas, and these visas really do present an opportunity for people to kind of direct their own destiny. A lot of times people think about coming to the United States on an H1B visa, which is amazing and it's great, but it requires them to find a job offer. Or they think about maybe being petitioned under EB2 or EB3, and those are amazing as well, but it requires both a job offer and a very long wait. But E2 and L1 are really opportunities where if you're from the right country, in the case of an E2, and if you have the funds and if you have a business plan, that you can actually direct your own destiny and move to the United States, bring your family to the US. It's an opportunity for people's spouses to work or for their kids to be part of the US education system, all based on their own funds, their own business plans.
Absolutely, friends. Today we are going to discuss about E2 and L1 visas, and especially all you folks out there who are businessmen and who want to maybe expand your business or go start a business. Great place to be in. So, yes, I think without further ado, I have my first question for you, David. And this is with regard to this change of administration. How might President Trump's immigration policies impact pathways for entrepreneurs and the processing of L1 and E2 visas, considering the administration's historical focus on stricter visa regulations?
That's a very good question, and the answer is not necessarily straightforward. There's two things we can look at. First of all, we can look at the prior Trump administration and what they did. And then we can look at some other issues relating to the incoming Trump administration. So first of all, looking back historically, the prior Trump administration implemented a policy called Buy American, Hire American. And the idea of that policy was that in relation to any visa or any immigration process, they wanted to make sure that issuing a visa for that individual would not hurt the wages and working opportunities for U.S. citizens. So it was always a part of, during the Trump era, we always had to demonstrate that jobs would be created. With E&L visas, that's already part of the program. So that's one thing. Next, over the last few years, a lot of U.S. consulates have been waiving in-person interviews. And what that's done is, I wouldn't expect that interviews would be waived for E&L visas, but waiving of interviews for, say, people who are getting extensions of their H1B visa has kind of opened up resources for quicker processing of other visa types like E2s. And so getting rid of interview waivers will probably cause some delays. If you'd want, I can talk a little bit about some another interesting aspect of it, Napasa, which is
Sure.
Everyone knows that Donald Trump has been very close to Elon Musk. Now, Elon Musk is a business leader from Silicon Valley, and so we're also hoping that Elon Musk will have President-elect Trump's ear, and he might influence him to be a little bit kinder and gentler and a little bit more efficient when it comes to visa issuance. So on one hand, we can expect things to be stricter and slower, but we're hoping possibly that Elon Musk might have some influence and might be able to influence things in a positive way.
Absolutely. And looking at how close they are, I think he might as well. And both of them business minded, they would love to soar with regard to business. So I'm sure this is going
Absolutely.
to be good. And right, right. But yes, on the other hand, like you were saying, like stricter rules, and maybe they are going to just make the situation even harder, that they, finally drain out or give up and just go away to their own countries. Who knows?
Absolutely.
So,
I mean, I think that we will have more RFEs. Normally, when you file an L1 petition, there's always going to be a chance that you could have a request for additional evidence. During the prior Trump administration, there were a lot more requests for evidence. And so I think we can
right,
expect more requests for evidence, which will cause processing times to extend a little bit.
right, right. All right. So, folks, we have mixed things to look forward to, but I think it's always best to stay on the right path and do the right thing and keep your documents right. And there is no limit to your dreams. So keep dreaming high and work for it. Yeah.
Absolutely.
All right. At this moment, I would like to say hi to Sneha. Thank you so much for joining us here on YouTube. I can already see your comments. Stay with us. All right. We are going to address your questions a little later in this webinar. Now, moving on, David, I have the second question, and this is, for entrepreneurs looking to establish their presence in the United States, quickly, especially, they don't have time to wait or don't want to wait that long. What are the critical steps to secure an E2 or an L1 visa within 6 months? Is it possible?
It is possible. So first of all, the key point with relation to an E2 visa is the individual needs to be from a treaty country. And the US has E2 treaties with many countries, but not every country. We have E2 treaties with about 85 countries, but we do not have them with the BRICS countries. So not Brazil, Russia, India, China, or South Africa. But if you are from an E2 country, then the E2 is a possibility. Otherwise, you have to go through an L1 visa, which has additional requirements. So if you're from an E2 treaty country, the first thing you'll need to do is really set up a business plan, decide what type of business you would like to be in the United States. Then you'll have to set up an entity in the United States. You have to set up a corporation or an LLC, register it with the Secretary of State in that state, get a tax ID number, set up a bank account, and then you can fund the company, and that's really the first step.
All right. Thank you so much. Thank you so much, David. I think that makes us hopeful at least. And maybe, are there any tips or maybe additional things that folks can keep in mind when they are in a hurry to be out there in the US?
Well, I think it's good to be in a hurry, but more importantly, to be in a hurry is to make sure that they're in a business that's going to be successful in the United States. So first of all, I recommend that they look at themselves, look at their history, look at what they're good at, and look where they could be competitive in the United States, because the business environment in the US is very competitive. And so rather than being in a rush, I think people should analyze where they think they can have an impact, where they can be successful in the United States. Once they've done that, yes, then they need to connect with advisors in the US, both an immigration attorney, a business attorney, to set up the U.S. entity. And then another key thing is to find a general manager in the U.S. that can kind of help them be feet on the ground, because there's a lot of things that they may not be able to do from overseas before they obtain the visa. And even if they come to the United States, they wouldn't be allowed to work until they obtain the visa. So hiring a general manager to be really feet on the ground will also be very, very key thing to help them to be able to move this ahead quickly.
Right. Thank you so much. Thank you so much, David, for, walking us through and giving us tips on how to quickly, get yourself ready for an E1 or an L1, for an E2 or an L1. Thank you. Thank you. So now moving on to my next question is, how can, a startup entrepreneur from a treaty country, demonstrate a substantial and non-marginal investment for an E2 visa while meeting current USCIS standards?
Definitely. So really, that's two questions. There are several requirements to obtain an E2 visa. One is the investment needs to be substantial. And then the regulations say that the business cannot be marginal, which is kind of a strange word. What does marginal mean? Well, they go on to explain that a marginal business is a business that only generates enough revenue to support the investor and his own family. And so the rule says the business cannot be marginal, which means that it needs to be successful enough and generate enough revenue to hire U.S. workers. So really what it should have said is that the business will support U.S. workers. And so I believe that goes back really to the business plan. The government needs to be able to review the business plan and see that the business plan makes sense, see that it's logical and believable that the company will be able to generate revenue so that it can employ U.S. workers. So that's marginality. You asked me about substantiality. The regulations also say that the investment needs to be substantial. And I have my clients all the time ask me, David, how much is substantial? And I wish that the government would tell us exactly what they want. In another context, in the EB5 program, the law specifically says 800,000 or 1,050,000. But in the E2 context, the rules only say substantial. So what is substantial? It really goes back to the same thing that I said relating to marginality. And that the investment needs to be enough so that the government believes that the business will be successful and generate revenue both to support the investor and the U.S. workers. However, I think there are some limits to what is substantial. Sometimes I have people asking me, David, can I apply for a visa with a $20,000 investment or $50,000 investment? Lately, I haven't seen E2s being issued with under $100,000 investment. And I'm often seeing people investing around 200,000. Again, the law doesn't say, doesn't give a specific amount. But usually lately I'm seeing people investing at least a couple $100,000.
Right, David. And that's a lot. I mean, for folks out there who were just expecting to start something within 20, I mean, they have to go 5 times more. So
Well,
there
that's
you go.
I
And
think we're gonna get
yes,
to that
it's
later, I believe. But sometimes if somebody doesn't have that type of funding, then an L1 visa would probably be a better route.
right. So we're getting to that. Thank you, David. Thank you for, telling us about USCIS standards and the E2 visa bit. And also, Vikas has joined with a few questions. Vikas, please stay with us. We are going to address your questions a little later, but thank you so much for joining. And now moving on, David, what are the key industries or business models that are currently seeing faster approvals for E2 and L1 visa applications?
So what I can't tell you is what models are being approved or being approved more quickly because it's really wide open. What I can tell you is models that won't work. And models that won't work are the passive businesses. I have a lot of people telling me, David, I want to buy a house. I live close to Malibu. I want to buy a house in Malibu. It's going to cost $10 million. That's a substantial investment. Can I get a visa with that? The answer is no. It is an investment. It is substantial, but it's not going to meet the marginality requirement. It's not a business at all. It's not going to generate income for anyone. I have other people asking me if they can be passive investors in minority interests in companies. So can they be essentially investors and get visas? And the answer is also generally no, because that is not an active business that generates employment for U.S. workers. So what we're looking for is active businesses. Some common ones are restaurants. Restaurants require a lot of human capital and require a lot of funding. So that's a very common business. But I've seen people obtain visas from almost every industry. It simply has to be an active business and not a passive investment.
Okay. Okay. Thank you so much for telling us about that as well. And anything important about USCIS standards to keep in mind? Maybe something, when people out there are trying to fit themselves with an E2 or L1. Anything else to keep in mind?
There are a lot of things to keep in mind. The focus really is on will the business support the U.S. workers? That's a
Right.
very key point to always keep in mind. A lot of people think, yeah, they can invest and get to the U.S. and kind of figure it out from there. But when they invest, they need to, when they apply for the visa, they need to submit a pretty detailed business plan. And the business plan needs to spell out, their business model, how they think they're going to be able to generate business, what they're going to do in the U.S., and how they're going to, generate enough revenue to create and maintain U.S. jobs. So I think that's a really key point, and it's going to be more important during the Trump administration.
Right. So the question is it going to benefit the United States? And
Absolutely. I mean, I know that it will benefit the foreign investor, but what does the U.S. government care about? How it's going to benefit the U.S. They want to see that those funds have been put into the U.S. economy and spent. So it's not just that they take that 100 or 200,000 and put it in their U.S. business bank account. They want to see that most of that has been utilized and spent and pushed out into the U.S. economy, and that U.S. workers are going to be hired. So it's a win-win. The foreign investor will be able to live in the U.S. Their spouse will be able to work. Kids will be able to go to school. They'll be able to do business in the U.S. And the U.S. will benefit quite a bit from each E2 or L1 that comes into the U.S.
Absolutely. Thank you, David. Thank you so much for the detailed explanation. And now moving on, if a new entrepreneur already has an operating business abroad, what documentation is critical to establish the connection needed for an L1A visa?
Absolutely. So if they already have a business operating abroad, that's a huge head start. And so they will be able to obtain what we call a new office L1. But before they can apply, they need to set up their U.S. Entity. And the U.S. entity has to have a qualifying relationship with the foreign business. So that can mean that the U.S. business is a wholly owned subsidiary of the foreign business, that it's a sister company of a common parent, that it's at least a 51% subsidiary, or that the U.S. business has the exact same ownership in the same percentages as the foreign business. So we call this a qualifying relationship. And this is a very, very key initial issue that needs to be addressed each time.
All right, David. Thank you so much for that and for the detailed explanation. I think now we should move ahead to our next question, and that is, what factors should an entrepreneur consider when selecting the US location for their new business under an E2 visa?
Absolutely. So a lot of people just want to do business in the United States. Other people understand that the US is a very large, very diverse country with really 50 different jurisdictions inside of it. Each of the US states have their own cultures, their own laws, and they even have their own taxation systems. So before they set up business in the US, I believe that people should talk to a tax advisor to determine if one state will be better than another. I have a lot of people that want to do business in, say, Florida or Texas because there is no state income tax. I have other people that don't really care about taxation, They want to be by the beach. And so they're going to live in Los Angeles or Florida, some even in Hawaii. And so really it's a personal decision, taking into consideration the business climate, taxation, and personal preferences.
All right, David. Thank you so much for, getting us through, for establishing a good connection that is required for an L1A visa. Now, moving on, I have another question, and that is about E2 visas. So, how can small businesses, now, especially after the pandemic, I think we see a lot of new businesses coming up. I think during that time, almost every household, or many households, they started their new businesses from home, online and everything. So I think that trend is still on. And nowadays, everybody shopping online, I think it's become a very big thing, startup businesses and everything. So how can small businesses, and first time investors overcome the common challenges of proving their business viability for an E2 visa?
That's a very good question. You talked about people doing business, kind of side gigs from home. The new E2, the Foreign Affairs Manual relating to E2 visas says that an E2 visa can't operate out of a home office. But how can they do a good job of establishing that they are a viable business? I believe number one, even though the regulations say they can have a home office, they need to have physical presence. Next, a lot of businesses nowadays are service businesses. Even me as a lawyer, this is service industry. It doesn't take a lot of capital to set up a law practice. It takes a computer and a good connection to the internet. And many other businesses are like that. They don't require much capital investment. But to be a good E2 business, in order to obtain a visa, it has to be the kind of business that does require capital investment. So it has to be the type of business that requires an office or a plant or a facility and inventory. So these are some key points. That physical space, and it has to require that investment. And it has to be invested in the right thing. Yeah.
Okay. No, you were saying you can you can continue.
Okay. Yes, I was contacted by some people from Canada, and they had invested about 100,000, and they wanted to open up a business where they were going to set up Airbnbs. And it sounded good because I know in order to set up Airbnbs, they have to either purchase or lease a property. They have to outfit it with furniture and technology. And so I thought it could be good. When I looked at what they put their money into, they put their first 50,000 into courses on how to be successful in the Airbnb industry. And while those might be tax deductible according to the IRS, I didn't believe that those would be considered to be proper investments for the E2 visa. So the investment has to go into the right area.
Right. And well, when you say right area, like that has to still benefit US, and only then they can be considered, right? So if in case they do not benefit the US, or there is like a chance that the US does not need this kind of business, there are chances that they can never start that business, right?
Well, so first of all, you ask, what if the investment does not benefit the U.S.? So I've seen some scenarios where somebody sets up a business, so they make an investment, they set up a storefront, and they purchase supplies and equipment, but then they purchase the inventory from a foreign country. And I'm asked, well, does that purchase count as part of the investment? It does, but I believe that it might not get full credit. I believe that the U.S. government will probably favor purchases that come from the United States, especially under the Trump administration, where we're going to have the Buy American, Hire American policies. And so, yes, if the government, if the U.S. consulate does not believe that the investment is substantial, and this is, again, the numeric number is not set in stone. They don't feel like it's enough. If they don't like it, they can deny it. They have a lot of discretion to deny the visa application.
All right, David, thank you so much for, walking us through, L1A visa and how important is it, for an entrepreneur to prove that they are going to benefit the US, and of course that they are doing the right kind of business, and maybe they are very innovative. So yes, thank you so much. And now moving on, I
one other
have
quick
an
point. Oh,
sorry. Sorry, yes, David, please say.
if it's okay, one other quick point. Um, the business that they're in the United States needs to be legal according to U.S. federal law. And I've seen a few people from countries like Canada operating in an area that's technically legal in some other countries and legal according to some states, but not legal according to U.S. federal law. What I'm talking about is anything related to cannabis or marijuana. In California, according to state law, it's generally legal to purchase and if you have the right licenses to sell. But according to U.S. federal law, it's not legal. So people, if they want to obtain a U.S. visa, they should stay 100% away from any industry that has the taint of being connected to something that's illegal, even according to U.S. federal law.
Right, very important thing to keep in mind. So, folks, I mean, thank you so much, David, for highlighting that. And folks out there, that's a very, very important thing. So, Vikas, thank you so much for more questions. We are going to come to that. But I think at this moment, it's time for a short break. So, folks out there, you can also have a one-on-one discussion if you're loving David's ideas, advices, and knowledge, and maybe you want to consult him with regard to your case. Why not contact him as well? You can call him on his number, and his phone number is 310-570-4065. And you can even email him dfulmer at wolfsdorf.com. DFULLMER at WOLFSDORF.com. And yes, go visit www.wolfsdorf.com. Don't go anywhere. Stay tuned to Immigration and Jobs Talk Show. Well, I'm Napasa Pradhan with none other than attorney David Fulmer. Hello and welcome back, everyone, to Immigration and Jobs Talk Show. This is the second half of the webinar we are having, and I'm Napasa Pradhan with today's guest, none other than attorney David Filmer. Yes, he is an amazing immigration attorney who is based out of Los Angeles. And it's such a great honor and a pleasure to have you here with us. Today, we're discussing about how entrepreneurs and investors can be on the ground doing business in the US in under 6 months. So it's been a great discussion so far. And we have a lot more questions to cover, and also folks out there who have questions for us. Vikas and Sneha, we are going to take up your questions. And I would also like to ask you folks to also join us in this conversation. You know, you can participate by asking your questions in the comment section wherever you've joined us from. We are streaming live on YouTube, LinkedIn, Facebook, and X. And yes, David, it's been a great discussion so far. Thank you so much for doing this.
Thank you for having me. It's been a lot of fun.
Thank you. So I have another question, and that is what are the primary differences between E2 and L1 visas that we are discussing today? You know, both for entrepreneurs, and how should one decide the best fit based on their business goals?
Absolutely. So first of all, the first thing to look at is whether or not an individual is from a treaty country. So if they're from a treaty country, then both possibilities are on the table. But if they're not from a treaty country, then the E2 can be dismissed. Secondarily, the business needs to be majority owned by individuals from the treaty country. So if we have a transferee from a treaty country, but the business is majority owned by his partners who are from another country, that's not going to work. So first we look at the treaty country. If the individual is from a treaty country, then E and L are both on the table. Next thing we would look at is whether or not the investment is substantial. As I mentioned before, E2 does require a larger investment. And so if the investors were thinking that they were going to set up a business with a lower amount, let's say $40,000, $50,000, then they would definitely, they should definitely go toward an L1 instead of an E2. Now, if the investment is substantial and they're from a treaty country, then which is better, E or L? There's some factors to consider. First of all, for a new office L1, they're only going to get a 1-year visa, where with an E2, depending on where they're from, they might get a visa that's valid for up to 5 years. And so if they're looking at saving costs and kind of getting it done and not having to worry about it in the future, then perhaps an E2 is better than an L1. However, with an L1, the L1 new office rules do allow them to apply essentially based on a business plan. And so theoretically, maybe it's a little bit less work in the business setup to obtain an L1 than it is to obtain an E2. Now, the other big difference is that an L1 visa is a dual intent visa, where an E2 is not technically a dual intent visa. That means that when you obtain an L1, you can have the plan and intention to obtain permanent residency in the United States. Where with an E2, you need to have the plan to depart from the United States once you're done doing business in the United States. That's a big difference. Finally, an L1 visa allows for an opportunity for applying for immigration or green card under the EB1C category, where E2 does not necessarily present that opportunity. So these are some factors to consider when you're trying to determine which is better, E2 or L1.
Thank you so much for highlighting the differences, David. And I'm sure, I mean, folks out there who are in a dilemma where to categorize themselves, they have a clearer picture now. Thank you so much. And moving on, now I have another question, and that is, if an entrepreneur's visa is tied to a new business that faces unforeseen challenges or restructuring, what options do they have to maintain compliance and their immigration status?
That's a good question. And this comes up a lot because plans are great. But once they obtain the visa and arrive in the United States, sometimes business does not go according to plan. In fact, maybe it never goes exactly according to plan. But what happens if, they get to the United States on their E or L visa and it's really slow. It's hard to get customers. And so first of all, on an E2 visa, if they obtain a 5-year E2 visa, they do have a little bit longer to turn the business around. Maybe they can't maintain all of the employees throughout the whole 5-year period, but they need to make sure that they have been able to turn the business around by the time it's time to renew the visa. And secondarily, they cannot close the business. So let's say that somebody has an E2 visa and it's tough and they can't maintain all of their employees. If it's a retail store and they close the store and they're no longer in business, then they're no longer in status. So they need to keep on trying. Sometimes that means investing more capital. It might mean changing the business model slightly. It might even mean changing the location slightly. But they need to stay in business, to stay in status, and stay in compliance in the United States. If somebody gets a new office L1, they only get a 1-year visa. And so the pressure is on to be successful and to step up within the first year. And if business is tough, if the contracts aren't coming and the money isn't flowing in, they do have the option again to invest more money to maintain the business and to be able to get that extension after the first year.
Okay. Thank you, David. Thank you so much for, walking us through. And now moving on, I have this next question, which frequently comes in mind, and we find them a lot in our groups also. And, folks out there have this question. So how can entrepreneur, transitioning from a visitor visa to an E2 visa ensure that they meet the strict timeline requirements for operating the business in the US?
That's a good question. So first of all, I would hope that if someone is entering the US as a visitor with the plan of obtaining an E2, that they enter on B1 instead of B2. Because usually when people obtain a B visa, it's B1/B2. So if they enter the US on a B1, then they're going to have 6 months to either depart from the US, or technically they may be even able to file the change of status in the US from B1 to E2 status. So if they know what they're doing, and if they have 6 months, that should generally be long enough to go through the steps of, again, setting up the entity, registering with the Secretary of State, getting a tax ID number, opening a bank account, transferring the funds, and then setting up the job. So if they know what they're doing, 6 months is long enough. If they have no idea, then it's going to be more difficult. If someone has no idea what they're going to do, they should probably look into a franchise, because a franchise will kind of have the business plan spelled out. So they should probably talk to a franchise broker and see if there's an opportunity that they're interested in an area that they're interested in, and that's within their budget. And then a franchise should offer a way for them to be able to kind of roll forward pretty quickly, even if they don't know quite what they want to do.
Okay. All right. Thank you so much, David, for that advice and tip, I would say. So now moving on, I have this next question, and that is, for investors planning to use an L1 visa to expand their company into the US. So what strategies can help them build a stronger case for a new office, for a new office petition while ensuring the timely approval?
Absolutely. So first of all, it's really important to look at the foreign business and the person's role within the business to make sure that they're going to be able to be categorized as a manager. So, the L1A visa is the visa for foreign executives or managers that are transferring into the United States to be managers or executives in the United States. It's very important to kind of look at the position abroad first before you launch the case into the United States. So is the person a manager? A manager has 3 subcategories. It can be an executive in a large company, a C-suite executive. It can be somebody who is what's called a personnel manager, who manages 2 levels of staff beneath them, or it can be a function manager who doesn't necessarily have direct reports, but who manages a very essential function of the business through indirect reports. So first of all, do they qualify based on their current position? And that's really the first step before even thinking about launching that business in the US. If they don't qualify, they need a year of qualifying time. Maybe they should adjust their position and wait 1 year so that they qualify, and so they will not have any problems when they launch the business in the United States.
All right. All right. Thank you so much, David. I think that would really help all of us, and it has definitely given us a clearer picture on how to go about either E2 or L1, or whether they or where can they actually fit themselves in? And I think now we should definitely go address these questions we have from our viewers. And I will take up Sneha, our first viewer, and her questions. So she says, I've already set up a business in my home country, but I want to expand to the US. How quickly can I establish a US branch under the L1 visa? And what steps should I prioritize to ensure a smooth application?
So, first of all, again, it's great that she has her business set up overseas. That's excellent. The question is there enough going on in that business to support an L1 visa? So, it's going to have a number of employees in order for her to be deemed to be a manager. So I would, in an ideal world, I'd like to see it have 10 or 12 employees at least, and a structure that's with a hierarchy where she's at the top, there are mid-level managers beneath her, and then the workers below her. That would be what's called a personnel manager. So before she thinks about setting up in the US, make sure she's built up her foreign business. Also, the foreign business needs to be strong enough that when she transfers to the US, it continues to be in business. Because if she gets the L1 visa and the business outside of the United States, winds down, then the L1 visa is no longer valid. So it needs to be really built up and strong enough to be able to support the transfer. Next, the procedure of setting up the entity in the US is really quite easy. But the first thing she should do is talk to tax advisors and see if they have any suggestions on the structure and the location. There are a couple of ways it can be done. It can be done as a subsidiary of the foreign business, as a sister company of a common parent, or the shares could even be owned by her individually, as long as the foreign business and the U.S. business are owned by the same shareholders in the same percentages. So strengthen the foreign business, get tax advice, and then get an attorney to help you set up the U.S. entity.
There you go. It's always best to have a U.S. attorney, to help you navigate or, guide you through any of your visas, because they are the experts and they know that each case is different and every case is special and every case needs special attention. So yes, thank you so much, David, for taking that up for Sneha. And I would like to share my screen now because we have more questions in our groups. So I think I'd like to take them up first before we take up Vikas' question. So let's take this one. This is from an anonymous participant asking, my L1B petition was approved on 15th of August in premium processing. Still, I have been waiting for the approval petition, and my company visa team is saying they are yet to receive the petition documents from attorney. Usually, how long does it take to receive the approved petition? That's the question.
So the question says that the application was filed through premium processing. And so when something is approved through premium processing, generally the attorney who filed the petition will receive the approved I-797 within about a week. And if it's not received within about a week, then the attorney or the petitioner should contact USCIS. Because premium processing was utilized, there's a little bit more customer service. And so the attorney or the petitioner can email premium processing to tell them they have not received the approved I-797. It should not take long. If it was approved in August, here we are in November, that's a problem. And that should be aggressively followed up on because there's no reason for that to happen these days.
Right, that means that is not a good scene. But thank you so much, David, for taking that up and for the answer. Now I have this next one. This is also from an anonymous participant asking, when looking at the wait times of interview waiver for L1 visa, it doesn't give any information on wait times. It's just blank. Also, when looking for an appointment for Dropbox for L1, it doesn't show any slots. Are there any changes to the process for L1 visa renewal stamping? Also, did anyone get it done in Mexico instead?
Okay, so we have a few questions here. First of all, I think, first of all, they're asking about interview times for an L1 under visa wait time. So the Department of State has a web page that's called Visa Wait Times. So you can Google it and you can find it. It says Visa Wait Times. You type in the city and it will tell you the common wait times for each different type of visa. And for some, and from consulates in some categories, it'll tell you the waiting time for interviews and interview waivers. So if it doesn't list it for interview waivers, sometimes what we have to do is kind of analogize it. So if it doesn't say L1 interview waivers, perhaps you can look and see what it is for H1 interview waivers and get a general idea of what it's going to be. Napasa, can you bring it up on the screen so I can see the rest of the question?
Sure.
When looking for an appointment, Dropbox L1 doesn't show any slots. It could be that they're not allowing for Dropbox appointments for L1s if it's not showing any slots, or you may have to email the consulate and see if they'll respond to you about that. Processing in Mexico. So processing in third countries may be a possibility. I can't say I have done too many in Mexico lately, but it may be a possibility. What you want to make sure is if you're processing in a third country, you have a visa to get into that third country. That can be an issue sometimes. And you may want to contact the consulate to make sure that they're open to processing the visa there if it's a third country.
All right. Thank you, David. Thank you so much for that insight, and that was really helpful, I'm sure. Now, moving on, I have this next one. This is from Naluri asking, is it okay to apply L1A extension in premium now? Bunch of thanks in advance for your response here.
There's no reason to not apply for an L1 under premium processing right now. It's available, and generally these days people utilize premium processing whenever it is available. Sometimes there are strategic reasons when you won't want to, but in most cases people are utilizing premium processing on any category that's available, and I don't see a problem with it in general.
All right. Thank you so much, David, for taking that up. Now I have another question, and this is also from another Facebook group, from an anonymous participant. What are supporting documents required for converting L1B to L1A category?
Okay, so that's a good question. L1B is for someone with specialized knowledge. L1A is for a manager. And so the assumption is that you were probably in your home country, were working in specialized knowledge. When you transferred to the US, you were working specialized knowledge. And now you've been promoted into a manager, or you will be promoted into a managerial category. And so you'll have to prove that the employer does have a position for you that fits the managerial category. And so what does that mean? Usually you're going to have a detailed job description. You'll have to have an organizational chart to show the people that are going to report to you. And you usually have to demonstrate what titles and what duties those people have so the government can see that you really are turning into a people manager from a specialist.
All right. Very interesting. Thank you so much for taking that up, David. And thank you, anonymous participant, for the question. Well, I have another one. This is also from another group. Another anonymous participant asking, has anyone recently got their L1A extension stamped in Canada? Please share your experience. We don't want to travel all the way to India. So this person is from India originally.
Absolutely. Canada and Mexico technically have jurisdiction over people who are physically present in the United States. And so it is theoretically possible. I'm not saying it happening a lot these days, but it is possible. Obviously, it's a shorter trip. A lot of people still want to go back home because if they stay in Canada, they're going to probably get a visa to get into Canada. They're going to have to stay in a hotel for a week or 10 days. And there's usually a longer wait time if you're applying in a third country. So people from Canada will have priority over people who are third country nationals. So even though it's theoretically possible, a lot of people would rather go back to their home country.
Oh, that's very, very interesting, really. Maybe could you tell us more about it?
Well, yeah. So, if someone's on assignment in the United States from India, they're away from their parents, their siblings, and a lot of times there's a need to kind of go back and see family. So if they go back home to India, they're going to be able to see all of their family, kind of check that box off, and they're probably going to be able to stay with their family for free. But if they're applying in a third country, again, they're going to have all the expense of a trip, and they're not going to be able to see family. So a lot of times people prefer going back home instead of and kind of making it into the annual family visit while they're getting visa stamped, as opposed to doing it in a third country.
Right, right. Very interesting. Thank you so much, David, for taking that up. And moving on, I have more questions. So let's take this one up. Another anonymous participant is asking, "Hi everyone, I'm heading to India for my L1 blanket visa stamping and currently see Chennai as the only available option for scheduling. Has anyone managed to book appointments at other consulates recently? Also, is it possible to schedule both for OFC and consular appointments on the same day since I see that option in the portal? Thanks in advance for your help."
So I can't say I have all of the information on exactly what the appointment booking is in India.
Yes.
Um,
But I
yeah, so
think we
maybe
didn't speak about the blanket visas, no? L1 blanket. So maybe if you have anything to say or especially highlight the important points about blanket petitions, it would be
absolutely.
great.
Yeah, I mean, blanket petitions are an excellent tool. Employers should definitely obtain a blanket if they qualify, because they don't have to submit every single application to the USCIS. Instead, they can apply directly at the US consulate. However, at the US consulate, there will be a little bit more adjudication, and the standard for adjudication of an L1 blanket at a consulate is a little bit higher than it is at the USCIS. And so you want to make sure you have a very strong case if you're utilizing the blanket.
All right, that's very important. Thank you so much, David, for taking that question up and also telling us about blanket petitions. Now, moving on, I have another question, and this is from another anonymous participant asking, "Hello, this one we've taken actually, right? We just took it. I think that's it. Okay, this is one last one. Hi guys, I need help. My husband's L1 extension petition and my L2 extension I-539 have been filed together in October 2024, while L1A extension is filed in premium processing. Mine is not. So it's still under process. My I-94 is expiring on December 20th this year, but I have a valid stamped visa till 2027. My husband received his approval notice. My questions are, if I travel outside the USA, will my I-539 be abandoned given it's the extension of the same visa category? Let's take
So
this
the
one
answer to
first.
that is yes. The I-539 is abandoned when you depart from the US.
Okay, and the second question is, can I re-enter USA with my husband's L1 approval notice and current visa?
Yes, you should be able to. You have a visa, you have your husband's L1 approval notice, he's still employed, you're still married. There shouldn't be a problem with that.
All right. Now, the third question is, if my I-539 is abandoned, do I need to apply for extension again with USCIS?
No, you do not. You will be admitted on a new I-94, so you do not need to file a new I-539.
All right. I think the last question is, I heard about flag polling where I get my I-94 extension using my husband's L1 approval. That's right. Will it
Correct.
affect my I-539 if I cross border to extend my I-94 based on my husband's approval notice?
So I think that's really a combination of questions 1 and 2 and 3. And so,
Right.
yes, the I-539 will be abandoned, but yes, they should be admitted on a new I-94.
All right. All right. Thank you so much, David. I think with that, we have covered most of the questions from our groups. And well, we have another live audience who has joined us on YouTube. This is from Rajesh. Hi, Rajesh. Thank you for joining us. He's saying, I am a Canadian and would like to know if I can apply for E2 visa based on my rental properties in USA and start a rental and property management business. Does this business apply under E2?
Yes, it could. So while just owning one rental property probably would not qualify, if someone had a number of rental properties and perhaps contracts with other companies to manage their properties, and if that business, again, meets the other requirements, substantial investment, if it had employees, so it met the marginality requirement, absolutely, this could be a valid E2 business.
Okay, there you go, Rajesh. I think that's good news for you. All the best. Now, let's take up Vikas. I'm so sorry, Vikas. I kept you waiting for so long, but here we are now. Let's take up your questions. He has a series of questions actually. So Vikas is saying, if I already have a tourist visa and want to explore potential business opportunities before applying for the E2 or L1 visa, are there restrictions I should know to avoid complications during my transition? Let's take this one first.
Absolutely. So number one, as I mentioned, they should enter on B1. So when they get to the airport, they'll be asked business or pleasure. They should say business. And if the government, if the customs officer asks them what kind of business, they can be honest and say, I'm thinking about applying for an E2 or L1 visa. I'm here to explore the opportunities. Next, if they get here and if they find the right business opportunity, they can do things like meet with a lawyer, meet with a corporate lawyer, meet with an accountant. They can do business meetings in relation to setting up the business, but they cannot work in the business. So once they've set up the company, if they want to do a soft launch before they obtain the visa, which is a good idea, they need to hire a general manager to perform the day-to-day management until they obtain their visa. Getting that first key employee to manage is very important in obtaining the visa. It also keeps them in compliance because it shows that they're not working illegally in the United States.
Right, right. Thank you. Thank you for taking that up. And he has more questions, so let's address them. If I apply for an L1 visa as an executive, how do I prove my role in my current company and show that my position in the US branch is necessary? And can you give examples of supporting documents that work best?
So it's really two questions. So first he's asking, how do we prove the position in the US is necessary? The government is generally not going to ask you to prove that it's necessary. If the company wants to launch an office in the US, obviously it has to have a genuine, profit motive. And if you have a business plan that shows that it will be profitable, that's all you have to prove. You don't have to prove that it's necessary. Only that it appears that it'll be profitable and that it will be able to sustain business in the United States. So the next question you ask is examples of documents. Can you read the question again, Nipasa?
Can you give examples of supporting documents that work best?
Mm-hmm. Well, again, I think that the question might not be accurate, but the main supporting document to show that the business in the US will be, again, generate profit will be a business plan. So that's the key document. It should be pretty detailed. And in the business plan, there'll be sections that will spell out, who the principals of the business are, who are the founders, what history they have, what plans they have in the United States. That's where you really make the sale to the US government that this business will be successful, will be sustainable, will hire US workers.
All right. Thank you for taking that up for Vikas. And Vikas, I think we've covered all of your questions, but if you still have any more further questions, you can keep commenting. And now let's take up Ganesh's question. So, what are the most effective and cost-effective visa options for entrepreneurs and investors seeking to establish a business presence in the US within a short time frame under 6 months? And what are the key requirements? I think we've covered this in this
I think
entire.
that's the whole topic, right? But I think the
Exactly.
answer is this. There in the U.S. there are two investor visas. First, we have EB5, which is an excellent program. It requires a minimum of $800,000 investment, and if somebody's not already in the United States, it's going to take them a number of years to get to the United States on the EB5 program. So the cost-effective option is the E2 because it does not necessarily require 800,000. It could be 100, 150, 200,000. So that is the answer. It's E2, which is the topic of our discussion today.
Absolutely. And I think with that, it also helps us wrap up a bit and probably summarize rather in a nutshell this whole topic for today. But before we go, David, I would really like to say thank you first, but also if you could, end this session with an end note and maybe some key pointers to keep in mind so that you can leave folks out there with some bullet minds they can think about as they leave this session.
Absolutely. Thank you very much for having me. I think that the key point is that you don't have to beg a friend for a favor or for a job in the United States. Sometimes it's very hard to search for jobs from overseas. So if you have the funds or if you have a business, then you can kind of you can direct your own fate. You can make a plan to be able to move you and your family to the United States within a reasonable amount of time using either an E2 or an L1 visa. And it's not going to cost 800,000 like the EB5 program would. Now, if you have the 800,000, EB5 is definitely a wonderful route. And if you're in the United States already as a foreign student or on an H1B visa, and EB5 is a great route. But if you're not, then you might want to look at an E2 or L1 as a way to move you and your family to the United States within a reasonable amount of time.
Wow. Absolutely. Thank you so much, David. And I wish we had a lot of audience. I mean, live audience, I would say, like, please give a round of applause for our guest today, none other than David, our filmer, who joined us from WR Immigration and also, like, folks, to add to how incredible David is. Well, he's a top-rated immigration lawyer and the past immigration section chair of the LA County Bar. So he was selected for inclusion in 2023 edition of the Best Lawyers in America, and in 2021 he was recognized as Best Lawyers Immigration Lawyer of the Year in Los Angeles. So I think that is a very great achievement, and thank you so much, David, for joining us and for sharing your very your time with us and all this knowledge that you could impart in this session. I'm really looking forward to have you join us again very soon.
Thank you very much.
And here's wishing you a very, very happy Thanksgiving, happy holidays to you and your family out there. Thank you so much for joining us. All right, so friends, thank you so much for joining us in this session. It was really great. Do not forget to check out David Fulmer and contact him if you want to have a one-on-one consultation, and also visit his website and send him an email. Yes, and these are his contact details. You can call him in this number, 310-570-4065. You can also email David. I think it would be best to email. So note down this email address, dfulmer@wolfsdorf.com, and go visit www.wolfsdorf.com. Thank you for joining us today. You can also email me, by the way. You can contact me if you have any questions with regard to immigration or jobs in the United States. And my number is 408-335-6444. You can email me, nipa@staffingly.com. And I have another great news, and that is Monday to Friday, 4 p.m. Eastern Time, me and my co-host, Sam, we join you with daily immigration dose here on Immigration and Jobs Talk Show. So I would like to say, please join us there in less than an hour. And until then, of course, don't forget to like, share, and subscribe to our channel. And also hit that bell icon so that whenever we have discussions and webinars like these, you are notified and you can join us. Thank you so much once again. Here's wishing you a good day ahead. Bye-bye. Hello and welcome back, everyone, to Immigration Talk. I'm your host, Pastor Pradhan, and today we have an exciting and highly informative session lined up for you. But before we move ahead with what our topic of discussion is going to be, and I even introduce you to our guest for today, I have this very important disclaimer, and that is, by watching our videos, you agree and understand that the information provided to you by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Once again, friends, thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook. And let me tell you that you can also participate in this session by commenting. So, whatever questions you have, especially with regard to the topic of discussion for today, it'll be very nice if you can comment them. And we will definitely make some time later in this session to answer to your questions. So, thank you so much for joining us. And definitely, I mean, the 2024 US presidential elections have really stirred up a lot of discussions, and people are really anxious also, especially when it comes to immigration policies. So, with potential changes on the horizon, many of you are wondering maybe what will happen to US study and work permits in 2025. So, to help us, navigate and dive into this really very critical topic today, I'm really thrilled to introduce you to our esteemed guest who is going to join us today for the first time on Immigration and Jobs Talk Show. None other than Attorney David Garson. David is the founding partner of Garson Immigration Law, one of Canada's premier immigration firms, and he is a certified specialist in citizenship and immigration law, recognized by the Law Society of Ontario, and is ranked among the top 9 immigration lawyers in Canada by Chambers and Partners. So David's extensive knowledge and expertise and experience in this field definitely makes him the perfect expert to help us in this topic today. So without further ado, please help me welcome David Garson for the first time on Immigration and Jobs Talk Show. Thank you so much, David, for joining us.
Thank you so much for having me. It's a pleasure to be here.
Absolutely lovely. And maybe you would like to tell us a little more about yourself, something you may want to highlight or tell us about yourself, anything at all.
Sure. I've been practicing immigration law for over 30 years. I'm dual licensed in Canada and the United States. We help individuals enter Canada and we help them go to the United States. So, I mean, we've seen a lot of what has been going on over the years, and immigration as it's been influenced by politics, and frankly speaking, politics has been influenced by immigration. So it's a very interesting time that we're facing right now, without a doubt. There's an old curse, though, may you live in interesting times. So I imagine that there's a lot of anxiety and a lot of questions that people have, including me, because I know we're going to get into questions, and you may hear this a lot from me going forward, but we really don't know much yet. We know what the intent is. We know what this administration had done previously when it was in power, or this president, but we don't know necessarily what is going to happen in the next 4 years. But there have been some indications. There's been some statements on the campaign trail, and I think we can try to piece together or guess, prognosticate as we go. So I look forward to it.
Me too. And definitely with your expertise and experience, I'm sure your perspective is going to add a lot to the viewers out there. I mean, who are all anxious, want to know more, what is going to happen. And some of them are even maybe, fired up to even acting quickly. So maybe you might want to warn them or give out some tips to relax them. So thank you so much, David, once again for joining us. And as we already have said about the topic of discussion, today's topic is U.S. study and work permits, what to expect in 2025 after the elections. So I'm sure folks out there are very, very excited. And I can already see some comments popping up. So thank you so much, Supriya, our first viewer who has commented with a question. Please stay with us. We will address your question a little later. So, David, are you ready for our questions now?
Sure, let's go.
Let's go. So how do you anticipate changes in U.S. study and work permits under the new administration, particularly for international students and foreign workers?
Well, it's an interesting question because, as many people may remember, under the last administration, they did try to enact legislation or presidential orders stopping people from coming or stopping students from coming and regarding work permits, but the courts overturned them on various occasions. So whenever they were attempted to try to sort of enact things or move forward, the courts sort of made them take a step back. So in the end, they didn't really get a lot done legislatively, meaning they didn't pass a lot of laws with regard to be restrictive. But what they did do, and what they can do again, is you can work within the system to make things more difficult if you're so inclined. I'll give you an example. If somebody makes an application for a student visa, as many people who are watching probably know, you have to satisfy the State Department or the consulate of a few things, one of which is that you have temporary intent. Now, that's a very broad concept, temporary intent, right? You have to show that you are willing to go back to your home country at the end of your studies. So to do that, you present a lot of documentation. You show you have bank accounts, or you have ties, you have family, you may own property, job offers, things of the sort. So you keep doing this, and you go to the consulate and you say, okay, I've been accepted to for University of Pennsylvania, and here's the proof that I've been accepted. Here's my I-20, which is the document you have to present, and here's my proof that I have ties. A consular officer can look at it, because it's very discretionary, and say, okay, I'm satisfied with those ties. Fine, we're going to give you the student visa. Or a consular officer can say, no, not satisfied, not good enough. Now, if an administration wanted to curtail the number of students that come into the country, then what they can do is simply tell the State Department, which tells its officers, perhaps look at these applications a bit more critically. Maybe there may be another set of criteria we want you to examine in that regard. So they can make things more difficult without changing any legislation for people from getting student visas. So let's say that somebody does get a student visa and they come into the country and they go to school. As many people know as well, at the end of their schooling, they can get something called an OPT, optional practical training, for a year. And then subsequently, under the Obama administration, they said they can extend that by 2 years, okay, if you're in a STEM field, okay? They could take away that. That was something that the Obama administration put into effect. That's not something you have to have. And certainly that means that in terms of being able to work at the end of your studies, they could make that 1 year, they can make it shorter, they could play with the STEM time frame, they could play with the OPT time frame. So I guess what I'm saying here is, what do we think is going to happen? I think that if they want to make it more restrictive, they can do a lot just with what the legislation and the rules that are on the books. And then subsequent to that, in terms of working afterwards, they can make it more difficult based on how they want to work the work permits after you graduate.
Okay. So we can definitely expect another layer of scrutiny, or maybe tightening of.
I was going to say, and there may be a question going forward that we want to, yes, I think based on previous experience, but remember when I started, I said that politics play a huge role in immigration, meaning especially the people that advise the president with regard to this. In his last administration, there was a fellow named Stephen Miller who was advising President Trump on immigration. Now, Stephen Miller was a pretty restrictive guy with regard to immigration. He had thoughts and policies that meant you couldn't, he wanted to narrow the ability for people to come to the United States. I don't know, or I haven't heard that he's advising President Trump this administration. In fact, he's taking a lot of advice from Elon Musk. Now, I'm a guessing man. If you guess, Elon Musk would know the value of foreign workers, and especially people in STEM fields, with regard to what he does. So if he's advising President Trump and he says, okay, listen, we need people, let's say, with regard to the H1s or OPTs, because these are the individuals that we need in the tech sector or the manufacturing sector or the innovation sector. And so maybe let's not be as harsh as we were previously.
So there we go, friends. And I think along these lines, we are going to definitely dive deeper. And we have more questions and more people joining us. So I'm really happy. Hello to George, if I'm pronouncing it right. Hello, George in LinkedIn. And we have Namrata Reddy, Jaya Kumar. Please stay with us. We are going to take up your questions for sure. So, David, my next question is, what specific policies do you expect Trump administration to implement in 2025 that could affect students applying for F1 visa or those already in OPT?
I'm thinking, as I said before, that they are going to be more restrictive with regard. This is what I expect. Everything I'm saying here is I'm just guessing the same as you, but based on what I've seen and based on what I've heard, I do expect them to be somewhat more restrictive with regard to issuing F1 visas than they have been. I also expect them to be somewhat more watchful. I mean, I don't think they enjoyed seeing, and especially they spoke out on the campaign trail, all of the occupied at the universities in terms of the encampments. I think that was something that was not something that this Republican Party, or certainly this president, wants to see going forward. So I think there may be somewhat more restrictions and or variations that are imposed on individuals with regard to what they do when they do come to the United States, if they get their F1. And if they do act in a certain way when they're here that doesn't exactly or expressly have to do with going to school, then there may be further actions that can be taken against them with regard to leaving the United States. In terms of work permits, you know, as I said, they got slapped a lot last time they were in power with regard to changing the law. So they acted or created situations that gave them what they wanted to do. They slowed down processing. They made it there. The amount of denials increased in terms of the percentage. So they can do things like that. I would guess, based on what they've done before, that that's what they'll do again.
Okay, but it's really nice to have, your point of view, your perspective on this. So thank you so much, David, for doing this with us today. And also, since we're talking about students, maybe you could tell us what challenges should students be prepared for, especially student visas on F1 and work visas H1B.
So when you're coming in, and as I said, when you're asking, I mean, if somebody's applying for an F1, you know, the easiest way to refuse a person, if they have the money to pay and if they have the money to support themselves and if they have been accepted to the school, the easiest way to be refused is on temporary intent. So if you are applying for a visa, to document yourself with regard to temporary intent and your ties to your home country, I think is going to be crucial. I think you have to have as much documentation as you possibly can with regard to your case and with regard to your ties, so that when you go to the consulate and you apply, that you are able to convince the officer that you do have that temporary intent and you can come to the United States and you will leave. I think that's going to be paramount with regard to that. In terms of the student visa, I mean, once you get a student visa and you get your OPT at the end, the issue is that, of course, with the lottery on the H1s, and it makes it difficult to get an H1 in any event. And we are, for instance, contacted by companies all the time that have an individual who is in OPT status and has applied, and they've tried to get that person in H1, and they can't. They've not been picked. And a year goes by, and if they're on STEM, they have the extension, but they don't get picked. And so the company is looking to see if they can go work in another place for that company elsewhere in the world or something of the sort. So the advice I would have, realistically speaking, is that once you're here on the OPT, I mean, it's not, you don't really have control of this situation. And unless they expand the number of H1s that they're willing to give in a year, realistically speaking, I would probably look at, on practical advice, working for a company that maintains as a multinational corporation that can send you other places if they need to, if that's at all possible.
That's good advice. I think that we should consider for sure, folks out there. I think you should look onto that too. And, David, I think we'll quickly take Jayakumar's question, if that is fine.
Sure.
So let's go with it. I got 221G issued with white slip, and after a week got an email that intend to revoke from consulate in India. What are the chances of getting approved if my employer responds back?
Oh, that's a very good question. So first of all, for anyone that wants to know, 221G means they need more information. So there's various ways that a consulate can refuse you. It could be under a section called 214B, which is that temporary intent section. The one you don't want is something called 212AC, because that's misrepresentation and that's horrendous. 221G means that they need more information, or so they're refusing the case pending more information coming in. It's a refusal, but it's kind of not a refusal, because it means that they're still considering the case and are okay to get more information. Now, I don't know the background of this case in the sense, why is there an intent to revoke? Is there an intent to revoke because they came upon other information that sort of speaks against what was previously submitted? Have they perhaps done an investigation and figured out that there isn't something here that they need that didn't occur or something of the sort. So in answer to your question, what are the odds? It depends on why they're going to revoke. If they're going to revoke because they have definite objective information that's not good, then the odds may not be that high. But if the intent to revoke is based on a misunderstanding or information that they didn't get or thought or they misread, then it could be fine. Realistically speaking, I mean, whatever you do, when you file that information that is supposed to that they want, please make sure it's as fulsome as possible, because you're going to get one crack at this. So if you're filing that information that's in addition to what they want to try to address the revocation, make sure it's as fulsome and as packed with whatever you need as possible. Don't play games with it. Because also, and again, I don't know the background, if you submit information that isn't helpful and they are looking at it and saying, well, we're revoking this because we think there is misrepresentation, then you could get slapped with that 212A6C, which is never a good thing. And it could be very deleterious to the case.
Right, David. Thank you so much for taking that up for Jaya. And Jaya, thank you for your question. Really great question. If you have any further questions, you can keep commenting. And we have Jorge saying hello, and he has a question. What can an experienced engineer in the IT industry that is a non-US citizen do to get a working visa, any type?
In the US or anywhere, I guess, in the US?
Yes, that is a non-US citizen, maybe in the US. Yes, in the US.
Yeah. I mean, realistically speaking, it depends on your citizenship, of course. If you're Australian, for instance, you may be able to get an E3 visa. Or if you are, let's put it this way. So there's different types of visas you can get depending on citizenship as well. So if in the normal course, everybody knows about the in the US. Okay, good. Everybody knows about the H1, right? You have to have an employer. The employer has to register. You have to register that expression of interest. The rates of acceptance haven't been that high. They've had a lot of applications and a lot of people have not been chosen. But that is the normal way that most people do get visas. There's something called an L1, an intercompany transfer. So if you, for instance, are an engineer and you go work for a company overseas for a year, and that company then wants to do this L1 intercompany transfer, they can do that to send you into the United States. If you go work for a company that has your nationality, there's treaties of navigation and trade. It's commonly called the E visa. So if you have the same nationality as the company ownership, then they can try to get you a visa under the E visa category. If you're Canadian, then you have the free trade agreement that you can look at, or Mexican for that matter. So there are various possibilities. That being said, the most common way an individual gets to the United States, all things being equal, is if a US company petitions for them under the H1 category. Actually, there's one more as well. If you are a person of extraordinary ability, and in that you are one of the top individuals in your field, you've written articles, there's been news about you, all that kind of thing, then you can apply for something called an O1, which is extraordinary ability. You have to be a very high level, though. It's not, they realize with the cap on H1s, a lot of people are going to try for O's. So you can't do it if you don't have at least, unless you've written a lot of articles or some scholarly, and unless you've been featured in a lot of different ways, it probably wouldn't be relevant.
Definitely. And by free trade agreement, you mean NAFTA, right?
Well, it used to be NAFTA. The US calls it the USMCA now. Canada calls it the CUSMA. And to be honest, they have no clue what Mexico calls it at this point.
Okay, but Jorge, you have a lot of options out there. Depends where do you actually fit. So you might as well go consult an expert. And I would always say, yes, you need an attorney. So it'll be good to be guided by an expert. Thank you so much. And now going on to our next question. And definitely, if you want to have a one-on-one consultation with David, you have his contact details on the screen. You can email David at garsonil.com. And you can go visit www.garsonil.com.
Thank you so much. And let's go to our next question, David. And that is DJ4496 asking, hi, my husband is primary. We are from India on EB2. We got our green card EAD for 5 years. Our priority date is September 30, 2014. So my question is, when can we expect green card?
Yeah, it's going to be a long time. It'd probably be within that 5 years. Well, right now, I'll take that back. Right now, it could be within the 5 years, but it is taking 5 to 7 years in that regard. However, that is also something else that may change come the new administration. These things could get elongated out. As you probably know, many people find themselves in a priority date that is current, or you think it's almost current, and then it doesn't move for a long time. The issue is that come the new administration, one of the things they can do as well is slow down the priority date processing. So that takes a while. I mean, the fact that you have a green card EAD for 5 years is good news. I mean, that keeps you there for a long time, and hopefully, you know, there is also the president-elect did go on radio and talk about the fact that people that graduate from U.S. universities should be eligible for green cards as long as they do everything right and they've done everything that is appropriate. So, you know, you can't always think that he's going to, or they're going to do anything that's that detrimental. It could be that if he's looking at who is applying and that they need individuals in that field that are applying, and I mean, he may speed up green card processing in certain situations. He may be tougher in others, but to your point, your husband has the EB2 approval. You have a 5-year work permit. Hopefully, within the next 4 years or so, you should be able to get a green card.
I think 4 years is not so bad. I mean, for many folks out there, it's decades.
But again, we don't know.
We don't know.
That's the problem with having this in November when a new president is taking office in January, and you have no clue what he's doing. Somebody asked a question about Tom Holman being appointed today as the new border czar. Yeah. True. You know, I'll answer. I was just looking at that. What do you view as Tom Holman being appointed as a border czar by Trump administration? Should people be scared given his known stance on immigration and mass
deportation? Drive 10, yes.
Well, you know, he was the head of ICE before, and he is a tough guy on this. In terms of being scared, I think that Trump is sending a message, certainly. You know, one of the cornerstones of his campaign was talking about deportations, right? I think Vice President-elect Vance talked about deporting 1 million people a year. I don't think they're going to be able to do that. Let's be blunt. They're not. First of all, how are they going to find them? I mean, where do you, if they're out of status in the States, where do you go? I mean, you have to locate people. But I think Mr. Holman is a very tough guy. I think that it is sending a message. I think that if you're going to look to deport people and you're going to look to be restrictive, he would be the man for the job. Yeah, I think that's what he's doing there. That all being said, the courts are there for a reason. And like I said, in the last Trump administration, a lot of what they wanted to do was thwarted by the courts. So once somebody is taken into custody and they move towards deportation. I mean, I'm not a deportation lawyer, an enforcement lawyer in that regard, but there is access that a court can comment on with regard to any of this. But yes, I think sorry to go on, but I think having Mr. Holman as the border czar will mean that the Trump administration is going to try to do what they said they were going to do.
Right. And this could be one of the biggest mass deportation in the history of the United States, I guess. Let's see what it holds.
I think that he wants to try. I mean,
let's see.
Yeah, and then somebody said they were talking about deporting illegals. If you're there illegally, there's nothing to fear. I agree with that.
Right.
I agree with that. I think if you're in the United States legally, I don't see anybody wanting to deport you. I don't think they can. They can't if you're there legally. The question is that they could create situations where you can't extend your status, or that it would be too difficult to extend your status. And in those situations, then you have to leave. But in terms of being gathered up by ICE and deported, no.
True, true. Thank you so much. David, for taking that up for Drive 10, and even Jorge, thank you again. So we have our next question. This is Akshay. Akshay is on YouTube asking, would the consulate officer check my past employment history after my MS? Now, if I am applying for a PhD, what should I be careful about?
So they're going to check my employment after my master's degree. Well, yeah, if they have information. I mean, realistically, when you fill out, when you're at the consulate and they're asking you questions, after you got your master's degree, I'm assuming you did your OPT. If that's the case, then they may look at that, certainly, yes. Mm-hmm. If you're applying for your PhD, if you're not extending status and you're going to a consulate and apply, then it pretty much is what I've just discussed, and that is the temporary intent issue and the fact that you're transparent with regard to what you're going to be doing and what you're doing and how you're going to be doing it. The fact that you're going for a PhD should, by practicality, make it easier to get a visa, because it does show you have certainly serious intent towards your education to get a PhD. And it's normally, when you get higher in the educational sphere, it normally would make it not easier per se, but the officer would understand you've had, especially if you've had visas there before, that you've adhered to U.S. immigration policy, and that you've been someone that is credible. Okay, and I think that has a lot to do with it, credibility, when you're applying for any visa, because if you do things that they don't particularly care for, or have done things they don't care for, then you lose your credibility with immigration, and that's when things go awry. And that's good. You did your OPT in STEM and then return back to your home country. I think that's very good. It shows that you adhere to U.S. immigration, that you follow the rules, and that they can count on you to follow rules. And I think that having a track record like that is important.
True. And I think that is a plus point for you, Akshay. Thank you so much for your question. And if you have any more questions, you can keep commenting. Well, he says, yes, I did my OPT in STEM and then returned back to my home country. Very nice. Following the rules. There you go. And thank you so much. Even DJ4469 says, thank you for answering the question. Great. Well, David, now I have another question, and that is, if an F1 student's OPT is set to expire in 2025, what options do they have for extending their work authorization, especially with the potential changes in U.S. immigration policies? What do you suggest?
Yeah, this is an easy answer, not much. There isn't that much to do. In the sense that if your OPT is expiring, and you don't have, my phone's going up here, sorry. If your OPT is expiring and you don't have a STEM OPT extension that you can look at, or you can't get another type of work permit based on nationality or a treaty or something of the sort, then there really isn't that much for you to do. As I said, though, we have seen companies, multinational companies, where somebody has an OPT and they're with them for a year, and then the company says, you know what, we are going to put you and you're going to work for our subsidiary or our parent or our affiliate in another country. Then that being the case, if they do that and you're in that with that company if you're with that company in another country, then if you work there for a year, they can then look for an L1 intercompany transfer to bring you back to the United States. By the way, that is another possibility where they may be more restrictive going forward. There's such a visa called an L1, and an L1 is an intercompany transfer. And you can do an L1 for a manager or executive or a specialized knowledge person. And specialized knowledge usually means a unique knowledge. It's both proprietary to the company and a knowledge of the field. So if they wanted to slow down people who are coming to the United States in specialized knowledge L1s, they could do so, again, not by changing legislation, but simply by making the criteria more rigorous and saying it's going to be harder for you to get an L1 because we want to see a lot more within what you've done and your history and your experience and things like that. So that could be something else that they look at. But if you're in OPT and you don't really have any, you can't extend it, And you can't qualify for another type of work permit based on, as I said, other factors. And unfortunately, there isn't really much that I can see that you can do.
Well, thank you so much for that, David. But I think that's all we can do for 2025 then. And I'd quickly like to say hello to Jemshid. Thank you so much for joining us on LinkedIn. And then we also have Ezzy Lydia. Lydia, thank you so much for joining us. Hello, everyone. I am Lydia. She says, hello. Now I have my next question to you, David, and that is, what impact will the expected changes to work permits and student visas have on industries that rely heavily on international talent, such as technology and healthcare?
That's a good, well, and this is what I was talking about before, that it would be I think it could be pretty detrimental in those situations, which leads me to believe that there will be individuals surrounding the president-elect that could talk to him about this, i.e. Elon Musk or someone of the sort. I mean, he doesn't want to, cut off his nose to spite his face necessarily. He understands that there are areas where people need employees, and if you don't have them, then things are going to not be as I guess you could say, they won't go as well as they should for that industry and for that company. So realistically speaking, I think it will have a deleterious effect on those companies and that industry, which leads me hopefully to believe that they will see that and make allowances in certain areas.
Okay, but definitely, I mean, people, I mean, especially where US needs talent from, I mean, different countries where, US may not have theirs. And I think this is something that is going to be affected for sure. So, David, thank you for highlighting that. Now, I have another question, and that is, if a university student on an F1 visa receives an unexpected job offer before graduation, what immediate steps should they take to ensure compliance with the new work permit regulations under the Trump administration?
Yeah, well, they won't be able to do, again, they'll have to, I mean, realistically speaking, they can do their CPT, which is part-time work within the context of when they're studying, and that's fine. But and they have to be able to do that and get approval to do that. But realistically speaking, if you, under this administration, we don't know what they're going to do with the OPT and what they're going to do with regard to the student visas, because in the normal course, you can't work if you're on a student visa. You have to go to school. In certain circumstances, a spouse may be able to, if things go very bad and in hardship circumstances, there may be ways for a person to get a EAD, but in the normal course, they can't do much in that regard. They have to be compliant. I think that is a lesson that going forward is going to be as important as anything. And that is, under this administration, you have to remain compliant to the letter of the law. Because I think that if you do anything that's not going to be completely by the book, you could find yourself in a situation where you will be removed from the United States, or put yourself in a position where you could be removed from the United States. So in any event, if you get an offer of employment, you can't necessarily you can't necessarily start working. You have to wait until you're eligible to work. You wait for that, then you can start to work. And any employer that is interested in hiring you, and frankly speaking, has worked in the system before, will understand that. Remain compliant. More than anything else, remain compliant.
Thank you, David. I think that is a great advice. And folks out there, you definitely need to stay vigilant, compliant, go by the rules, be on the right track, and stay hopeful. I think that is what I can say for now. And yes, absolutely. Go contact Attorney David Garson, and he's definitely going to direct you at least how to go about it if you have any confusions, or especially that every case is different and you might need special attention. So why not email David? His email address is david@garsonil.com. And you can also go visit his website, www.garsonil.com. Thank you, David. And okay, Akshay is back saying, I'm sorry I missed the first 15 minutes of this session, but I wanted to ask about the implications on OPT and STEM OPT going in the future. Do you want to say that?
Sure. As I was saying, we don't know. There's been a lot of discussion regarding it, to be honest with you. In fact, this is probably the area that has been focused on the most by pundits and newspaper reporters and things. So what is this administration going to do with the OPT and STEM OPT? The STEM OPT was established by the Obama administration. I think that the Trump administration, in this first go around, tried to get rid of it, as I recall, or tried to limit it, and they weren't able to do so. That doesn't mean they aren't going to try again. The OPT, I don't see them stopping the OPT. I really don't. I don't know why they would. I think that it's helpful to employers, it's helpful to the individuals, but I don't know that it would be expanded in any way, shape, or form. Unless, and I mentioned this at the beginning, as I said, under the last administration, the person who was responsible for advising the president was a fellow named Stephen Miller, who is pretty restrictive. I don't know that this person is advising the president under this administration. I think Elon Musk is having a lot of say in this. And that being the case, if he listens to that kind of individual, then he may understand the importance of people who are in STEM or technology or even trades, to be honest with you. I mean, let's be honest, a lot of people, they say there's 11 million people who are out of status in the United States. I don't know. I haven't looked at the statistics, but I'm kind of thinking that a lot of them are in construction and in trades in places that need them. So for instance, there was just a hurricane in North Carolina. There's always hurricanes in Florida, things like that. They have to rebuild their infrastructure. And I'm not sure there's enough people who are US citizens or green card holders who can do that. So I think practically, and I think I don't want to say it's a secret, but I think most people believe or think that a lot of the people that are working in trades and construction and I was going to say technology, not so much, but trades and construction are probably people who are out of status. And so if the president or this administration wanted to look at something like that, there may be a possibility of I don't want to say an amnesty because people freak out when I say the word amnesty, but of a possibility of creating a pathway for individuals who work in certain sectors and have worked in those sectors for a while to get permanent residence, especially if they're needed.
There you go. Thank you. Yes.
Somebody made a comment that Elon will be the savior of the STEM people.
He's the same guy. Akshay is the guy only. So he was also saying, also it is true that you can use STEM OPT only once. For example, if I used STEM during my master's, then I cannot use it after my PhD. Please clarify.
Correct. Yes.
That's true. That's true, Akshay. So there you have it. Thank you. Thank you so much, David, for taking that up. Jorge says, just want to thank David for this session. He's very well spoken and knowledgeable. Definitely. Thank you so much, David, for joining us and making time for this.
That's very
now,
nice.
my
Thank
next
you.
question. Yes, thank you. Next question for you, David, is how will the proposed restrictions on OPT affect international students pursuing STEM degrees, and what steps can students take to mitigate these changes? We've been discussing this over and over, and maybe if you have any more points to...
Yeah, no, I think I pretty much said everything I can say. We don't know what they're going to do. Everything may change or nothing may change. You know, I know I sound... That's an easy thing to say. It gets me out of a lot of questions, but I do think based on previous experience, meaning the government's previous governing, or this government's previous governing, that things will get more restrictive. It will be tougher to get cases approved. They don't need to change the law to do that. The L1s, the H1s, they could take away spousal. I'm going away from OPTs, I apologize, but they could take away spousal work permits from the H2s or the L2s. I'm sorry, the H4s and the L2s. They could take away, meaning if right now, if I'm on an H or an L, my spouse can get a work permit. They could take that away. And by taking that away, it lessens the, I guess, desirability of people coming to the United States. Because if their spouse can't work, then what are you doing? That's not very fair. It's fair, but it's their country. But what I'm saying is it's not as attractive to somebody who's coming. So they could do all sorts of things. So in terms of the OPT, I don't know that they'll do anything significant. I think the STEM OPT, that in itself is up for grabs. And to that person's point of view, Elon may be the savior. Who knows?
For sure. Okay, well, what do you want to say about the H1B lottery? Maybe of course, we are going to expect changes, everything immigration related. But do you have anything to say on that H1B
Well,
lottery system?
yeah. I mean, the 65,000. It's always it's a mad rush when cap season comes and employers file the expressions of interest, and wherever it's usually 15, 20, 25% that get picked. I can't see them going a lot higher than that. If they wanted to do things that were, I guess you could say, innovative, and then they could change that cap for the various industries that people go into. So for instance, there's a lot of people in STEM, a lot of US citizens and a lot of green card holders in that sense. So if you have if you have a degree in a STEM field and they need STEM people, then they can absolutely say, you know what, we can raise a cap in this area. We can get more people in this area. Why we need them? Or it could be another field or something of the sort. In the sense of that. So they could be innovative. You never know. Things could go better than it has been before. In that way, they could be somewhat creative and think outside of the box when they're doing these kinds of things, or they may just be completely restrictive. In other words, it may be a very good hedge, and it would be a good legacy for this administration if they changed the immigration policy and made it something that was more utilitarian for everybody, so that it's functional and practical, not necessarily a one-size-fits-all.
True, and maybe everything you say cannot happen. I mean, even Trump cannot say that whatever he has said can happen, right?
Right. No, that's exactly the case. I mean, in the end, it will depend upon who the president surrounds themselves with, right? It goes to the fact that if you are in a field or in an area that the president believes is important to the country, then he could basically do it he could do things that would be a great help to the US. And then, as I said, he's very concerned about his legacy. It could really help his legacy.
Right. Thank you so much, David, for that. And, I had some more questions from people who keep commenting on our groups and YouTube channel. So I think I would like to share that. But hold on, not this one. Okay. So this was a nationwide protest on Canada 2 months back when they were talking about deportation. But if you find it relevant and if you want to take them up, you may want to give out some views or perspective on this. So when you apply as an international student in Canada, you are required to write a letter stating you will return to your country once you complete your studies. That was the agreement they signed.
Yep. Sorry, is there a question or?
It's just a comment. I mean.
Oh, yeah.
Then we have. Let me take this up for now. This is from Dixit, asking urgent. I went for my first H1B visa stamping yesterday and learned that my F1 visa was revoked. I was sent for second interview on same day, but my visa is cancelled. The interviewer told me that I was involved in a fraud with my first OPT employer. My other friends have worked with this employer, but they had no visa issues. Did anyone else? Do you want to say anything on this?
Yeah, I've seen this before. It's a scam. So what it is that people I've had people consult me on this, and that is they get an OPT for an employer that they're not really working for. And so, but the employer says that they're working for them. And so, and they go ahead and they have their OPT, and then they can get the extension on the STEM and things of the sort. But realistically speaking, they're not working for the employer. And either I think in the worst case scenarios, they pay the employer to basically say that. So, that unfortunately is a fraud scheme that I've seen before and keeps turning up. It leads me to believe that the authorities or the State Department or USCIS or CBP have been alerted to it and are now looking for it. So when somebody gets an F1 and they get an OPT and then they say, okay, I'm working for Mary's company, being a systems analyst or a software developer, and they're not really working for a Mary's company, they may be working at the Walmart or something of the sort, but they get that letter, and then when they go to get the H1, if they're picked, or they go to get a STEM extension and it comes out, then that's pretty bad, because then you do get charged with misrepresentation and you lose your ability to stay in the States and or go to the States.
Okay. Thank you so much, David, for taking that up. And now I have my next question, and that is also from this is with regard to the I-20. Got admission offer for spring, haven't filed I-20 yet. Now wanted to change my term to fall. At what point should I request for change of term before getting F1 visa, or after I get F1 visa? Or should I select defer in I-20 form to next term and submit? And get confirmation from university for fall, file the new I-120 then, or submit I-120 for spring now, get visa, and then ask university to change term to fall? Which one of the options will be better?
So I need to see it. Can you make it bigger so I can read it? I can't.
Sure. This is, I think, how it goes.
Okay. So I'm going to do it myself here for a second. Sorry. Got an offer for spring, haven't filed it. Now I want to change my term to fall. At what point should I change? No, don't go to the consulate if you're not going. Should I select defer in I-20 to next term and submit? If conference or submit I-20 for spring. Well, I would advise, this is my opinion. And again, it's not, I can't give you legal advice, but if you got admission to the offer for spring, and when you say file your I-20, or you mean going to the consulate, I'm assuming. Now, if you're changing fall, don't go to the consulate with an I-20 saying you're going to spring term, because that's misrepresentation. You're telling you're going to it and you're not. So in the I-20, when you go to submit, get confirmation of the fall, fill in, I would get a proper I-20 for the session you're going to before you go to the consulate, and then apply to go for that session. I wouldn't go at all. I wouldn't play with going to, especially now. I wouldn't go to the consulate with an I-20 that has a different session than you're actually going to attend.
Okay. Thank you so much, David. I think that will be very much helpful. Thank you for that advice. And now I'll quickly take up my next question. And that is, my wife got admission in MBA in US. Should we apply F2 visa for spouse and kids along with her F1 visa application in one go? Or after she gets F1 and lands in the United States, then we apply for F2 visa?
It's a very good question. I get this a bit in the sense, what strategically is probably the better way to go? Either way, they're going to be looking at it in the sense of temporariness of intent, right? So if you're going to your MBA, and it depends, realistically, this is going to sound, not fair, but it isn't. It depends where you're applying from, and it depends on your monetary situation, and it depends on the circumstances surrounding yourself. Meaning, let's say you you apply from a country that the U.S. has, their statistics show that people don't come back or they stay, and meaning you are not from a family that is wealthy or you have wealth, and in that regard, it's again, it doesn't sound good, and it kind of makes people say, well, why can't I go if somebody else goes? But the truth is, If you're applying for a visa and the consulate is convinced you will return to your home country, or you have the resources to support yourself and go to your home country, they're going to be a lot less restrictive. So to your question, if somebody's applying for an F1 and the F2 and for your spouse and children, you can all go at the same time if you are confident that you are from a certain situation that make this, again, less restrictive. If you go separately, it's no guarantee that your spouse is going to get it if you didn't all go together. I guess my point is that I don't know if it makes too much difference. I think what matters most in that circumstance is whether or not you are of a certain individual or person that the consulate is confident that everybody will come back. So in the end, if you are that, if you are from a certain strata that unfairly is treated a bit differently, then you can all go together. If not, then you can go separately, but it doesn't mean that your spouse and kids are going to get the visa if you go separately. You're still going to be subject to those issues and that kind of scrutiny.
Thank you so much, David, for such a truthful opinion and help. Thank you so much. I wish I knew this participant's name, but it's anonymous post, so thank you so much for taking that up. Now, moving on, this is my next. Hi guys, I need your suggestions. I am admitted to UT Dallas for master's with a scholarship. However, I realized that I could have applied to UT Austin, Rice, UIUC. However, my visa is scheduled later this month. Do you guys recommend me to defer it and apply to these universities? Is it worth it? Or should I just go to UT Dallas?
Yeah,
what do you suggest?
I don't think it much matters, to be honest. I don't know that it matters. Somebody asked a question about, do you expect positively, negatively affecting any policy?
Yes, Hari Guru, let's take that up. Yes.
Okay.
Thank you.
Yeah, I don't know, to be honest with you. I don't see anything. If you are in valid status and you have the 485 is a change of status, by the way, and then you've made application to change status and you're in valid status and you're doing everything right, I don't know that it'll affect it negatively or positively. I don't think it'll affect it at all. I think it's being slow as it is. To your point, you've been there for 3 or 4 years waiting for your priority date. So I guess only negatively if they decide to slow down processing instead, which they have the ability to do. So if that's the case, then sure, that's negative. But in either event, if all things being equal and they're not looking to cause trouble to people in that situation, then I don't think I think it's a neutral answer. The only way it will affect negatively, as I said, if they decide to slow down processing as a means to limit immigration, meaning they don't have to change legislation to change processing and the law and how many people come, because they can make it more difficult within the parameters and the tools that they have already.
Okay. Thank you so much for taking that up, David. And now I have another question. This was on our YouTube channel. This was asked by Vijay Kumar. I am on my F1 visa OPT and recently got approved for H1B I-797B consular services. Since I am in US and working for employer on OPT, can my employer refile for new I-129 as change of status so that I can continue working on H1B and no need to travel for stamping? Thanks.
Yeah, but they could, but I'm curious as why they didn't. To be honest, I mean, I don't know why they wouldn't to begin with. There must have been a reason necessarily. The second is that even if you do get you change your status, you can't travel at all unless you get that visa. So once you get a 797 and you don't have a change of status, then you have to travel to the consulate that you're on, that you need to go to even travel. So it probably wouldn't be a bad idea to do it, to be honest with you. I would go and do it, especially if you get the approval and you were in the States and you went to school in the States. There's no temporary intent for an H1. So that's a good thing. So you don't have to satisfy that. So the only thing they could really refuse you under is if they think that it wasn't a real job offer, or you don't have the qualifications or things like that. But given that you went to school in the States, given that you work for the employer in the States, if it's real, then I wouldn't be afraid of the consulate.
Okay. Thank you so much for taking that up for Vijay Kumar, David. And I think we'll just go on with one last question. And I think that should be, let me just see if this is the one. Or I think we've taken up all of them for now. Yes, but if you want to give a view on this, hello, in my case, I have an F1 status to H4 status. I am in USA, but I just have the status, not a visa stamp. Would this process be the same for me? And once I upload my documents, do I need to keep studying during the processing time?
So if they've already changed their status to H4, they don't study at all because they can't. They're on H4 unless they get approval to do it. But that's what I was just talking about, in the sense that they have a visa, they have status, so they can't go anywhere. And until, you're changing status from F1 to H4, and they're asking, okay, well, can I keep studying? Do you have to keep studying? No. Are they studying? Did they finish? You know what I mean? Every situation is as it is. If they are still in F1 status and they file the change of status to H4, realistically speaking, they should stay in F1 status until they get an approval to H4, right? They shouldn't. So should they? If they're supposed to keep studying, yes, keep studying. If you are done, then you nothing to study. So you are in that status until you change your status, until you get an approval to change your status. By just filing the application to change status does not give you the new status. So you have to wait until the new status is approved before you can do whatever you want to do or not do whatever you want to do. In this case, not study. And in terms of travel, correct. They can't go anywhere. And if they do, they need a new visa.
Thank you so much, David. That was really wonderful, taking up all these questions so patiently and giving us all your point of views and expert advice, I would say. So thank you so much. And maybe we could wrap up if you want to say anything about maybe AI or these latest things that are trending right now, technology-wise or student-wise. And maybe even Akshay's last question. DHS says you can use STEM OPT twice. Please confirm.
Yeah, actually, do you want to contact me on that? Because I want to look at something. So if you want to contact me, I'm happy to answer it. Okay?
Absolutely. And so, yes, David, maybe you would want to say anything with regard to AI.
Well, it's funny. As I said, I'm dual licensed in Canada and the US, and Canada uses AI a lot in adjudication. And frankly speaking, I hate it. It's just because what happens is that if anything is out of the ordinary, it picks it up. Meaning, if you have a difficult case, and then it makes it more difficult, it goes to the officer becomes increasingly suspicious. And when the officer becomes increasingly suspicious, they're harder on the case. And AI as well is refusing a lot. Refusals have gone up, I think, by 12% using AI. So the US isn't quite there yet. It isn't really using AI per se, but it will. And I can only say that when they start using AI, refusals will rise. Because just psychologically speaking, right? If you get a case as an officer and you adjudicate it, fine, that's great. It can be a yes or no. And then when you have AI, if AI says, yeah, you should approve this case, you should approve this case, you should approve this case, you start to rely on it. But then when AI takes a case and says, well, there's something different here, you should look at it, the officer's perspective right away becomes negative, thinking, well, why didn't AI approve it immediately? And so that creates a harsher result, in my opinion, with regard to adjudication.
Thank you so much, David. Really such a great session. I wish we didn't have to wrap it up as quick, but thank you so much. And folks out there, do contact Attorney David Garson, and maybe when you do, let him know that you found him here on Immigration and Jobs Talk Show, and tell him about your case, and maybe for sure he's going to be happy to help you. So his email address is david@garsonil.com, and his Website is www.garsonil.com. So definitely go visit and contact David. Thank you so much, David, for doing this today.
Pleasure. Have a good day.
You too, have a good day. And I hope to see you again very soon.
Thank you. Myself as well.
Thank you. Thank you, David. And folks out there, thank you so much for joining us once again. It's really lovely that you did. And please do not forget to like, share, and definitely subscribe to our channel. It's Immigration and Jobs Talk Show. You can hit that bell icon so that, whenever we have sessions like these, you are notified. And definitely, if you resonated and if you think that your friends and folks out there can also resonate with this kind of content, don't forget to share, please. And also, my number is where you can also contact me on WhatsApp. This is my number, 408-335-6444. You can also email me. My email address is nipa@staffingly.com, and go visit www.staffingly.com to get to know more about us. Thank you so much for joining us. Y'all out there have a great day and a splendid week ahead. See you again. Stay tuned to Immigration and Jobs Talk Show.